Section 18 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Chris Pyle. American State Trials, Volume 1, by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks, Kentucky, 1839, Part 3. March 13th. Mr. Hardin asked the court for instructions to the courtkeeper not to keep such strong fires in the stoves, one at each end of the attorney's bar, Mr. Hardin's seat being between the two stoves. The court remarked that as the gentleman did not like to be placed between two fires, there could be no objection to his ceding to his wishes. Mr. Prentice sat rather to Mr. Hardin's left hand, and Mr. Rowan to his right. Mr. Davis hoped the court would allow the stove to remain lit next to the end of the bar appropriated for the gentleman on the defense. The court said that the gentleman, Mr. Hardin, would not, of course, impose a greater degree of coldness on the opposite gentleman than they could bear. If they felt chilly, they too ought to be indulged. Henry Banks. Heard of the fuss at Redding's shop. Was told by a young man about the 3 Mississippians. Asked Redding if he was hurt. He said not. Asked him who they were. He said they were 3 Mississippians, and that he'd have satisfaction. He said he'd whip all 3 in a room. In about an hour a young man came to me and said there would be the damnedest work at the Galt House in a short time that I ever did see. All I saw in the Galt House was Murdaugh knocked down on the steps and afterward fired at. There were 2 balls discharged by the shot at him. One struck in the casing, and the other in the wall at the left-hand side. Oldham fired the pistol. Dr. Graham. Was in the bar room of the Galt House. Saw the servants peeping into the bar and guessed there was something going on. Saw the judge and Redding moving a little backward and forward, abusing and calling hard names such as coward, liar, villain, and scoundrel, and saying he should like to know in the name of God who made him a judge, and that he must have taken the title on himself, and that he was too big a coward to do anything right. He continued so long that I got tired and turned to speak to someone. Judge Wilkinson paced the room, pulled his cap over his face, and assumed the philosopher, or tried to do it. He walked to the counter, put his cap before his face, one hand in his pocket, and walked along the counter, Redding going to the extreme exasperation all the time. Redding at last pulled his hand out of his pocket and said he'd whip the whole 3 if they'd go into the street. The judge said he did not wish to fight or quarrel with a man of his profession. Judge Wilkinson passed out of the room. Someone observed, "The damned rascal is run." Walked into the passage to go to the bar to inquire the cause of the quarrel. When in the bar, I heard the word lie and damned lie in succession. Saw a small man with a drab coat holding a knife in this position with his back to the writing desk. I recognized him only as a small man with a drab coat. He had a small knife, held that way, and spoke in a threatening manner. He hallooed out, "Stand back and don't crowd on me, or I'll kill the first man that rushes upon me." I thought he looked like a rattling viper that would say, "Don't step on me or I'll bite you." Heard other voices cry out, "Stand back, goddamn you, or I'll kill you." Saw a cane strike at his head. A crowd and general row commenced, and chairs were raised, some rushing in and some rushing out, and such confusion ensued that I saw no more of that part of the affair. Marshal Halbert came to the counter immediately after the affray, before the room was cleared, and asked me to drink. He said, "By God, I hoed a wide row this evening. We took it with a rush. Dr. Wilkinson, the first man that entered, I downed with a chair, and Bill Holmes mounted him and rode him around the room. The doctor's back was to me when I downed him. It was rather bad, but by God I could not help it. Bill then pounded him so that he fell quite limber upon the floor, and I thought he was dead. But the judge came round, and Bill took a chair, when the judge, throwing up his arm, with his bowie knife in his hand, struck Bill, and by God I thought his arm was cut off." Cross-examined. Did not see Halbert performing those great actions he boasted of. I did not see him at all during the action. Think Halbert was bragging of more than he did. S. Prentice. Have been acquainted with Judge Wilkinson intimately in Mississippi for 6 or 7 years. My profession has brought me into intercourse with him as a practicing lawyer. There is no man in the state whose character stands higher than that of Judge Wilkinson, for a modest and retiring disposition. Know this to be his character as a legislator and public man. Know his brother, Dr. Wilkinson. His character is of a very high standing in the state of Mississippi. The first time I saw Mr. Murdaugh was in 1836, introduced to me by Judge Wilkinson as a protege of his. The judge has acted for some time as his friend and guardian, and he accompanied the judge as his friend on the occasion of his marriage. Mr. Murdaugh's general character is very good, and stands high in every respect. I have never heard of his being engaged in any difficulty. Of Judge Wilkinson I can speak with the utmost confidence. As a circuit judge, a distinguished member of the legislature, a commissioner appointed by the state to go to New York on state business, and a public man, I know that no man ever stood higher in the estimation of the South. In his public capacity, he has been particularly noticed for being free from anything like a controversial disposition. His general character is for being more retired and unwilling to meddle in controversy than others. I have been acquainted with him 7 years. Cross-examined. Mr. Murdaugh received license as a practicing lawyer last winter. I know nothing of his early history. Heard Judge Wilkinson make a speech at the election in Mississippi that rendered him unpopular, notwithstanding which he was elected. Mr. Dawson. Formed an acquaintance with Judge Wilkinson a year ago. Live in Vicksburg. Have known him for 7 or 8 years. No man stands higher in his state in the affections and esteem of its inhabitants. Never heard anything improper imputed to him. Mr. Rowan, Jr. Visited these gentlemen in jail shortly after the affair occurred. They were very much bruised, and they had wounds and blood on them. The doctor particularly was very much bruised and cut. Mr. Murdaugh also was very much cut, and there was a good deal of blood about him. Mr. Murdaugh had accompanied Judge Wilkinson from Mississippi. The occasion was the judge's expected marriage. The marriage was to take place about a week after this affair. Mr. Everett. The gentlemen all arrived together at the Galt House about a week before this affair. The marriage was to take place the Tuesday succeeding the affray at Louisville. The preparations for the wedding had been made. Franklin Roberts. Happened to enter a coffee house on Christmas morning and heard gentlemen talking of this affair. Mr. Oldham was one. Heard him say that Holmes came out with a chair, Oldham following the judge, and that he, Oldham, took a pistol out of his pocket and fired at the judge. Someone asked if it was his pistol. He said, "No, it was my pistol and I fired it, and I wonder it did not hit him, for it had 2 balls in it." Thomas A. McGrath. The fight was over before Mr. Holmes' arm was dressed. Do not know Mr. Oliver. Know Mr. Deering. Never heard anything against his character. Mr. Redding. Do not recollect seeing Mr. Johnson at my shop that evening at all. Mr. Craig. Did not see Jackson in Redding's shop that evening. Did not hear Johnson say he would go for Bill Holmes and give the Mississippians hell. William Johnson. Did not see Jackson at Redding's that evening. J.W. Graham. Know Jackson. Was a carpenter, and served 3 years of his time to me. Would say he is a man of middling character. Have no confidence in a man's veracity whose integrity I have no confidence in. I have had some dealings with him, have known Oliver a long time, and have heard his character spoken of. It was not very good, it was very bad, and I know it would not be entitled to any credit in the city of Louisville. Know Mr. Redding. His character for integrity, industry, and veracity stands as high as that of any man in the community. Cross-examined. Mr. Jackson served part of his time to me. He is a hard-working man when he does work. We had differences, but not of late. Have at different times advised him to change his habits, of late particularly. Did not know that he is now a member of the church. Would not call him industrious, though he works hard by spells. 8 or 9 years ago, Mr. Jackson and I had a fight. He has a wife, and I do not know whether he has children or not. Have heard many people speak very hardly of him. Have no unkind feelings toward him myself. He knows that I have, within the last year, advised him to change his habits, and have pointed out how he would prosper if he did so. His habits are that when he has a job he works hard, and then any sport carries him off to the neglect of his business. I doubt his veracity from what I have heard his acquaintances, and men with whom he has been dealing, say of him. Thought the affray at the store a most outrageous affair, but took no part about it. Spoke of it, on several occasions, as an outrageous act that ought to be punished severely. I spoke yesterday of the outrage being dragged off here. I said if the legislature were in hell, and I a fireman, I would give them a good warming, because I felt aggrieved at being brought this distance from home. Did not hear the Galt House fuss till next morning. Mr. Murdaugh. Know Mr. Oliver by sight. Have no personal acquaintance with him. His reputed character in Louisville is not very good. Mr. Taboo. Judge Wilkinson, when he entered the bar room, walked 2, 3, or 4 times across the room. He had his hand behind and stopped in the middle of the room, a little nearer the dining room door, and seemed to face the corner where Redding was standing. He threw his head up and cast his eye at Mr. Redding, and then at the door, as if on the lookout, and greatly excited. About that time Mr. Murdaugh spoke to Mr. Redding, saw Mr. Halbert do nothing but tell Holmes he had beaten the doctor enough. He was wanting to take Holmes off the doctor. Heard Halbert say that when he had knocked down the doctor, Holmes jumped on him. Am satisfied Halbert was only bragging, and that he did not do it. I could not say a crowd followed Redding in. I thought 7 or 8 men did. Henry Oldham. Was going in the bar room when Dr. Wilkinson was rushing out and cut me in the arm, and I knocked him down. Holmes then came to the passage with a raised chair and struck at the judge, breaking the chair against the door. The judge ran to the stairs. Holmes struck Mr. Murdaugh at the stairs with the chair. Mr. Murdaugh got up towards the head of the stairs and hallooed for his pistol. That put me in mind of my pistol, and I took it out and fired it at him. There was no concert for me to go to the Galt House that evening. Knocked the doctor down because he had cut me in the arm. Knew none of the gentlemen. Why he cut me I am unable to tell. Am confident he never saw me before. Cross-examined. Saw Holmes, Rothwell, and Halbert in the bar room. They asked me to take some liquor, which I did. A gentleman asked to see me, and I went away with him. We were talking outside, where I could hear chairs rattling, and then on trying to go into the bar room, I got the cut in the arm. Was in the bar room that evening before any fuss began at all. Was cut with a dirk knife. Had not given the doctor, by word or gesture, any cause for doing it. Went there accidentally. It was on my way home. Fought on my own hook. When he hallooed out for his pistol, I took advantage to get out mine and fired at him. Was stabbed first. Had a bowie knife. Usually carry a bowie knife and pistol about me, since I belonged to the city guard last summer. The button on the scabbard came off, and it slipped through my pantaloons. There could be no blood on it, but it had a red scabbard, which may have been mistaken. Did not wipe blood off with my handkerchief. A gentleman at Zanone's coffee house asked me to show him a bowie knife, and I showed him mine. Did not hear of the affair at Redding's before I went into the bar room. Mr. Pearson. Have known Jackson as a carpenter for many years. He makes boxes and cases for dry goods merchants. Have formed a favorable opinion of him, and I know this is the opinion of several other merchants. What his private associations are, I do not know. Have not ever heard his veracity being called in question. Would credit him upon oath. Have no acquaintance with Oliver, and have not heard his character spoken of. Mr. Miller. Am very little acquainted with Mr. Jackson. Consider him an industrious mechanic. Favorably impressed with his general character. Surprised to hear it doubted. James MacDonald. Have known Mr. Jackson for a few years. He is sober. Never heard his veracity questioned. If he had been a man of loose habits, would have heard it. Know Mr. Oliver. Never heard anything against his veracity. I seldom go to the theater. Do not recollect ever seeing him there as a doorkeeper. Alfred Harris. Mr. Jackson's general character is fair. I have heard him spoken of in this way, that he is fond of conversation, and as a person that says more than he ought. Would credit him on his oath. Know very little about him. End of section 18. Section 19 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Chris Pyle. American State Trials, Volume 1, by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks, Kentucky, 1839. Part 4. The speeches to the jury. The evidence closed at 11:30, and the court adjourned for dinner. It assembled again at 1 o'clock. The courtroom crowded to excess, over 1,000 spectators being present, among them 300 ladies who filled the judge's bench. Footnote, of which the reporter of the day gallantly adds 3/4 were distinguished for great beauty. Mr. Rowan suggested to the court the desire of many citizens that the hearing of the arguments might be adjourned to the adjacent church, to which, if the court approved, the jury no doubt would consent for the accommodation of the public and the ladies in particular. The court conceived that no judicial proceeding would be proper anywhere, under present circumstances, but in the ordinary tribunal of the country. And although the mere delivery of arguments from the counsel was not necessary in the nature of a judicial act, yet some proceeding or recalling of evidence might be requisite, which would embarrass such a departure from the usual course. To accommodate the ladies, the court would order the galleries to be appropriated exclusively to their use. The gallery was accordingly cleared of men, and the ladies provided with seats. Mr. Bullock: Gentlemen of the jury, you have gratified me by the attention you have bestowed upon the examination of evidence in this cause, and I feel assured from that of your honest intention to do your duty in weighing that evidence and deciding upon it as becomes you. Yours is, indeed, no ordinary duty, and I know you are aware of your obligation. I would not have your feelings excited on the one hand or the other of this prosecution, but I would have you impressed with a proper conviction of the facts to enable you to do your duty between the Commonwealth and the accused. I also occupy a public situation here to which the laws have assigned duties of no ordinary trust. I am required not alone to see that the laws be vindicated, but that the innocent should be separated from the guilty and protected from persecution. If guilt exist, it is my duty to present the evidence of it to you together with the law applicable to the case, and if that evidence is so satisfactory as to bring conviction to your minds, you are required to decide according to the law and the facts. You gentlemen have taken an oath that you have no interest, feeling, or prejudice one way or another, and it behooves you, as honest and impartial jurors, to weigh well not only the evidence but the arguments for the Commonwealth as well as for the accused, and according to your solemn oath, a true verdict give. In the opening of this argument, I shall not enter into the depths of the case. I shall merely lay before you the law in relation to the alleged offense, that you may be enabled to judge of its violation from the evidence of the facts. There are 3 individuals arraigned before you for separate and distinct offenses. Edward C. Wilkinson is now on trial for the murder of John Rothwell, and John Murdaugh and Benjamin R. Wilkinson for aiding, assisting, and abetting. John Murdaugh is upon trial on another indictment for the murder of John Meeks, and the other 2 for aiding, assisting, and abetting. You are to try both cases, for the evidence is applicable to both, and your verdict will apply to both. So far as your verdict and finding reach, it is immaterial whether you find one guilty of the killing and the others as accomplices, or the 3 together guilty, because, if you believe but one did the act, and that the others were accomplices, the guilt is the same in all, and it is immaterial which struck the blow that produced the death. It is also necessary to mention that if you believe 1 or 2 out of the 3 guilty and the other innocent, you have the right to find your verdict against the guilty and to acquit the innocent. It has been proved to you that 2 men were killed in the city of Louisville, that the blows were inflicted on them with deadly weapons, and that they died from the effects of those wounds. The laws of Kentucky afford protection to all her citizens. 2 of these citizens have been slain. And your first inquiry is, who committed the crime against our laws? 3 gentlemen, now before you, are charged with this murder. I need not lose time in endeavoring to prove to you that 1 or more of these gentlemen inflicted the blows which caused these deaths, because, from the evidence you are bound to believe, that the judge or Mr. Murdaugh inflicted them, and that each participated in the act of the other. The question is, have they been guilty of any crime which the laws of the land will reach, and if they have, what that crime is designated? It is in the eye of the law homicide, and homicide is either justifiable or punishable by law. The killing constitutes the homicide, and that has been proved. But it is for you to say whether that killing has been murder, manslaughter, or justifiable homicide. Although these gentlemen are indicted for the major offense, murder, you may, if the evidence justify you, find them guilty of the minor offense, manslaughter. Or, even if the accusable homicide is proven, you may acquit them. But as they are charged with the commission of the crime of murder, it is necessary you should hear the law read as it exists in cases of homicide. In defining the law, I shall endeavor not to set down aught in malice, neither shall I, on the other hand, aught extenuate. Murder is one of the highest crimes known to our laws. It is defined by Sir William Blackstone, when a person of sound memory and discretion unlawfully killeth any reasonable creature in being, and under the king's peace, or in this case, in the peace of the Commonwealth of Kentucky, with malice aforethought, either express or implied. That a killing has been committed, it would now be a waste of your time to prove. You have it already established by the evidence, and it is not denied. The only question you have to decide, in addition to the fact, is whether this killing was or was not the result of malice. Malice aforethought does not mean a spirit of hatred or malevolence to the deceased in particular, such as arises from former grudge or previous quarrels, and which is evidenced by lying in wait, etc. This is express malice, but it is not the only kind of malice. For the law meaneth by the term malice, that the fact hath been attended with such circumstances as are ordinary symptoms of a wicked, depraved, and malignant spirit, which carry in them plain indications of a heart regardless of social duty, and fatally bent upon mischief. See Foster, page 256, and Blackstone, page 199. The Constitution makes you, gentlemen of the jury, the arbiters of life and death. You are to make a solemn inquiry into the causes which deprive by violence your country of the life and services of one or more of its citizens. In all cases of death by violence, the law implies that it is done by malice until the contrary is proved. Such is the shield thrown by the law around human life, that it raises a presumption of malice in the consummation of violence. The law does not require in proof of malice that there should have been a previous grudge, for it may arise at the moment of inflicting the deadly violence, or be inflicted upon persons previous to the act unknown to the slayer. On this occasion it is not necessary to prove that Judge Wilkinson or Mr. Murdaugh had ever known their unfortunate victims. If their act springs from hearts regardless of social duty and fatally bent upon mischief, and this is manifested in different ways, from the manner of the assault, the weapon used, and the probability that death would result from the blow. For in all cases of homicide upon provocation, if it may be reasonably collected from the weapon used, or from any other circumstances that the party intended to kill, or to do some great bodily harm, such homicide is murder. And right it should be, for he who carries a weapon calculated to take life shows he broods over blood, and that he thinks with levity of taking the life of a fellow being. Nature itself revolts at the idea of death, and a thrill of horror runs through every nerve at the thought of embruing our hand in the life's blood of a fellow being. And he, therefore, who with the impending glittering blade over an unarmed man can strike with a deliberate intent to kill, is a monster, dead to the social ties, dead to the sympathies of our natures, and no longer worthy of human regard, or to the protection of human laws. Gentlemen, it is not essential that there should have been any previous grudge or quarrel, or even a previous acquaintance. But if you believe the killing was done with a heart fatally bent upon mischief, and fraught with malice, and you must judge of this from the manner of the blow, the nature of the weapon, and all the other circumstances of the case, then it is murder, and you must so find. Let your feelings be how they may, yea, even though you write your verdict in tears. If you believe these gentlemen have been guilty of this crime, you are to consider whether any extenuating circumstances are in proof, and in mercy you are bound to regard those extenuating circumstances. But if you believe those circumstances are not of that weight which the law says is necessary to justify the taking of human life, you are not to be swayed from your duty by your feelings. The counsel on the opposite side will endeavor to show you that there was a mob, or a concert of a mob, got up by Redding and his friends to assault these gentlemen at the Galt House. You will have the opinions of counsel on this point. But you must keep in mind that opinions are not evidence. Ascertain the facts from the proof, and consult your own consciences to make up your judgment. Recollect that you are here to try the law and the facts, and that you are not to mingle up with them that which is not legitimate testimony. I can compare the defense in this case to nothing but a boiling cauldron, into which a vast quantity of angry feelings and fermenting passions have been thrown, and it must be your business, gentlemen, to filter the truth from the dregs and scum with which it is intermixed. You are to ascertain whether, when the affray commenced and the fatal blows were given, there was any danger to these gentlemen of their own lives. That there was not seems to me clearly established. The witnesses tell you, one and all, that there were strange faces in the bar-room of the Galt House. Well, what of that? Is it an uncommon circumstance that there should be strange faces in the bar-room of a public hotel, the most extensive and most frequented in the western country? Almost on all occasions, at every moment of the day, there are strange faces to be met with there. That bar-room is the resort of every stranger attracted by the celebrity of the house, and having business to transact in Louisville or its vicinity. If anything can be based upon this circumstance, I should be glad to know what supposition the gentleman for the defense can raise upon it. When Redding was in that bar-room, getting the names of these Mississippi gentlemen, What demonstration was there of a contemplated assault by others? None. There is nothing in the whole case to warrant the assertion, except the mere conjecture of some few individuals. Not a man produced here to testify the facts, not a man who heard and saw the whole transaction, has sworn that Rothwell, Holmes, or Halbert then said a word to Judge Wilkinson. How then could he infer they were to be engaged in any concert? When Judge Wilkinson went off after what passed between Redding and him, was he not suffered to go his way in peace? What reason could he have to consider there was an individual except Redding who could have a particle of ill will against him? Well, he left the bar-room, was met at the door into the passage by Mr. Everett, and retired to his own room. In doing so, he passed unmolested, unobstructed, and on reaching his apartment had time to detail to his companions, Mr. Murdaugh and Dr. Wilkinson, all that had occurred between him and Redding in the bar-room. Without waiting for their comments or reply, he demands pistols from Mr. Everett. What did he want with pistols, if not for attack? If he wanted them for defense, why did he not wait for them? No, gentlemen, Judge Wilkinson and his companions did not need pistols for their defense, or they would not have come down armed with their knives alone. They could not restrain themselves, so eager were they for the attack. They came down, and of what passed you are to be the judges. I have satisfied you that there had been no concert, no scheme to assault these gentlemen. There is no proof of it, and it can only be inferred from conjecture. But are you to conjecture? You are forbidden by the law. When Judge Wilkinson returned to the bar-room, he had no right to suppose that he would be even addressed, much less assaulted, by any other person than Redding. In the absence of all proof that there was anyone desiring to attack him, who is there that even says he, Judge Wilkinson, was told that Redding's friends had any design of that kind? Did any witness for the defense, prodigal of long stories of his thinking, tell him there was such a design? Not one. There is nothing in the whole case to justify this supposition. That some may have been there from curiosity is possible, but certainly none from design to assault. Well, after coming down, Judge Wilkinson entered the bar-room accompanied by Mr. Murdaugh and Dr. Wilkinson. The judge, after pacing the room, stood firmly and fixed his eye on Redding, while Murdaugh approached. The latter, and, according to some of the witnesses, addressed him insultingly, at the moment throwing his knife open in a menacing manner. What immediately followed is known to you from the evidence. All have seen the subsequent transactions differently, yet they occurred in one way only. It is necessary to remark these conflicting accounts in order to arrive at the facts, and it will also be necessary for you to select from the mass of evidence the testimony of such men as you think have given their evidence without intent to pervert the truth. Those who witnessed the transaction with the greatest quantity of self-possession and the clearest observation. Not such men as those who started and got away to the outside of the windows, though they may be honest, yet evidently having acted under alarm and trepidation sufficient to render them incapable of seeing calmly and dispassionately what occurred. It is natural to conclude that the excitement and alarm caused the different views taken of the transaction by different individuals. Some of these individuals, who remained and retained their self-command, I know to be men who could look on and take in what occurred without much danger of misconception. I know Trabue and Montgomery to be such men, and I feel satisfied that Mr. Robert Pope, though not as well known to me, is of this number, if I may form an opinion from his manner of giving his testimony. I admit that most men are incapable of viewing coolly and deliberately the shedding of human blood, but that some men are more self-possessed under such circumstances than others will not be denied. It is surely more consonant to human sense to predicate our conviction upon the testimony of those who evince the most coolness and self-possession when their veracity is questioned. An additional reason why I attach great weight to Mr. Trabue's testimony is that he expected the affray and was prepared to watch narrowly what was about to take place. He tells you that he had his eye fixed on Judge Wilkinson and Mr. Redding. At the moment his ear caught the words passed from a third person. He was watching these two that he might observe which would commence the expected conflict. Mr. Trabue's is the most consistent and rational account of what then occurred, and I adopt his view of it in preference to others because I want a clear view only of the facts. Gentlemen, I seek not these men's conviction if they are innocent. It would be at variance with the trust reposed in me as the organ of government placed between the Commonwealth and the accused. But if your verdict must be against them, though you write it in tears, justice demands that it should be rendered faithfully. What are the rational conclusions you ought to come to? I will tell you my conviction on that point, grounded on the evidence, Trabue and Montgomery, and corroborated by others. When Judge Wilkinson had arrived in his bedroom, had told his brother, Mr. Murdaugh, what had occurred between himself and Redding, and Mr. Everett had left them, these gentlemen deliberately agreed to come down and see the contest out. They were Mississippians. They had shown their knives, at least 2 of them, and a third, a large bowie knife, had been added, and they descended for the work of death. They knew of no hostile foes below but Redding, for they could not know of any other. There was no reason to believe that they could meet with any others in the barroom, over whom they could crow and triumph but Redding. And they did crow and triumph over him, for it is in proof that he truckled under. When Murdaugh said, "I understand, sir, you say, or it is reported that I assaulted you in your own house with a bowie knife. If you say so, you are a damned liar." Redding did not stand up to this like a man. He backed out by saying, "I do not say it was you, but one of the 3 did it." Is it like what a man backed by a mob would say? Is this like what a man surrounded by a company of friends would say? Gentlemen, it is impossible to believe it. It is immaterial what part Redding took in the affray. The question is, what excuse these gentlemen had for taking the life of a fellow creature. It is my duty to show you what the law says in reference to killing and excuses for killing. I shall come to that presently. Murdaugh had his knife in his hand before any attempt at assault had been made on him. When Meeks approached him, what would any man expect but a blow? What kind of blow did Murdaugh receive from Meeks? Why, nothing but a blow of a short cowhide over the head, and unfortunately for Murdaugh, the law will not excuse him for resenting a blow that could not have threatened his life, by taking a life for that blow. I promise to show you what the law says on this point. He that would excuse himself upon the foot of self-defense must show that before a mortal stroke was given, he had declined farther combat, and had retreated as far as he could with safety, and also that he killed his adversary through mere necessity and to avoid immediate death or great bodily harm. Foster, page 277. This is the law, and it is not now necessary for me to go farther than to show you it is founded upon natural and immutable principles of justice. A, being assaulted by B, returneth the blow, and a fight ensueth. A, before a mortal wound given, declineth any farther combat, and retreateth as far as he can with safety, and then in his own defense killeth B. This is excusable self-defense, though A had given several blows, not mortal, before his retreat. But if the mortal stroke had been first given, it would have been manslaughter. Foster, page 277. He must show that at the moment of the mortal blow, he gave it from necessity to avoid his own death or great bodily harm. Here is another case. The prisoner was indicted for the murder of his brother, and the case upon evidence appeared to be that the prisoner on the night the fact was committed came home drunk. His father ordered him to go to bed, which he refused to do, whereupon a scuffle ensued between the father and son. The deceased, who was then in bed, hearing the disturbance, got up and fell upon the prisoner, threw him down and beat him upon the ground, and there kept him down, so that he would not escape nor avoid the blows. And as they were so striving, the prisoner gave the deceased a wound with a penknife, of which he died. This, upon a special verdict, was at a conference of all the judges of England, ruled manslaughter, for there did not appear to be any inevitable necessity so as to excuse the killing in this manner. Foster, page 278. In all cases where a blow is given to produce death, unless to avoid death or great bodily harm, it is either murder or manslaughter. Now, unless there was absolute necessity that Murdaugh, to avoid death or great bodily harm from the blow inflicted by Meeks, gave that deadly blow which killed Meeks, after he had changed the knife from his right to his left hand, unless you believe that he could not himself escape death but by killing Meeks, you must believe him guilty of manslaughter, at least according to the law. The law discountenances the idea that because a man is a mechanic, you are not in an unavoidable scuffle to resort to fisticuffs on account of any presumed superiority of station. But when your adversary assaults you in that way, that you may draw a deadly weapon and kill your opponent, because the law cannot excuse such unequal odds. What is there in this case to justify Murdaugh? Montgomery, whose breast was sprinkled with the spouting blood of Meeks, though at several feet distance, tells you there was no blow when Meeks was stabbed. If Murdaugh was struck with a stick or cane afterwards, he is not to say that because of that subsequent blow or blows he is justified in having previously inflicted death. As to what transpired when Rothwell was stabbed, you will recollect that Rothwell had 3 wounds. we are able to account for 2 of them by direct evidence. For the other, we account by circumstantial evidence. 2 witnesses who saw the judge's bowie knife enter him say the first stab was given in the right-hand corner of the barroom, as you face the fireplace. These 2 are Tribou and General Chambers. They say that when Rothwell was in the northwest corner, Judge Wilkinson rushed up and plunged his murderous knife into his back, towards the left side, at a time, too, when Rothwell was not offending him, and could not offend him, because his back was turned. A second time, Judge Wilkinson stabbed Rothwell in nearly the same place, when Rothwell was in another part of the room. So it is at least certain that 2 of the wounds inflicted upon Rothwell were inflicted by Judge Wilkinson. Let them say what they will about Meeks having struck Murdaugh, and that at the time anyone else was offending Judge Wilkinson's brother, I say, and I say it here in the presence of his honor, who will set me right if I am in error, that a man has no right to take a life in defense of his brother because merely he is his brother, though a right might exist if in defense of his child or wife. There is no conclusive testimony that Rothwell was assaulting Dr. Wilkinson when stabbed by Judge Wilkinson. On the contrary, it is proved that Rothwell was endeavoring to rescue Dr. Wilkinson from Holmes. Now, as to the law of self-defense, we find it in page 273, under the head of justifiable self-defense, etc., when a man comes with evident intent to commit felony, which he must be engaged in at the time. The other case is when, in self-defense, an adversary is killed. But there is no law to justify Judge Wilkinson in doing what he did on the plea of saving his brother. In the slaying of Meeks by Murdaugh, I will ask, was there the absolute necessity for the taking of a life because he was struck over the head with a whip, which is recognized by the law? They cannot produce any law of England to show it, and I defy them to show me any statute of Kentucky that warrants it. In order to justify you, gentlemen of the jury, in finding the 3 persons indicted guilty of the offenses charged, though only 1 or 2 committed the act, it must appear that there was an aiding or abetting, a concert of action. What did these 3 gentlemen come down to the barroom for, if not to countenance each other, and aid each other in striking terror into those with whom they meditated a conflict? Why did they arm themselves with their knives and enter together, if they did not mean to stand by each other? It is to show that they were united, unanimous, and mutually willing to aid and abet each other in their design. I did not intend to occupy so much of your time, depending upon a further development of this argument by Mr. Harden, to show how the prosecution will reconcile the events detailed in the evidence. You will hear from the gentlemen opposite their view of the case for the defense. You will weigh the facts with the arguments on both sides, and I trust, I know, you will hold the scales of justice impartially. If, in this instance, there has been a violation of that security for life guaranteed by our Constitution, execute your duties, gentlemen, as law-abiding citizens. That you will do so conscientiously, fearlessly, and becomingly, I have every confidence, and with this conviction I confide the case to your hands. End of section 19.
Section 20 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Justin S. Barrett. American State Trials, Volume 1 by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks, Kentucky, 1839, Part 5. Colonel Robertson. It has fallen to my lot, gentlemen of the jury, to follow the attorney for the Commonwealth, and to open the defense on the part of the accused. In doing this, I take pleasure in according to the gentleman my profound acknowledgments for the just, fair, and liberal ground on which he has placed the law that must control, as well as the prosecution as the defense in this case, while at the same time I have to express my regret that he has permitted himself to draw deductions from the evidence which I think cannot be maintained. I do not know that I shall be able to present this case to you in the aspect which properly belongs to it, nor do I know that my feeble state of health will allow me to proceed far with the argument which I propose to offer. Should I find myself unable to go on with the discussion, I will resume my seat and leave the case in the hands of the distinguished gentlemen who are associated with me in the defense, and who, under any circumstances, would be able to do far more justice to the accused than would fall within the range of my powers. For 3 months past, I have been prevented by a local disease from engaging in argument at the bar, and this is the first occasion during that time in which I have attempted to engage in forensic strife. Gentlemen, I feel very sensibly the weight of responsibility which rests upon me, not because there is anything alarming in the case itself, but because the charge is a solemn one, presented in the most solemn form, and which, if true, might produce the most solemn consequences. The case, too, has been made to wear the most aggravated form, not only by an abuse of public feeling, for a time, about the city of Louisville, but by the indiscretion of the public prints, two of which in the city not only departed from invariable usages upon such occasions, but, unfortunately for the accused, these papers permitted themselves to fall into the grossest errors, operating against the truth of the case and against the accused, and which to this day have not been corrected or in any way atoned for. Other papers at a distance copied from them, and thus there has been a most extensive circulation of facts which never existed, to the great injury of the accused. Under these circumstances, though the public mind has in a great degree corrected itself by the lights which were thrown open before the examining court, yet we deemed it better to bring the cause to the consideration of 12 men, not only equal in all other respects to a jury to be selected in Louisville, but who should be entirely untainted by prejudice, and would be certain to render a verdict according to law and to evidence. Such a jury, gentlemen, we think we have found in the county of Mercer. Such a jury now sits before us, and to you is committed the fate of our clients. Our clients stand before you, gentlemen, charged with no mean ignoble crime. They stand before you in the highest and noblest attitude in which man can exhibit himself before his fellow man. They stand before you upon proof that they invaded not the rights of others, whilst at the same time, understanding their own rights, they defended them against the assaults of their assailants, even unto bloodshed and death, as by law they had a right to do. Intending to place the defense upon grounds of self-defense, and that self-defense being against the attack of a band of conspirators against the honor and perhaps the lives of the accused, I will, for my own convenience, and for the benefit of the counsel who may reply to me, state the authorities on which I shall mainly rely. They are few, but I think they are strong. Quote, if 2 or more come together to do an unlawful act against the king's peace, of which the probable consequence might be bloodshed, as to beat a man, to commit a riot, or to rob a park, and one of them kills a man, it is murder in them all, because of the unlawful act, the militia praecogitala, or evil intended beforehand. Close quote. 4th Blackstone, page 201, Chitty's edition. Quote, but if several attack a person at once with deadly weapons, as may be supposed to have happened in Ford's case, though they wait till he be upon his guard, yet it seems, there being no compact to fight, that he would be justifiable in killing any of the assailants in his own defense, because so unequal an attack resembles more a desire of assassination than of combat. Close quote. East Pleas of the Crown, Volume 1, page 276. Quote, for no man is required by law to remain defenseless and suffer another to beat him as long as he pleases without resistance, although it be evident that the other did not aim at his life, but he may lawfully exert so much force as is necessary to compel him to desist. Close quote. Same book, page 286. But who is to judge of the degree of force necessary to be applied to make a man who attacks desist? I answer, in the very nature of things, he who is attacked must be the judge, and so the law intended, and so it has been ruled, as may be seen from the following authority. Quote, yet still, says East, speaking upon this very point, if the party killing had reasonable grounds for believing that the person slain had a felonious design against him, and under that supposition kill him, though it should afterwards appear that there was no such design, it will only be manslaughter, or even misadventure, according to the degree of caution used, and the probable ground of such belief." Close quote. Same book, page 173. Quote, "For," says the same author, speaking of unlawful combinations, "if the act or design be unlawful or premeditated, and death happen from anything done in the prosecution of it, it is clearly murder in all who took part in the same transaction." Close quote. Same book, page 259. Quote, "He who voluntarily, knowingly, and unlawfully intends hurt to the person of another, as Redding and his party intended to the accused, though he intended not death, yet if death ensue, is guilty of murder or manslaughter according to circumstances. As if A intending to beat B happened to kill him, if done from preconceived malice or in cool blood upon revenge, it will be no alleviation that he did not intend all the mischief that followed." Close quote. Same book, page 266. The learned author, in continuation of his illustrations, by rules laid down, says, quote, "The above rules govern all cases where diverse persons resolve generally to resist all opposers in the commission of any breach of the peace, and to execute it with violence or in such a manner as naturally tends to raise tumults and affrays, as by a violent disseisin with great numbers, or to beat a man, or rob a park, or standing in opposition to the sheriff's posse. For they must at their peril abide the merit of their actions who wilfully engage in such bold disturbances of the public peace. In such cases, the law adopts a presumption of fact that they came with intent to oppose all who should hinder them in their design." Close quote. Same book, page 257. As Judge Wilkinson's case differs somewhat from the others, and as some authorities may be applicable to his case, which may not apply to the others, I will at this time introduce the following general principle, immediately following the last quotation and in the same book. Quote, "And in all such instances, whether the breach of the peace were sudden or premeditated, not only officers, but even private persons may interfere to suppress the riot, giving notice of such their intention, and much more may they defend themselves. And if in so doing they kill any of the rioters, if they could not otherwise accomplish their purpose, it will be justifiable. And the killing any person so interfering by any of the rioters would be murder in all who took part in the fact or abetted thereto." Close quote. Same book, page 257. As Judge Wilkinson's case will turn somewhat upon the right of third persons to interfere and prevent a felony, such, for instance, as the killing of another, I will continue my authority, that I may be saved trouble hereafter. Lord Hale, in speaking upon this right of third persons to interfere, for the purpose of preventing a felony, puts this case, viz., quote, "If A, B, and C be walking in company together, and C assault B, who flies, and is in danger of being killed from C's pursuit, unless present help be afforded, and A thereupon kill C in defense of the life of B, it seems that in this case of such inevitable danger of the life of B, the killing of C by A is in the nature of self-defense. But it must plainly appear by the circumstances of the case as the manner of assault, the weapons with which it was made, etc., that B's life was in imminent danger." Close quote. Lord Hale, page 484. I will continue my authorities. Blackstone, speaking of crimes committed by violence, says, quote, "For the one uniform principle that runs through our own and all other laws seems to be this, that where a crime, in itself capital, is endeavored to be committed by force, it is lawful to repel that force by the death of the party attempting." Close quote. Fourth Blackstone, Chitty's edition, page 134. Quote, "Homicide in self-defense, or se defendendo, upon a sudden affray, is also excusable rather than justifiable by the English law. This species of self-defense must be distinguished from that just now mentioned, as calculated to hinder the perpetration of a capital crime, which is not only a matter of excuse, but of justification. But the self-defense of which we are now speaking is that whereby a man may protect himself from an assault or the like, in the course of a sudden broil or a quarrel, by killing him who assaults him, and this is what the law expresses by the word chance medley, or, as some rather choose to write it, chawd medley, the former of which, in its etymology, signifies a casual affray, the latter an affray in the heat of blood or passion, both of them pretty much the same import. Close quote. Blackstone, page 135, Chitty's edition. Quote, homicide, or the killing of any human creature, is of three kinds: justifiable, excusable, and felonious. The first has no share of guilt at all, the second very little, but the third is the highest crime against the law of nature that man is capable of committing. Close quote. Fourth volume Blackstone, page 178, Chitty's edition. Murder is described or defined by Sir Edward Coke to be, quote, when a person of sound memory and discretion unlawfully killeth any reasonable creature in being, and under the king's peace, with malice aforethought, either express or implied. Close quote. Fourth Blackstone, page 195, Chitty's edition. The statute of Kentucky, which prescribes the punishment of persons convicted of manslaughter, contains this proviso, quote, provided always that nothing in this act contained shall extend to any person who shall kill another in self-defense, nor extend to any other who shall kill another by chance, in keeping or preserving the peace, so as the said manslaughter be not committed willingly and under color of keeping the peace. Close quote. Moorhead and Brown's Digest, page 1294. Gentlemen of the jury, I believe you now have all the authorities to which I shall have occasion to advert in the course of the remarks I shall address to you, and I have given them to you drawn together in one view, under the hope that you will bear them in mind, and know how to apply them to every branch of the case, as such branch may be presented in the argument. Let us now see what is the testimony before you, and by a short process of analysis, you will be enabled to make such an application of the law to the testimony as cannot fail to conduct you to just and rational conclusions. I repeat, gentlemen, that I do not propose to go into any strict and rigid examination of the testimony. The labor will be more than my feeble condition will bear. I shall take little more than a passing view of its general character, for I verily believe that you already understand the whole case, as well as you will be able to, after discussion, at least so far as my argument will go. I do not intend to trouble you with any argument upon the scenes which have been described as having happened at Redding's own house, in the afternoon of the day on which this tragedy was played at the Galt House, because they are separate and distinct matters, occurring at different times, at different places, and with different men. Rothwell and Meeks, for the killing of whom the accused are now arraigned before you, were neither of them at Redding's when the difficulty about the coat took place, and what occurred there cannot have any legal connection with the Galt House. We might, indeed, have prevented the evidence relating to what happened at Redding's from going to your consideration, and with that view might have submitted a successful motion to the court. But we had other objects in view. We wished nothing to be concealed which might affect the characters of our clients, and we wished, moreover, to show the malice which animated and moved the lawless band of conspirators with which the accused afterwards had to contend. So far as it may be necessary to show this violent and malicious feeling on the part of Redding and his company, I may probably have occasion to refer to portions of the testimony showing the things which happened at Redding's house, because the danger which surrounded the accused at the Galt House can only be known by first showing in what state of feeling this lawless band entered the house in which the tragical scenes were afterwards exhibited. Gentlemen of the jury, whether you shall view this case as an individual conflict between the slayers and the slain, whether you view it as an affray of the moment, without previous concert, or whether you view it as a previously and deliberately formed conspiracy, maliciously entered into by Redding and his party, for the unlawful purpose of beating and disgracing the accused, they, the accused, stand equally justified or excused. View it as you may, place it in every varied aspect, and it is still a case of self-defense, strictly so by the most rigid construction of law. This right of self-defense is not a right derived from municipal law. It is not a thing that has been taught us. We have not learned it from books. It is a principle of our nature, born with us, and has grown with us in feeling and in strength. It is the most important right which belongs to man by the law of nature. It is his birthright, of which human power cannot deprive him, and which man, when he entered into the social compact, reserved to himself and to posterity. Municipal law is a consequence, not a cause, of the social compact. Before man entered into a state of society, each one judged of the wrongs which he had supposed he had sustained, and he took redress in that mode and manner which inclination and strength enabled him to do. This state of things could not long endure, for the strong would soon gain possession of all that belonged to the weak, and thus all the principles of right and justice were broken down and destroyed. To remedy this, a plan was conceived by individuals of forming what is called the social compact. This social compact was an agreement amongst all that the general affairs of mankind should be regulated by lawmakers, chosen or appointed in such mode as might be from time to time prescribed by supreme authority. The great object in view, at the time of agreeing to this social compact, was to secure individuals in the exercise of certain great and inalienable rights which belonged to man as his birthright, and of which posterity could not be deprived. Amongst these inalienable rights will be found the right of every person to defend his person, his property, and his habitation. Hence we find that municipal law, in all civilized countries, is constantly throwing new guards around these rights. You will be told, no doubt, by the learned counsel for the prosecution, that when an individual is unlawfully assaulted, he must only apply as much force in resistance as will prevent the contemplated injury. This authority I shall not deny, but insist that, in this resistance, the party assaulted is the only judge of the degree to which it shall be carried. And if he has good reason to believe that nothing but killing his assailant will save him from being wounded, maimed, or killed, then he is authorized to slay his assailant. And in this position, I think I am well sustained by some of the authorities already read to you. You will be told that it was the duty of the accused to retreat to the wall, as the books call it, before a mortal blow could be given. Gentlemen of the jury, all this is true as a general proposition, but it has its limitations and exceptions. If a man is already against a wall, he can retreat no further. This is one exception. If he is in his own house and is assaulted with a felonious design, he need not retreat. This is another exception. And if he is so fiercely attacked that the delay in retreating would place him in imminent danger, then he need not retreat. And this is another exception. Whilst, therefore, the general rule may be very good, it is liable to at least these three exceptions. The counsel reviewed the evidence at length and proceeded. I have known these gentlemen and their fathers before them almost from their infancy. I knew them in our mother's state, Virginia. They grew up into manhood without a blemish upon their characters. They carried with them to their adopted state, Mississippi, the fairest and best reputations, and they have maintained their standing there without a blemish, as you are told by the testimony. A regard for peace, a profound respect for the laws, a determination to conduct themselves towards all as good members of society should do, seem to be traits of character strongly stamped upon their whole course of life as the best members of society could desire. To believe, therefore, with all this evidence of good character and moral integrity before us, that they would wantonly have attacked a set of strangers whom they never had seen before, would be to reverse the qualities of all human nature. And knowing them as well as I do, I would not believe it, though witnesses from heaven should come and testify to the facts. But the facts proven even by mortals do not show them guilty of anything but a determination to defend themselves. Judge Wilkinson had come to Kentucky at the time for the purpose of executing and consummating the most important and holy contract which man can enter into. On the Tuesday of this bloody tragedy, he was to take to his bosom as his wife one of the most lovely girls of Kentucky, and all the considerations which spring from such a prospect naturally prompted him to avoid all personal dangers. His natural disposition and his delicate situation at the time united in keeping him thoughtful of his own safety, and it would be one of the most violent of all presumptions to suppose that at such a time and under such circumstances he would be found violating the law and hazarding his own existence. No, gentlemen, such an opinion cannot for a moment be entertained. Necessity alone prompted him to action, and however tragical may have been the consequences, that necessity is the only thing which he deplores. A necessity forced upon him by a band of violent, athletic, and lawless men who sought him in his own house to degrade and disgrace him by public chastisement. There is no part of the United States where a man would be punished for such conduct, and least of all, it is to be expected at the hands of a Kentucky jury composed of men whose fathers fought themselves into their homes and were distinguished by a spirit of chivalry which enabled them to subdue every foe and surmount every danger. With you, the descendants of such gallant sires, may safely be entrusted this and every other cause which involves the sacred principles of honor. Before I take my seat, I beg leave to say one word to the distinguished gentleman who has been employed to aid in this prosecution. I regret, most sincerely regret, to see the practice of hired counsel in criminal cases gaining ground in this Commonwealth. Under its influence, the heart becomes corroded and steeled against all the sympathies of our nature. The learned gentleman who is aiding in this prosecution is to receive $1,000 for his services, and from the very nature of his bargain, as it has been proven, he must have undertaken to convict, if he can, whether the accused be innocent or guilty. 3 times have we met him, first at the examining court, next at the Circuit Court of Jefferson, and now before this court. Here the generous and gallant Hector takes his last, his final stand, and his fate is victory or death. 3 times has he been pursued around the walls of Troy, and as he cannot now speak for himself, I will speak for him, and will use his own words. Quote, "Too long, O son of Peleus, Troy has viewed her walls thrice circled and her chief pursued. But now some god within me bids me try thine or my fate. I kill thee or I die. Come then, the glorious conflict let us try. Let the steel sparkle and the javelin fly." Close quote. But the gentleman will probably say that the beautiful quotation which I have made from the still more beautiful Iliad is neither an apt nor an appropriate illustration, since in the combat between Hector and Achilles, Hector was vanquished and slain. In answer to which I say that, in those ancient days, the gods were supposed to hold in their hands the fate of men and of nations, and that they invariably decided according to the principles of right and justice. In more modern times, gentlemen of the jury, you have been substituted for the gods. You hold in your hands the fate of my gallant and much injured friends, and, not less just than the gods, you too will decide according to right and justice. Do this, as I know you will, and we shall be content. The distinguished gentleman who aids in this prosecution has furnished us with some proof of the corroding influence upon the human heart caused by a long indulgence in prosecution for alleged crimes. I am sure that nature gave him a kind and generous disposition, and that he is still possessed of these amiable qualities. I do not doubt but he has so long lent his aid in prosecutions of this kind, that he has brought himself, quote, to look on blood and carnage with composure. Close quote. He will doubtless make, as he has heretofore made, a bold and mighty effort to convict the accused, though in my judgment such conviction would be against both the law and the evidence. Neither the shrieks nor the tears of the lovely Andromache, nor the groans and lamentations of the aged Priam can stay him in his fierce pursuit. The wife and the father sink into nothingness when compared with the glittering fee that awaits his efforts. He has bargained for conviction, and he goes for his bond. Give it to him, gentlemen. Tell him to take his pound of flesh. But tell him at the same time that if in cutting it he spills one drop of blood, Shylock himself shall be the only victim of the law. You have now heard this bloody history, gentlemen, in the best form permitted by my feeble health. And whether you take it into consideration upon the exclusive testimony of the Commonwealth, or whether you view the testimony on both sides, your minds must arrive at the same conclusion. In either case, I know that your verdict will be not guilty. Gentlemen of the jury, in conclusion I will say that, if it were necessary, I would invoke the lovely beauty by which we are surrounded to aid me in a cause so just and holy. I would ask them to indicate to you their feelings in favor, as I know they are, of my persecuted and much injured friends. For, after all, we exercise our energies and are stimulated to generous and noble deeds for the sake of woman. And when she commands, we are bound to obey. Take woman from the world, and the dark planet is left without a sun. Gentlemen, I have done. So far as I am concerned, the case is with you, and if law, justice, and evidence can favor us in the cause, we dread not your verdict, for we have all on our side. End of section 20.
Section 21 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 1 by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks. Kentucky, 1839, Part 6. Gentlemen of the jury, in conclusion, I will say that if it were necessary, I would invoke the lovely beauty by which we are surrounded to aid me in a cause so just and holy. I would ask them to indicate to you their feelings in favor, as I know they are, of my persecuted and much injured friends. For after all, we exercise our energies and are stimulated to generous and noble deeds for the sake of woman, and when she commands, we are bound to obey. Take woman from the world, and the dark planet is left without a sun. Gentlemen, I have done. So far as I am concerned, the case is with you, and if law, justice, and evidence can favor us in the cause, we dread not your verdict, for we have all on our side. Honorable S. S. Prentice, I rise to address you with mingled feelings of regret and pleasure. I regret the occasion which has caused me thus accidentally and unexpectedly to appear before you, and has compelled you to abandon, for the time, the peaceful and quiet vocations of private life for the purpose of performing the most important and solemn duty, which in the relations of civilized society devolves upon the citizen. I regret to behold a valued and cherished friend passing through one of the most terrible ordeals ever invented to try human feelings, or test the human character, an ordeal through which I do not doubt he will pass triumphantly and honorably without leaving one blot or stain upon the fair fame that has been so long his rightful portion, but through which he cannot pass unscathed in his sensibilities and feelings. The lightning scar will remain upon his heart, and public justice herself cannot, even though by acclamation through your mouths she proclaims his innocence, ever heal the wounds inflicted by this fierce and unrelenting prosecution, urged on, as it has been, by the demons of revenge and avarice. Most of all do I regret the public excitement which has prevailed in relation to these defendants, the uncharitable prejudgment which has forestalled the action of law, the inhospitable prejudice aroused against them because they are strangers, and the attempt which has been, and is still making, to mingle with the pure stream of justice, the foul, bitter, and turbid torrent of private vengeance. But I am also gratified that the persecution under which my friends have labored is about to cease, that their characters as well as the cause of public justice will soon be vindicated, that the murky cloud which has enveloped them will be dissipated, and the voice of slander and prejudice sink into the silence before the clear, stern, truthful response of this solemn tribunal. The defendants are particularly fortunate in being tried before such a tribunal. The bearing and character of his honor, who presides with so much dignity, give ample assurance that the law will be correctly and impartially laid down, and I trust that I may be permitted to remark that I have never seen a jury in whose hands I would sooner entrust the cause of my clients, while, at the same time, I am satisfied you will do full justice to the Commonwealth. I came before you an utter stranger, and yet I feel not a stranger toward you. I have watched during the course of the examination the various emotions which the evidence was so well calculated to arise in your bosoms, both as men and as Kentuckians, and when I beheld the flush of honorable shame upon your cheeks, the sparkle of indignation in your eye, or the curl of scorn upon your lips, as the foul conspiracy was developed, I felt that years could not make us better acquainted. I saw upon your faces the mystic sign which constitutes the bond of union among honest and honorable men, and I knew that I was about to address those whose feelings would respond to my own. I rejoiced that my clients were, in the fullest sense of the term, to be tried by a jury of their peers. Gentlemen of the jury, this is a case of no ordinary character and possesses no ordinary interest. 3 of the most respectable citizens of the state of Mississippi stand before you indicted for the crime of murder, the highest offense known to the law of the land. The crime is charged to have been committed not in your own county, but in the city of Louisville, and there the indictment was found. The defendants during the past winter applied to the legislature for a change of venue and elected your county as the place at which they would prefer to have the question of their innocence or guilt investigated. This course, at first blush, may be calculated to raise in your minds some unfavorable impressions. You may naturally inquire why it was taken, why they did not await their trial in the county in which the offense was charged to have been committed. In fine, why they came here. I feel it my duty before entering into the merits of this case to answer these questions and to obviate such impressions as I have alluded to, which, without explanation, might very naturally exist. In doing so, it will be necessary to advert briefly to the history of the case. My clients have come before you for justice. They have fled to you even as to the horns of the altar, for protection. It is not unknown to you that upon the occurrence of the events, the character of which you are about to try, great tumult and excitement prevailed in the city of Louisville. Passion and prejudice poured poison into the public ear. Popular feeling was aroused into madness. It was with the utmost difficulty that the strong arm of the constituted authorities wrenched the victims from the hands of an infuriated mob. Even the thick walls of the prison hardly afforded protection to the accused. Crouched and shivering upon the cold floor of their gloomy dungeon, they listened to the footsteps of the gathering crowds, and ever and anon the winter wind that played melancholy music through the rusty gates was drowned by the fierce howling of the human wolves who prowled and bayed around their place of refuge, greedy and thirsting for blood. Every breeze that swept over the city bore away slander and falsehood upon its wings. Even the public press, though I doubt not, unwittingly joined in the work of injustice. The misrepresentations of the prosecutor and his friends became the public history of the transaction, and from one end of the Union to the other, these defendants were held up to public gaze and public execration as foul, unmanly murderers, and that, too, before any judicial investigation, whatever had occurred, or any opportunity been afforded them for saying a single word in their defense. I recollect well when I received the first information of the affair. It was in some respectable newspaper, which professed to give a full account of the transaction, and set forth with horrible minuteness a column of disgusting particulars. Instantly, openly and unhesitatingly, I pronounced the paragraph false, and tramped it under my heels. When rumor seemed to endorse and sustain in the assertions of public prints, I laughed her to scorn. I had known Judge Wilkinson long and well. I knew him to be incapable of the acts attributed to him, or of the crime with which he was charged. Not an instant did I falter or waver in my belief. I hurled back to the charge as readily as if it had been made against myself. What? A man whom I had known for years as the very soul of honor and integrity, to be guilty, suddenly and without provocation, of a base and cowardly assassination? One whose whole course of life had been governed and shaped by the highest moral principle, whose feelings were familiar to me, whose breast ever had a window in it for my inspection, and yet had never exhibited a cowardly thought or a dishonorable sentiment. That such a one, and at such an era in his life, too, should have leaped at a single bound the wide gulf which separates vice from virtue, and have plunged at once into the depths of crime and infamy. Why, it was too monstrous for credence. It was too gross for credulity itself. Had I believed it, I should have lost all confidence in my kind. I would no longer have trusted myself in society where so slender a barrier divided good from evil. I should have become a man-hater, and Timon-like, gone forth into the desert, that I might rail with freedom against my race. You may judge of my gratification in finding the real state of facts in the case responsive to my own opinion. I am told, gentlemen, that during this popular excitement there were some whose standing in character might have authorized the expectation of a different course of conduct, who seemed to think it not amiss to exert their talents and influence in aggravating instead of assuaging the violent passions of the multitude. I am told that when the examination took place before the magistrates, every bad passion, every ungenerous prejudice was appealed to. The argument was addressed not to the court, but to the populace. It was said that the unfortunate individuals who fell in the affray were mechanics, while the defendants were Mississippians, aristocratic slaveholders, who looked upon a poor man as no better than a Negro. They were called gentlemen in derision and contempt. Every instance of violence which has occurred in Mississippi for years past was brought up and arrayed with malignant pleasure, and these defendants made answerable for all the crimes which, however much to be regretted, are so common in a new and rapidly populating country. It was this course of conduct and this state of feeling which induced the change of venue. I have made these remarks because I feel that a similar spirit still actuates that portion of this prosecution which is conducted not by the state but by private individuals. I am not aware that the Commonwealth of Kentucky is incapable of vindicating her violated laws, or unwilling to prosecute the perpetrators of crime. The district attorney has given ample proof that she is provided with officers fully capable of asserting her rights and protecting her citizens, and with the exception of one or two remarks which fell from him inadvertently, I accord to his observations my most unqualified approbation. He has done equal justice to the state and the defendants. He has acquitted himself ably, honorably, and impartially. But, gentlemen, though the state is satisfied, the prosecutor is not. Your laws have spoken through their constituted agent. Now private vengeance and vindictive malice will claim to be heard. One of the ablest lawyers of your country, or of any country, has been employed to conduct the private part of this prosecution, employed not by the Commonwealth, but by the real murderer, him whose forehead I intend, before I am done, to brand with the mark of Cain, that in after life all may know and all may shun him. The money of the prosecutor has purchased the talent of the advocate, and the contract is that blood shall be exchanged for gold. The learned and distinguished gentleman to whom I allude, and who sits before me, may well excite the apprehension of the most innocent. If rumors speak truth, he has character sufficient, even though without ability, and ability sufficient, even without character, to crush the victims of his purchased wrath. I said that, with the exception of one or two remarks, I was pleased with the manly and honorable course of the Commonwealth's attorney. These remarks seemed to be more in the spirit of his colleague than in accordance with his own feelings. I was sorry to hear him mention so pointedly and dwell so long upon the fact that the defendants were Mississippians, as if that constituted an ingredient in their crime or furnished a proof of their guilt. If to be a Mississippian is an offense in my clients, I cannot defend them. I am myself criminis. We are all guilty. With malice afterthought, we have left our own bright and beautiful homes, and sought that land, the name of which seems to arouse in the minds of the opposing counsel only images of horror. Truly the learned gentlemen are mistaken in us. We are no cannibals nor savages. I would that they would visit us and disabuse their minds of these unkind prejudices. They would find in that far country thousands of their own Kentuckians who have cast their lot by the monarch stream, in the enjoyment of whose rich gifts, though they forgot not, they hardly regret the bright river upon whose banks they strayed in childhood. No state has contributed more of her sons to Mississippi than Kentucky, nor do they suffer by being transplanted to that genial soil. Their native state may well be proud of them as they ever are of her. But I do injustice to you and myself by dwelling upon this matter. Here in the heart of Kentucky, my clients have sought and obtained an unprejudiced, impartial jury. You hold in your hands the balance of justice, and I ask and expect that you will not permit the prosecution to cast extraneous and improper weights into the scale against the lives of the defendants. You constitute the mirror whose office it is to reflect, in your verdict, the law and the evidence which have been submitted to you. Let no foul breath dim its pure surface and cause it render back a broken and distorted image. Through you now flows the stream of public justice. Let it not become turbid by the trampling of unholy feet. Let not the learned counsel who conducts the private part of this prosecution act the necromancer with you as he did with the populace in the city of Louisville, when he raised a tempest which his own wizard hand could not have controlled. Well may he exclaim in reference to that act like the foul spirit in Manfred. I am the rider of the wind, the stir of the storm, the hurricane I left behind is yet with lightning warm. Aye, so it is still with lightning warm, but you, gentlemen, will perform the humane office of a conductor and convey this electric fluid safely to the earth. You will excuse these prefatory observations. They are instigated by no doubt of you, but by a sense of duty to the defendants. I wish to obviate in advance the attempts which I know will be made to excite against them improper and ingenious prejudices. You have seen in the examination of one of the witnesses, Mr. Graham, this very day, a specimen of the kind of feeling which has existed elsewhere, and which I so earnestly deprecate. So enraged was he because the defendants had obtained an impartial jury that he wished the whole legislature in that place not to be mentioned to ears polite, and that he might be the fireman, and all on account of the law changing the venue. Now, though I doubt much whether this worthy gentleman will be gratified in his benevolent wishes in relation to the final destiny of the Senate and House of Representatives of this good Commonwealth, yet I cannot but believe that his desires in regard to himself will be accomplished, and his ambitious aspirations fully realized in the ultimate enjoyment of that singular office which he so warmly covets. Gentlemen of the jury, I ask for these defendants no sympathy, nor do they wish it. I ask for them only justice, such justice alone as you would demand if you occupied their situation and they yours. They scorn to solicit that from your pity which they challenge from your sense of right. I should ill perform toward them the double duty which I have assumed, both of friend and advocate, did I treat their participation in this unfortunate transaction otherwise than candidly and frankly, did I attempt to avoid responsibility by exciting commiseration. I know that sooner than permit deception and concealment in relation to their conduct, they would bare their necks to the loathsome fingers of the hangman, for to them the infamous cord has less of the terror than falsehood and self-degradation. That these defendants took away the lives of the two individuals whose deaths are charged in the indictment, they do not deny, but they assert that they did not so voluntarily or maliciously, that they committed the act from stern and imperative necessity, from the promptings of the common instincts of nature, by virtue of the broad and universal law of self-defense, and they deny that they have violated thereby the ordinances of either God or man. They admit the act and justify it. The ground of their defense is simple, and I will state it so that it cannot be misapprehended. They assert, and I shall attempt from the evidence submitted to convince you, that a conspiracy was formed by Mr. Redding, the prosecutor, and various other persons, among whom were the deceased, to inflict personal violence upon them; that the conspirators, by preconcerted agreement, assembled at the Galt House in the city of Louisville, and attempted to accomplish their object; and that, in the necessary, proper, and legal defense of their lives and persons from such attempt, the defendants caused the deaths of 2 of the conspirators. After discussing this proposition, I shall submit another, which is, that even though a conspiracy on the part of the deceased and their companions to inflict personal violence and bodily injury upon the defendants did not exist, yet the defendants had reasonable ground to suppose the existence of such a conspiracy and to apprehend great bodily harm therefrom, and that upon such reasonable apprehension they were justified in their action, upon the principle of self-defense, equally as if such conspiracy had in point of fact existed. The law applicable to these 2 propositions is simple, being, in fact, nothing more than a transcript from the law of nature. The principles governing and regulating the right of self-defense are substantially the same in the jurisprudence of all countries, at least all civilized ones. These principles have been read to you from the books by my learned and excellent friend, Colonel Robertson, and require no repetition. That a man has a right to defend himself from great bodily harm, and to resist a conspiracy to inflict upon him personal violence, if there is a reasonable danger, even to the death of the assailant, will not, I presume, be disputed. That reasonable, well-grounded apprehension arising from the actions of others of immediate violence and injury is a good and legal excuse for defensive action, proportionate to the apparent impending violence and sufficient to prevent it, I take to be equally indisputable. By these plain rules, and upon these simple principles, let us proceed to test the guilt or innocence of the defendants. First, then, as to the existence of the conspiracy. Before examining the direct evidence to this point, you will naturally inquire, was there any cause for this alleged conspiracy? Motive always precedes action. Was there any motive for it? If we establish the existence of the seed, we shall feel less hesitation in being convinced of the production of the plant. Was there, then, any motive on the part of Mr. Redding and his friends for forming a combination to inflict personal violence upon the defendants? In answering this question, it will be necessary to take notice of the evidence which has been given in relation to events that transpired at the shop of Mr. Redding at a period anterior to the transaction at the Galt House, and which, except for the clue they afford to the motive, and consequently to the subsequent action of the parties, would have no bearing upon the case before you. You will take heed to remember that whatever of impropriety you may consider as attaching to the conduct of Judge Wilkinson and his friends during this part of the affair must not be permitted to weigh in your verdict, inasmuch as that conduct is the subject of another indictment which is still pending in this court. Judge Wilkinson visited Louisville for the purpose of making the preparations necessary for the celebration of his nuptials. The other 2 defendants had also their preparations to make, inasmuch as they were to act as his friends upon this interesting occasion. Dr. Wilkinson, a brother of the judge, had ordered a suit of clothes of Mr. Redding, who follows the very respectable occupation of tailor, occasionally relieved and interspersed by the more agreeable pursuits of a coffee-house keeper. On the day but one preceding that fixed for the marriage ceremonies, the doctor, in company with his brother and friend, Murdaugh, proceeded to the shop of Mr. Redding for the purpose of obtaining the wedding garments. Upon trying on the coat, it was found ill-made and of a most ungraceful fit. It hung loosely about his shoulders, and excited by its awkward construction the criticism and animadversion of his friends. Even the artificer did not presume to defend the work of his hands, but simply contended that he could reorganize the garment and compel it, by his amending skill, into fair and just proportions. From the evidence, I presume no one will doubt that it was a shocking bad coat. Now, though, under ordinary circumstances, the aptitude of a garment is not a matter of very vital importance in the economy of life, and ought not to become the subject of controversy, Yet all will admit that there are occasions upon which a gentleman may pardonably indulge a somewhat fastidious taste in relation to this matter. Dr. Wilkinson will certainly be excused, considering the attitude in which he stood for desiring a well-made and fashionable coat. I confess I am not a very good judge in concerns of this sort. I have had no experience on the subject, and in my investigations in relation to it having been exceedingly limited. Under favor, however, and with due deference to the better judgment of the learned counsel on the other side, I give it as my decided opinion that a gentleman who is about to participate in a marriage ceremony is justified in refusing to wear a coat which, by its loose construction and superabundant material, indicates, as in the case before us, a manifest want of good husbandry. Suffice it to say, Dr. Wilkinson and his friends did object to the garment, and Mr. Redding, after some altercation, consented to retain it. The pantaloons, which constituted a part of the suit, had been sent to the hotel, and the doctor was in the act of paying for them out of a $100 bill, which he had previously deposited with Redding, when the judge remarked that he had better not pay for the pantaloons until he had first tried them on, as they might be found to fit no better than the coat. Mr. Redding, according to his own evidence, responded that they had said too much already about the matter, to which the judge, he says, replied that he did not come there to be insulted, and immediately seized the poker and struck him, upon which the doctor and Mr. Murdaugh also fell on him, with their knives drawn. Redding then seized his shears, but did not succeed in cabbaging therewith any part of the assailants. He was successful, however, in dragging the judge into the street, where after a slight scuffle, which resulted in no personal injury to any of the parties, they were separated. After the separation, Redding offered, if they would lay down their knives, to fight them all. This kind proposition to the defendants declined, but the doctor returned into the shop, obtained his $100 note, and then the defendants retired from the place. Such in substance is Mr. Redding's own account of the transaction at his shop. The witness Weaver also proves the altercation which occurred in relation to the fit of the coat and the scuffle which ensued in consequence. He, however, avers that Redding, in a very insulting manner, told the judge that he was more meddlesome than the other, and that he was too meddlesome, or words to that effect, which insulting language so excited the judge that he seized the poker and commenced the assault. The other witness, Craig, Redding's journeyman, testified in substance the same as Redding as to what passed in the shop, corroborates his account of the altercation about the coat, and says he considered Dr. Wilkinson not as assisting in the affray, but as attempting to separate the parties. Some of the witnesses think that the doctor attempted, in the street, to stab Redding, as he was getting the advantage of his brother. The evidence on this point, as well as in regard to the conduct of Murdaugh, is somewhat contradictory. In the view, however, which I have taken of the case, the discrepancy is of little importance. It is clearly proven, take the evidence in any way, that Mr. Redding used insulting language towards Judge Wilkinson on account of the judge's expression of an opinion in relation to the fit of his brother's coat. What was the exact language used, it is difficult to ascertain. There were 6 persons in the room when the quarrel ensued. On the one side, the prosecutor, Redding, his foreman, Craig, and the boy, Weaver. On the other, the 3 defendants. All the evidence on this point has been derived from the first party, and ought, consequently, to be taken with many grains of allowance. The prosecutor has given you his version of the affair, but his cunning has prevented the defendants from giving you theirs. Dr. Wilkinson, who was discharged by the examining magistrate, has been included in the indictment, one would judge, for the very purpose of precluding his testimony. No one can doubt that the conduct of Judge Wilkinson, however reprehensible, resulted from the abusive language and insulting demeanor of Mr. Redding. The happy facility with which he indulged on a subsequent occasion in the use of opprobrious epithets give good reason to suppose that his remarks on the present were not very guarded. The expression deposed to by Weaver is, I presume, but a sample. "You are too meddlesome," was the observation, accompanied no doubt by the overbearing and bullying manner which illustrated his conduct afterwards, and which smacked more of his spiritual pursuit as the gainmead of a coffee-house than of his gentle calling as a knight of the shears and thimble. He certainly did on this occasion sink the tailor, for tailors are proverbially polite and gentlemanly in their deportment. I do not wish to be considered as justifying Judge Wilkinson or his friend in taking notice of the petulant and insolent conduct of Redding. I think they would have better consulted their character and feelings by treating him with contempt. I will go further and candidly admit that I consider their course reprehensible, that it resulted from passion and sudden excitement and not from deliberative determination. They were themselves convinced of this in a moment and left the ground ashamed, as they still are, of their participation in the matter, Judge Wilkinson rebuking and leading away his young and more ardent friend, Murdaugh, who seemed to indicate some disposition to accept the boastful challenge of Mr. Redding, that he could, if they would lay down their knives, whip them all three. From all the evidence, it is perfectly clear that in the altercation no personal injury resulted to any of the parties. That the defendants retired voluntarily from the quarrel, while Mr. Redding retained the field, and with boastful taunts and insulting outcries invited a renewal of the fight. The Mississippians were manifestly satisfied. Not so Mr. Redding. He was full of wrath and cabbage, boiling over with violence, and breathing defiance and vengeance against the retreating foe. He doubtless retired to his coffee-house and attempted to soothe his wounded feelings with some of the delightful beverages which it was occasionally his profitable province to dispense to others. Here his friends gathered around him. He recounted to them his manifold grievances. He grew warm in the recital. The two white-handled pocket-knives, which had been drawn but not used in the affray, danced before his distempered imagination in the shape of trenchant and death-dealing blades. These little instruments of ordinary and general use became at once bowie-knives in buckram. He believed, no doubt, and made his friends believe, that he was an injured man, and that some satisfaction was due to his insulted honor. I have presented this part of the case to you simply for the purpose of enabling you to judge of the subsequent action of the parties, and to indicate on which side a desire for vengeance and a combination to obtain it were most likely to originate. Upon the conclusion of the first affray, which party would you have suspected of a disproportion to renew it? Where could lie the motive on the part of Judge Wilkinson and his friends for additional violence? But who that is acquainted with these workings of human nature, or the indications of human feeling, will hesitate a moment in believing that revenge lurked in the bosom of Redding, and sought only a safe opportunity for development? His conduct indicated a state of mind precisely fitted for the formation of a conspiracy. Having laid the foundation, I will now proceed to the erection of the superstructure. I will show first by the direct and then by the circumstantial proofs the existence of this foul and cowardly conspiracy. I will, however, here remark that I doubt not the misrepresentations and falsehoods of Mr. Redding in relation to the transaction induced several of the persons implicated to join the combination who, with a correct knowledge of the facts, would never have participated in the affair. First, then, as to the direct and positive evidence, Mr. Jackson says that immediately after the first affray he was passing Mr. Redding's when his attention was attracted by loud talking in the store, which induced him to enter, where he found Redding, Johnson, and Meeks. Johnson was expressing his opinion as to the course which should be pursued towards the Mississippians for their conduct, and said they ought to go to the Galt House and flog them. "Jack," he said to Mr. Redding, "just say the word, and I'll go for Bill Holmes, and we'll give them hell," at the same time boasting, in his own peculiar phraseology, that he was as much manhood as was ever wrapped up in so much hide. Upon some hesitation, being evinced at this proposition, Meeks said, "Let's go anyhow, and we'll have a spree." Mr. Jackson further deposes that some time after he was stopped by Johnson on the street, who told him he was going after Holmes, that Jack Redding was a good man, and that he, Jackson, ought to go with them to the Galt House and see him righted. Jackson declined, alleging as an excuse his religious character and his desire to abstain from fighting, whereupon Johnson exclaimed in his ardent zeal for enlisting recruits that church, hell, or heaven ought to be laid aside to right a friend. Jackson said he understood it distinctly that it was a fight to which he was invited. Mr. Jackson's testimony is entitled to credit. He did not participate in the affair, and he can have no inducement to speak falsely, for all his prejudice must naturally be enlisted on the side of the prosecution. His character is sustained by unexceptionable testimony, and has been impugned by no one except the salamander gentleman, whose ambition seems to be to pursue in the next world that occupation which in this is principally monopolized by the descendants of Ham. The next direct evidence of the conspiracy is from Mr. Deering, whose character and testimony are both unimpeachable. He says he was panning down Market Street on the evening of the affray when he saw, near the market house, Johnson in company with Holmes and others, and that they were discussing the subject of the quarrel between Mississippians and Reading. This proves that Johnson was carrying into effect his proposition at Reading's store to go and get Bill Holmes and give them hell. He had already found Bill Holmes, and we shall presently see made all his arrangements for giving them hell. Mr. Deering says that soon after he met Mr. Johnson again, who inquired for Mr. Turner, the city marshal. Mr. Deering told him he would be too late with his officers, for the Mississippians would be gone, to which Mr. Johnson responded, there were enough gone there, that if they came down, their hides would not hold shucks. What did this mean if it did not indicate that the conspiracy had already been formed and a portion of the conspirators assembled at the Galt House for the purpose of preventing the game from escaping and holding it at bay until the arrival of the rest of the hunters? They had gone, it seems, to insufficient numbers to authorize the classical boast of Mr. Johnson that if they, meaning the Mississippians, came down, their hides wouldn't hold shucks. There is one more witness whose testimony is positive to the point. It is Mr. Harris. He swears clearly and unequivocally that Johnson met him on the evening of the affray, told him that the Mississippians had insulted Mr. Reading, and directly solicited him to go with Reading's friends to the Galt House and see him righted. Mr. Harris says he refused to go, whereupon Johnson exclaimed, "Are you a friend of Reading's?" thereby showing how strong was the feeling when even a more refusal to participate in the violence was considered as proof that the man refusing was no friend of Reading. Such, gentlemen, in the positive proof of the conspiracy, it consists of the evidence of 3 disinterested and honest witnesses, 2 of whom were directly and strongly solicited to participate in the matter. The testimony of each of these witnesses corroborates that of the other 2. The facts sworn to have a natural order and connection. There is a verisimilitude about the whole story which would not belong to either portion by itself. The testimony is entitled to much more weight than if it had been the recital of a single witness. For if you believe one of the witnesses, you must give credit to all. One of them swears that he heard Johnson in Reading's shop propose to Reading and his friends that he should get Bill Holmes and give them hell. The next witness saw Johnson on the street immediately after, in company with Bill Holmes, who seems to have been the Achilles of these myriads, explaining to him how his dear Patroclus, Reading, had been insulted by the hectoring Mississippians and urging him to vengeance. Again, the same witness met Johnson and was informed by him that a portion of his banditti had already taken possession of the passes of the Galt House, and that if the Mississippians appeared, their hides wouldn't hold shucks. The third witness swears to a positive solicitation from Johnson that he should join in the foray, and to the expression of strong indignation by this slayer of cattle upon his refusal to do so. Johnson was the malaise of the party, the messenger of blood and brand, sent forth to summon the clansmen true. Too well did he perform his duty. He collected his friends and conducted them like beasts to the slaughter, while he himself found the manhood which, according to his boast, distended his hide, rapidly descending to his heels. But enough for the present of this vaporing worthy. I shall pay my respects to him hereafter. I will now proceed in pursuance of the plan I had prescribed to show the existence of the conspiracy by circumstantial evidence, which is, if possible, more irrefragable than the direct testimony, but yet more beautifully illustrates and confirms it. I will exhibit to you a chain of facts linked together by a natural and necessary connection, which I defy even the strong arm of the opposing counsel to break. I will weave a cable upon whose unyielding strength the defense may safely rely to ride out the storm of this furious prosecution. Mr. Redding went to the Galt House after the affair at his shop for the purpose, as he avows, of obtaining the names of the Mississippians that he might procure process against them from the civil authorities. On his way, as he confesses, he armed himself with a deadly weapon, which, however, I am bound in justice to say he never had the courage to use. A number of individuals accompanied and followed him, whose manner and strange appearance excited universal attention even in the bar-room of the most frequented hotel in the western country. Their strange faces and strange actions excited general apprehension. Nearly every witness to the unfortunate catastrophe had deposed that he was struck with the strange faces congregated in the bar-room. The learned counsel on the other side has attempted to prove in the examination, and will no doubt insist in the argument, that the room is daily crowded with strangers from every part of the country, that the excellence of the fare and the urbanity of its proprietors invite to the Galt House a large portion of the traveling public, and that consequently it is nowise remarkable that strange faces should be observed in the bar-room. Though I admit the gentleman's premises, I deny his conclusion. That strangers should frequent the Galt House is not wonderful. They do it every day, and for that very reason strange faces, under ordinary circumstances, arouse neither remark nor attention. That the strange faces of Mr. Redding's friends should have excited remark and scrutiny, not only from the inmates of the house, but from strangers themselves, is truly wonderful, and can be accounted for only by admitting that there was something very peculiar in their conduct and appearance. They went there prepared for preconcerted action. Having a common object and a well-arranged plan, a glance or a motion sufficed to convey intelligence from one to the other. Telltale consciousness spoke from each countenance. Their looks, unlike the mysterious brotherhood, gave up to the observer the very secret they wished thereby to conceal. There is a strange and subtle influence, a kind of mental sense by which we acquire intimation of men's intentions, even before they have ripened into word or action. It seems, on such occasions, as if information was conveyed to the mind by a sort of natural magnetism, without the intervention of the senses. Thus, in this case, all the bystanders were impressed at once with the conviction that violence was intended by the strange men who had attracted their attention. These men, it is proven, were the friends and intimate companions of Redding. Most of them, though living in the city of Louisville, were not in the habit of going to the Galt House, and yet, by a singular coincidence, had all assembled there on this occasion. They were remarkably stout men, constituting the very elite of the thews and muscles of Louisville, and many of them noted for their prowess in the vulgar broils of the city. Why had they thus congregated on this occasion? Why their strange and suspicious demeanor? I will show you why. It will not be necessary to await the actual fight to become fully conversant with their purpose. It found vent in various shapes, but chiefly bubbled out in the unguarded remarks and almost involuntary expressions of the more garrulous of the party. End of section 21.
Section 22 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Peter Torella. American State Trials, Volume 1, by John D. Lawson. Section 22. Telltale consciences spoke from each countenance. Their looks, unlike the mysterious brotherhood, gave up to the observer the very secret they wished thereby to conceal. There is a strange and subtle influence, a kind of mental sense by which we acquire intimation of men's intentions, even before they have ripened into word or action. It seems, on such occasions, as if information was conveyed to the mind by a sort of natural magnetism, without the intervention of the senses. Thus, in this case, all the bystanders were impressed at once with the conviction that violence was intended by the strange men who had attracted their attention. These men, it is proven, were the friends and intimate companions of Redding. Most of them, though living in the city of Louisville, were not in the habit of going to the Galt House, and yet, by a singular coincidence, had all assembled there on this occasion. They were remarkably stout men, constituting the very elite of the thews and muscle of Louisville, and many of them noted for their prowess in the vulgar broils of the city. Why had they thus congregated on this occasion? Why their strange and suspicious demeanor? I'll show you why. It would not be necessary to await the actual fight to become further conversant with their purpose. It found vent in various shapes, but chiefly bubbled out in the unguarded remarks and almost involuntary expressions of the more garrulous of the party. I shall be compelled, even at the risk of being tedious, to glance at the evidence of a number of the witnesses in showing you the circumstances of the Galt House, which conclusively indicate the existence of the conspiracy. Mr. Everett, one of the proprietors of the Galt House, says he was admonished by his barkeeper that a difficulty was about to arise, and he had better persuade Judge Wilkinson out of the bar-room. Accordingly, he went in and took the judge away, and gives as a reason that he was alarmed at the strange faces in the bar-room and apprehended difficulty. Alarmed, not because the faces were those of strangers, but because of something in their appearance which indicated concert and threatened violence. Mr. Trabue was waiting in the room for supper, and says he heard someone remark, "If the Mississippians had not gone upstairs, they would have been badly treated," in connection with which remark Redding was pointed out to him. This, it seems, was after the judge had retired at the solicitation of Mr. Everett. Now, who were to have treated the Mississippians badly except Mr. Redding and his friends? Who else had any pretense for so doing? Can you doubt for a moment that the remark had a reference to Mr. Redding's party? It was probably made by one of them, but whether by one of them or a stranger, it equally indicated their violent determinations. Mr. Trabue also proves that after Judge Wilkinson retired, Mr. Redding also retired, and when the judge returned to the barroom, Redding presently entered, followed, to use the language of Mr. Trabue, by a right smart crowd of his friends. Now why did Redding thus go out and return with his gang at his heels? Why were his movements thus regulated by the motions of the judge? Wherefore was it that every one expected a difficulty? Mr. Redding, according to his own story, went to the Galt House simply for the purpose of obtaining the names of the gentlemen who had insulted him. He had accomplished his ostensible object. He had obtained the names, and more than that, had gratified his base appetite by abusing one of the gentlemen in the most indecent and disgusting manner. No rowdy who ever visited his coffee-house could have excelled him in this, to the vulgar mind, sweet mode of vengeance. He had even driven the judge from the room by the overwhelming torrent of his Billingsgate epithets. To use an expression suited to his comprehension and feelings, he remained cock of the walk. Yet he was not satisfied. He retired and watched the return of the judge, and then, emboldened by his previous impunity, followed with his cutthroat band to complete the work of vengeance. But to proceed with the circumstantial evidence. Mr. Montgomery states that he was with Mr. Trabue at the Galt House when Redding came in after the names, and also when he came back just before the conflict. Heard him use very rough language, and also heard Halbert remark that there would be rough work with the Mississippians. Now, this fully corroborates the testimony of Mr. Trabue on the same point, who heard the remark, but did not recollect who made it. This Marshal Halbert is the man who boasted, after the affair was over, that he had knocked down one of the Mississippians with a chair while his back was towards him, and recounted many other feats of daring to the astonishment of the listeners. I should judge him to be the blood of honest Jack Falstaff, whose killing, as everybody knows, was always by word of mouth, and whose deeds of desperate valor were so unfortunate as to find neither historian nor believer except himself. At all events, Halbert, according to his own confession, was one of the conspirators, and I have no doubt performed his part in the affray as well as he knew how, and with much greater humanity than he pretends. In addition to the above remark of Mr. Halbert's, Mr. Montgomery states that he heard several persons say, at a time when the defendants were not in the room, that they would beat the Mississippians well. General Chambers, who lives opposite the Galt House, and is in the daily habit of visiting it, says he went into the bar-room just before the affray, that he observed persons whom he was not in the habit of seeing there, and that from their appearance and demeanor his suspicions were immediately aroused. I attach great weight to the testimony of General Chambers. His character for intelligence and observation needs no comment from me, and the fact that his suspicions were aroused must convince everyone that cause for alarm existed. The next testimony to which I shall refer is that of Mr. Oliver. He says that he was acquainted with Mr. Meeks, and was taking a social glass with him on the evening of the affray, when Meeks started off saying he must go to the Galt House, which was on the opposite side of the street, that he was bound to have a fight that night, and by God he would have one. You will recollect that Meeks was one of the persons who collected around Reading immediately after the affair at the shop, and seconded Johnson's proposition to get Bill Holmes and give them hell, by saying they would go anyhow and have a spree. Can you doubt for a moment that the observation made by this unfortunate man to Mr. Oliver, as just recited, had relation to the previous arrangement with Johnson and the others at Reading's shop? The remark of Meeks seems to me, taken in connection with his previous and subsequent conduct, almost conclusive of itself as to the existence of a conspiracy. I had almost forgotten to observe Mr. Oliver's statement that Meeks, before he started, tied a knot in the small end of a cowhide which he carried, manifestly to prevent it from slipping out of his hand in the conflict which he was so eagerly courted. His knife, by a sort of pious fraud, had been taken from him by Mr. Oliver. Otherwise the result might have been very different. The prudent caution of Mr. Oliver in disarming him of this weapon proves how strong must have been the indications of his violent disposition. Mr. Rowe says he was at the Galt House on the evening of the affray, and saw Reading in conversation with Rothwell and Halbert. He also saw Holmes and Johnson. Something in the demeanor of the party induced him to ask Johnson what was the matter. Johnson replied by relating the affair of the shop, upon which Rowe observed, "If the Mississippians fall into the hands of these men, they will fare rather rough." "Yes," replied the worthy butcher, "they would skin them quicker than I could skin a sheep." Mr. Rowe states that he made the remark to Johnson because of the remarkable size and strength of the men to whom he alluded, the strange manner in which they had assembled, and the fact that he knew them to be friends of Reading, and that Miss Reading had been in a quarrel with the Mississippians. Mr. Miller states that, being a member of the grand jury, and having heard of the affray at Reading's, he went into the tin shop to inquire about the matter, when Mr. Halbert came in and boasted much of what he intended to do. Witness then went to the Galt House for supper when he heard Reading abusing Judge Wilkinson and challenging him for a fight. Witness advised Halbert to take Reading away, observing that he, Witness, was on the grand jury, had the names, and would have all the matter attended to. Someone, he thinks Johnson, then remarked that if he didn't leave the room, he'd see the finest sort of beefsteaks served up. Presently he heard the exclamation near the counter, "There they are, all three of them," and the crowd immediately closed in upon the person so indicated. Mr. Wagry also heard the remark about the steaks, and then heard someone exclaim, "We'll have a hell of a fight here just now." He also heard Mr. Miller advise Halbert to take Reading away. Mr. Brown swears that he heard Mr. Miller tell Mr. Reading he was not taking the proper course, he'd have the matter before the grand jury, whereupon someone said, "Hush you, Billy Miller. If it comes to handcuffs, the boys will settle it." The witness then became so apprehensive of a fight that he left the room. Though Miller is not positive as to the person who made use of the expression, "serving up beefsteaks," yet no one, I take it, will hesitate as to his identity. Who but Johnson could speak in such rich and technical language? Who but Johnson could boast of having as much manhood as was ever wrapped in the same extent of hide, while at the same time he had so arranged it that the hides of the Mississippians would not hold shucks? Who but this unmitigated savage would talk of skinning a gentleman quicker than I could skin a sheep? Why, he rubs his hands, licks his lips, and talks of serving up Christians in the shape of steaks, with as little compunction as you or I would exhibit in eating a radish. The cannibal! He should go at once to New Zealand and open his shambles there. His character would suit that country, and I doubt not he would obtain great custom and find ample demand for his human steaks. Why, gentlemen, I should be afraid to buy meat out of his stall. He talks as if he supplied it by burking. I should expect some day to swallow an unbaptized infant in the disguise of a reeking pig, or to eat a fellow citizen incognito in a steak. Such a fellow should be looked to, but again, what meant the expression deposed to by Rowe? There they are, all three of them now. It was the signal for the conspirators to close in. It clearly proves a preconcerted plan. No names were mentioned, and without a previous understanding, the expression would have been nonsense. Most of the party did not know the Mississippians, hence it was necessary that someone should give intimation when they entered the room. The expression, "There they are," was the signal for the onset. What meant the expression sworn to by Waggery? "We'll have a hell of a fight here just now." What conclusion do you draw from the response made to Miller when he advised Redding to bring the matter before the grand jury? "Hush you, Billy Miller, and if it comes to handcuffs, the boys will settle it." If what comes to handcuffs? And who are the boys? Why, if the quarrel with the Mississippians comes to handcuffs. And as for the boys, there was not a man present who did not know who they were. Redding was one of the boys, and a very bad boy too. Billy Holmes was another. Marshal Halbert was a perfect broth of a boy, and if his own story is entitled to credit, he must have been twins, for he acted the part of at least two in the fight. Bill Johnson was as much of a boy as ever, was wrapped up in the same amount of hide, though his extraordinary modesty has induced him to deny the soft impeachment. The unfortunate Meeks and Rothwell were two of the boys, and last, though not least, comes Harry Oldham, the Jack Horner of the party. He sat in the corner till the fight was nearly over, when he put in his thumb and pulled out not a plum but a pistol, and ever since has been exclaiming, "What a brave boy am I!" Yes, gentlemen of the jury, these were the boys whose strange appearance aroused the suspicions and excited the apprehensions of all. Permit me now to call to your attention the testimony of Mr. Donahue. It is clear and conclusive. He swears that on the evening of the affray, and just before it occurred, being in the barroom of the Galt House, he heard Rothwell ask Redding if they were here. Upon being answered in the negative, he exclaimed, "Come, let us go upstairs and bring them down and give 'em hell." Rothwell was the brother-in-law of Redding, had been informed by Redding of his grievances, and had accompanied him to the Galt House. Whom did he mean when he asked if they were there? The Mississippians, undoubtedly. Whom did he propose to drag from their rooms and chastise? Of course the same persons for whom he had just inquired. Rothwell asked if they were there. When the defendants came in, someone cried out, "There they are, all three of them." These two expressions manifestly emanated from persons who understood each other, and were engaged in pursuit of a common object. If these remarks had not relation to some previously concerted plan of action, they would be unmeaning and foolish. But granting the existence of the conspiracy I have supposed, and every word is pregnant with meaning, full of force, weight, and effect. Mr. Raley deposes to the caution given by Miller to Redding, also to the fact that Redding left the room when Judge Wilkinson had retired, and came back again immediately after the judge had returned. He also saw Oldham after the affair was over, putting a pistol into his pocket, and wiping with his handkerchief the blood from a double-edged dirk. Mr. Pearson says he went to the Galt House just before supper on the evening of the affray. As he stood behind the bar, one Captain Rogers observed that there would be a fight. Presently, witness met Marshal Halbert and told him he ought to stop it, meaning the fight. Halbert said, "No, let it go on." This was before Redding had commenced abusing Judge Wilkinson, and proves that the idea of a fight did not originate from that circumstance. The judge came, and Redding abused him. He went out, and Redding followed. He returned, and presently so did Redding with a crowd at his heels. Seeing the crowd, and apprehending violence, Mr. Pearson was in the act of leading the judge out of the room, when the crowd rushed upon Murdaugh. The affray commenced, and the judge stopped, refusing to leave the room until he saw his friend out of the difficulty. Need I ask you if he was right in so doing? Mr. Banks says he saw Redding just after the first affray, and asked him if he was hurt. He said no, but that he would have satisfaction, and that he could whip them all three. Dr. Graham says that after Judge Wilkinson had left the barroom, first time he heard someone observe, "The damned coward has run." Does not Mr. Oldham's testimony prove the conspiracy? I do not mean directly, but circumstantially. He says he was not present at the fight in the barroom, and knew nothing of the affair, nor of the defendants. He says he was standing in the passage when the door opened, and he received a cut from Dr. Wilkinson, whom he knocked down for his pains. After fighting in the crowd a while, he saw Murdaugh retreating up the stairs and asking for a pistol, whereupon he was reminded of his own pistol, which he immediately drew and discharged at the young gentleman, giving him not the weapon, but its contents, to wit, a bullet split in 3 pieces. This worthy gentleman, who is certainly as mild a mannered man as ever scuttled ship or cut a throat, swears positively that he did not know either of the defendants, that he belonged to neither party in this affray, and that he fought, to use his own descriptive and unrivaled phraseology, entirely upon his own hook. Surely Mr. Henry Oldham must be the knight-errant of the age, the Don Quixote of the West, the paragon of modern chivalry. He fights, not from the base desire of vengeance, nor from sordid love of gold, not even from patriotism or friendship, but from a higher and loftier sentiment, from his pure, ardent, disinterested, unsophisticated love of glorious strife. Like Job's war horse, he smelleth the battle afar off, and at the sound of the trumpet he saith, Ha ha! To him there's something of pride in the perilous hour, whate'er be the shape in which death may lower. For fame is there to tell who bleeds, and honor's eye on daring deeds. You have heard, gentlemen, of the bright, warm isles which gem the oriental seas, and are kissed by the fiery sun of the tropics, where the clove, the cinnamon, and the nutmeg grow, where the torrid atmosphere is oppressed with a delicious but fierce and intoxicating influence. There is the spirit of man partakes of the same spicy qualities which distinguish the productions of the soil. Even as the rinds of their fruit split open with nature's rich excess, so do the human passions burst forth with an overwhelming violence and prodigality unknown till now in our cold, ungentle clime. There, in the islands of Java, Sumatra, the Moluccas, and others of the same latitude, cases similar to that of Mr. Henry Oldham are of frequent occurrence. In those countries it is called running amuck. An individual becomes so full of fight that he can no longer contain it. Accordingly, he arms himself with a species of dagger, very similar to that from which Mr. Oldham wiped the blood with his pocket handkerchief, and rushing into the public streets, wounds and slays indiscriminately among the crowd. It is true that this gallant exploit always results in the death of the person performing it, the people of the country entertaining a foolish notion that it is too dangerous and expensive a mode of cultivating national bravery. But, in the present instance, I trust this rule will be relaxed. Mr. Oldham is the only specimen we possess of this peculiar habit of the Spice Islands, and he should be preserved as a curiosity. But alas, the age of chivalry has gone by, and in the performance of my duty I fear I shall have to exhibit some little defects in the character of Mr. Oldham, calculated in this censorious day to detract from his general merits. It is with great pain I feel constrained to say, for he is a sort of favourite of mine, that telling the truth is not one of his knightly accomplishments, and that his heroic conduct in the affray at the Galt House was nothing more nor less, according to his own story, than a downright cowardly attempt at assassination. First, as to his veracity. He says that he was cut in the passage by Dr. Wilkinson, to whose identity he swears positively. Yet it is proven by 6 unimpeachable witnesses that the doctor was, at that time, hors du combat, beaten to a mummy, almost lifeless and perfectly limber, while his knife had fallen from his relaxed and nerveless grasp upon the floor of the bar-room, where it was afterwards picked up. Yet Oldham swears manfully that it was the doctor who cut him, though, when asked if his face was not bloody, he replied that the passage was too dark to enable him to distinguish faces. If he could not see whether the face of the person who cut him was bruised or bloody, how dare he swear it was Dr. Wilkinson, whom he admits he had never seen before? Yet though his vision was so dull in regard to this matter, it was almost supernaturally keen upon another. He swears that he was cut by a dirk knife with a white handle. Now as this dusky passage, where he could not see his assailant's face, how could he distinguish so accurately the character of the weapon, and more especially of the handle? The handle of such a knife as either of those exhibited would be entirely concealed in the grasp of the holder. But Mr. Oldham could see through the hand, and swear to the color of the handle, even when he could not distinguish the color of the assailant's face. The prosecution seems to be afflicted with a monomania on the subject of white-handled knives. The white handles cause them greater terror and excite more of their observation than the blades. One would be almost led to suppose from the evidence that the defendants held by the blades and fought with the handles. These white handles flash before their eyes like the bright inscription upon the dim steel of a Turkish scimitar. I hope, though with many misgivings, that none of them will ever die of a white handle. But, to return to my subject, why in the name of all that is human or humane did Oldham shoot at Murdaugh, whom he acknowledges he did not know, of whose connection with Dr. Wilkinson he was unacquainted, and who had not attempted to do him the slightest injury? According to his own account of the matter, he acted the part of a base and cowardly assassin. If he tells the truth, he is an assassinating villain. If he does not, he is a perjured villain. I leave him choice of these two horns of the dilemma, though I doubt not the latter is the one upon which he is destined to hang. I cannot believe in the existence of such a monster as he would make himself out to be, and have offered his conduct to you as evidence of the existence of a conspiracy and of his participation in it. It is better that he should have the excuse of having fought in Redding's quarrel than no excuse at all. Gentlemen of the jury, I have now performed that portion of my task which embraced the circumstantial evidence. Out of the mouths of 15 different witnesses, most of them gentlemen of high character and undoubted veracity, I have exhibited to you an almost countless variety of circumstances, the occurrence of which, or any great portion of them, is absolutely incompatible with any other hypothesis than that of the existence of the conspiracy, which I proposed at the outset to prove. Upon that hypothesis, all these circumstances are easily execrable and in perfect accordance with the ordinary principles of human action. I have combined the scattered strands of evidence. I have finished the cable which I promised, and now challenge the opposing counsel to try their strength upon it. They may pick it into oakum, but I defy them to break it. There is one other argument in favor of the view that I have taken of the origin of this unfortunate affray, which may be properly introduced at this time, and with which I shall close this branch of the subject. It arises out of the respective characters and positions in life of the two parties, and is, in my opinion, entitled to great weight. Who, judging of character and situation, was most likely to have sought and provoked the unfortunate conflict, Judge Wilkinson or Mr. Redding? The conduct of the judge, under the opprobrious epithets heaped upon him by Redding in the bar-room, sufficiently indicates that though he had previously given way to sudden passion, he was now cool, collected, and forbearing. His mind had recovered its balance, and he behaved on this occasion, as well as subsequently, with philosophical calmness. I doubt, gentlemen, whether any of you would have permitted Mr. Redding to have indulged with impunity in such unmeasured abuse. But the situation of the judge was peculiar, and every inducement which could operate upon a gentleman warned him against participation in broils and battles. With buoyant feelings and pulse-quickening anticipations, he had come more than 1,000 miles upon a pilgrimage to the shrine of beauty, not of blood, upon an errand of love, not of strife. He came to transplant one of Kentucky's fairest flowers to the warm gardens of the sunny South, there to bloom in beauty and in brightness. The marriage feast was spread, the bridal wreath was woven, and many bounding hearts and sparkling eyes chided the lagging hours. The thoughts of the bridegroom dwelt not upon the ignoble controversy which for an unguarded moment had occupied his attention, but upon the bright and glorious future whose rapturous visions were about to become enchanting realities. Under such circumstances, Judge Wilkinson could not have desired the conflict. Had the fires of hell blazed in his bosom, they must have been quenched for a while. The very fiend of discord would have been ashamed, fresh from a voluntary, vulgar, bloody quarrel, and reeking with its unsightly memorials, to have sought the gay wedding banquet. You cannot believe he coveted or courted the unfortunate affray, without at the same time considering him destitute not only of all sentiment of delicacy and refinement, but every characteristic of a man. Does his previous character warrant such a conclusion? He has, as has been shown to you in evidence, ever entertained the character of an honorable and upright gentleman. I see, by the smear upon the lip of the adverse counsel, that the term grates harshly upon his sensibilities. But I repeat it, Judge Wilkinson has ever entertained the character of a gentleman, a character directly at war with the supposition that his conduct on this occasion resulted otherwise than from necessity. I mean by a gentleman not the broadcloth but the man, one who is above doing a mean, a cowardly, or a dishonest action, whatever may be the temptation, one who forms his own standard of right and will not swerve from it, who regards the opinions of the world much, but his own self-respect more. Such men are confined to no particular class of society, though I fear they do not abound in any. I will save the learned counsel the trouble of translating his sneer into language, by admitting that they are to be found as readily among mechanics as elsewhere. Such a man I believe Judge Wilkinson to be. Such has ever been his character, and is entitled to the benefit of it on this occasion. It ought to have, and I know it will have very great weight with you. Good character always has been, and ever should be, a wall of strength around its possessor, and a sevenfold shield to him who bears it. This is one of the advantages virtue has over vice, honorable over dishonorable conduct, an advantage which it is the very highest interest of society to cherish and enforce. In proportion to the excellence of a man's character is, and ever ought to be, the violence of the presumption that he has been guilty of no crime. I appeal, then, to Judge Wilkinson's character, to prove that he could not have desired this unfortunate controversy, that it is impossible he should have been guilty under the circumstances which then surrounded him, of the crime of wilful and malicious murder. What, on the other hand, was the condition of the conspirators? Redding had been going about from street to street, like Peter the Hermit, preaching up a crusade against the Mississippians. Jonathan, like Tecumseh, but no, I will not assimilate him to that noble warrior, like an Indian runner, was threading each path in the city, inciting his tribe to dig up the tomahawk and drive it not into the scalps, but the stakes of the foe. But I will not pursue this point at greater length. I proposed, after arguing the position that there actually was a conspiracy to chastise the defendants and inflict upon them great bodily harm, to show, in the next place, that the defendants had good reason to believe that such a conspiracy existed, whether in point of fact it did or not. Most of the arguments bearing upon this proposition have been already advanced in support of the other. These I will not repeat. There are one or two others worthy of notice. What could Judge Wilkinson have supposed from the conduct of Redding, but that he sought and provoked a difficulty? What else could he conclude from the unmitigated abuse which was heaped upon him from the very sluices of vulgarity? That the judge gave apprehended violence is evident from the warning which he gave. He told Redding that he might say what he pleased, but not to lay his hands upon him. If he did, he would kill him. He could not be supposed to know that Redding came only for names. When Meeks stepped up to Murdaugh and struck him with his clubbed whip, while the crowd closed in around, what could Murdaugh reasonably expect but violence and bodily harm resulting from preconcerted arrangement? Without going at length into an argument on this point, I take it for granted no one will deny that the defendants had ample grounds for apprehending the existence, on the part of Mr. Redding and his friends, of a conspiracy to commit upon them personal violence. End of section 22.
Section 23 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1, by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks. Kentucky, 1839, Part 8. Let us now look a moment at the conduct of the defendants at the Galt House and see whether it transcended the bounds of right, reason, or prudence. When Murdaugh and the doctor entered the room, the exclamation was made by someone loud enough for all to hear, "There they are, all three of them now." Upon which, according to nearly all the witnesses, Mr. Redding made the remark to Murdaugh, "You are the man that drew the bowie knife on me." You will recollect Redding had just crossed Judge Wilkinson's path and placed himself with his back against the counter, manifestly with the object of bringing on the fight. Murdaugh, indignant at being publicly charged with having drawn a bowie knife upon an unarmed man, replied that anyone who said he had drawn a bowie knife told a damned lie. Whereupon instantly steps up Meeks, with his knotted cowhide, exclaiming, "You are the damned little rascal that did it," at the same time inflicting upon him a very severe blow. By the by, this assertion of Meeks proves that he had been at Redding's after the first affray, and heard a full account of it. It is urged against the judge that when Mr. Everett led him to his room, he asked for pistols. I think an argument may be drawn from this circumstance in his favor. His requisition for arms proves that he considered himself and his friends in great personal danger. He manifestly required them not for offense, but for defense. Had he intended an attack, he would not have gone down to the barroom without first obtaining the weapons he desired. Men do not voluntarily attempt the lives of others without being well prepared. It is evident that Judge Wilkinson and his friends thought only of the protection of their own persons, for they went downstairs provided only with the ordinary weapons which they were accustomed to bear. Murdaugh and the doctor had a pocket knife each, the same they had previously carried. They had added nothing to their armor, either offensive or defensive. The judge, apprehensive of difficulty, had taken his bowie knife, which probably he had not previously worn. When, at the solicitation of Mr. Everett, he retired, he doubtless informed his friends of what had just transpired in the barroom, and expressed his fears of violence. This accounts for the readiness with which Murdaugh met the assault of the two powerful men who simultaneously rushed upon him. The evidence is conclusive that Meeks commenced the attack upon Murdaugh by two rapid, violent blows of a cowhide, accompanied by a heavy blow from a stick or cane from the hands of Rothwell. At the same time, he seized the hand of Murdaugh, in which, prepared for defense, was an open knife. But Murdaugh, with coolness and celerity, changed the weapon to his left hand and used it according to the dictates both of law and common sense. The very first blow had driven him to the wall. The crowd closed around him, he could not retreat, and was justified, according to the strictest and most technical principles of even English jurisprudence, to take the life of the assailant. No man, but a fool or a coward, could have acted otherwise than he did. Was he not, according to the rule read by the district attorney, in imminent danger of his life or of great bodily harm? Let the unhealed wound upon his head respond. Let his hat, which has been exhibited to you, answer the question. Upon this you may perceive two incisions, which must have been caused by a sharp cutting instrument. No obtuse weapon was capable of the effect. The blows were manifestly sufficient to have caused death, but for the intervention of the elastic material upon which their principal force was expended. The part, then, taken by Murdaugh in the affray was clearly defensive and justifiable. It is not pretended that Dr. Wilkinson took any other part in the affray than attempting to escape from its violence, unless you notice the evidence of Oldham that he cut him as he fled from the room. He was beaten, first by Rothwell, then by Holmes, and if you take their own statements, by those two worthies, Halbert and Oldham, he was crushed almost to atoms. He had not a chance even for self-defense. Rothwell had left Murdaugh, after striking him one blow, in charge of Meeks, and fell upon the doctor. While beating the doctor, he was stabbed by the judge, near the dining-room door. The doctor fled round the room, still followed by Rothwell, who was again struck by the judge when upon the opposite side. The two blows paralyzed his powers, when Holmes stepped in and so completely prostrated the doctor that he was compelled to hold him up with one hand while he beat him with the other. Neither offensive word nor action upon this occasion, on the part of Dr. Wilkinson, is proven or pretended. It is perfectly clear that he was beaten by Redding's friends, simply because he was of the Mississippi party. I consider it highly disgraceful to the grand jury who found the bill that he was included in it. In reference to the part taken by Judge Wilkinson, it is proven beyond contradiction, by Mr. Pearson, a gentleman of undoubted veracity, that the judge, at his solicitation, was in the act of leaving the room as the affray commenced, when, witnessing the attack upon Murdaugh, he stopped, refusing to leave until he saw the result of the controversy in which his friend was engaged. Standing in the corner of the room, he did not at first take part in the conflict, perceiving, doubtless, that Murdaugh was making good his own defense. Presently, however, he cast his eyes around and saw his brother trodden underfoot, entirely powerless, and apparently either dead or in immediate danger from the fierce blows of Rothwell, who, as you have heard, was a man of tremendous physical power, and armed with a bludgeon, some say a sword cane. Then it was he thought it necessary to act, and advancing through the crowd to the spot, he wounded the assailant, who was crushing out his brother's life. General Chambers swears positively that Rothwell was beating, with a stick, and with great severity, someone whom the other witnesses identify as the doctor, at the time he was stabbed near the dining-room door. This produced a slight diversion in the doctor's favor, who availed himself of it by retreating in a stooping posture towards the passage door. Rothwell, however, pursued and beat him down, but was arrested in his violence by another blow from Judge Wilkinson, which, together with the puncture in his throat, received in all probability from a chance thrust of the sword cane in the hands of one of his own party, disabled him and caused his death. About this time, Holmes was completing Rothwell's unfinished work, and the doctor, hunted entirely around the room, fell utterly exhausted at the feet of his relentless pursuers. It is wonderful that he had strength enough to escape with Murdaugh and the judge. Such briefly were the parts enacted by these defendants, respectively, in this unfortunate affray, the result of which none regret more than themselves. Considering the proof of the conspiracy and the knowledge, or even the reasonable apprehension on the part of the defendants, of its existence, as affording them ample justification for their participation in the matter, I have not thought it necessary to go into minute analysis of the evidence on this branch of the subject, nor to attempt to reconcile those slight discrepancies which will always occur in the testimony of the most veracious witnesses, in giving an account of a transaction viewed from different positions and at different periods of time. The law of self-defense has always had, and ought to have, a more liberal construction in this country than in England. Men claim more of personal independence here. Of course, they have more to defend. They claim more freedom and license in their actions toward each other. Consequently, there is greater reason for apprehending personal attack from an enemy. In this country, men retain in their own hands a larger portion of their personal rights than in any other, and one will be authorized to presume an intention to exercise and enforce them, upon grounds that, in other countries, would not excite the slightest suspicion. It is the apprehension of impending harm, and not its actual existence, which constitutes the justification for defensive action. If mine enemy point at me an unloaded pistol or a wooden gun, in a manner calculated to excite in my mind apprehensions of immediate great bodily harm, I am justifiable in taking his life, though it turn out afterwards that I was in no actual danger. So, on the other hand, if I take the life of another without being aware of any intended violence on his part, it will constitute no excuse for me to prove that he intended an attack upon me. The apprehension must be reasonable, and its reasonableness may depend upon a variety of circumstances, of time, place, and manner, as well as of character. The same appearance of danger would authorize greater apprehension, and of course readier defensive action, at night than in the daytime. An attack upon one in his own house would indicate greater violence and excuse stronger opposing action than an attack in the street. Indications of violence from an individual of known desperate and dangerous character will justify defensive and preventative action, which would be inexcusable toward a notorious coward. A stranger may reasonably indulge from the appearance or threats of a mob apprehensions that would be unpardonable in a citizen surrounded by his friends and neighbors. Bearing these observations in mind, let us look at the situation of the defendants. They were attacked at their hotel, which, for the time being, was their house. They were strangers, and a fierce mob had gathered around them, indicating, both by word and deed, the most violent intentions. They were 3 small, weak men, without friends, for even the proprietor of the house, who should have protected them, had become alarmed and left them to their fate. Their enemies were comparatively giants, dangerous in appearance and desperate in action. Was there not ample ground for the most fearful apprehensions? But the district attorney says they are not entitled to the benefit of the law of self-defense, because they came down to supper and thus placed themselves, voluntarily, within reach of the danger. According to his view of the case, they should have remained in their chamber, in a state of siege, without the right to sally forth even for provisions, while the enemy, cutting off their supplies, would doubtless soon have starved them into surrender. But it seems there was a private entrance to the supper table, and they should have skulked in through that. No one but a craven coward, unworthy of the privileges of a man, would have followed such a course. The ordinary entrance to supper was through the barroom. They had a right to pass this way. No law forbade it. Every principle of independence and self-respect prompted it. And through that barroom I would have gone, as they did, though the floor had been fresh sown with the fabled dragon's teeth and bristling with its crop of armed men. I care not whether the assailing party had deadly weapons or not, though I will by and by show they had, and used them too. But the true question is whether the defendants had not good reason for believing them armed and every way prepared for a desperate conflict. I have shown already that Dr. Wilkinson and Murdaugh did not transcend the most technical principle laid down by the Commonwealth's attorney, not even that which requires a man to run to the wall before he can be permitted to defend himself, a principle which in practice is exploded in England and never did obtain in this country at all. But, says the learned attorney, Judge Wilkinson interfered and took part before he was himself attacked. He had no right to anticipate the attack upon himself. He had no right to defend his friend. He had no right to protect his brother's life. Now, I differ from the worthy counsel on all these points. I think he had a right to prevent, by anticipating it, violence upon his person. He had a right to defend his friend, and it was his sacred duty to defend his brother's life. Judge Wilkinson was the most obnoxious of the party. His friends were already overpowered. He could not expect to escape, and in a moment the whole force of the bandit gang would have been turned upon him. The principles of self-defense, which pervade all animated nature and act toward life, the same part that is performed by the external mechanism of the eye toward the delicate sense of vision, affording it, on the approach of danger, at the same time warning and protection, do not require that action shall be withheld till it can be of no avail. When the rattlesnake gives warning of his fatal purpose, the wary traveler waits not for the poisonous blow, but plants upon his head his armed heel, and crushes out at once his venom and his strength. When the hunter hears the rustling in the jungle, and beholds the large green eyes of the spotted tiger glaring upon him, he waits not for the deadly spring, but sends at once through the brain of his crouching enemy the swift and leaden death. If war were declared against your country by an insulting foe, would you wait till your sleeping cities were wakened by the terrible music of the bursting bomb? Till your green fields were trampled by the hooves of the invader and made red with the blood of your brethren? No, you would send forth fleets and armies. You would unloose upon the broad ocean your keen falcons, and the thunder of your guns would arouse stern echoes along the hostile coast. Yet this would be but national defense, and authorized by the same great principle of self-protection, which implies no less to individuals than to nations. But Judge Wilkinson had no right to interfere in defense of his brother, so says the Commonwealth's attorney. Go, gentlemen, and ask your mothers and sisters whether that be law. I refer you to no musty tomes, but to the living volumes of nature. What? A man not permitted to defend his brother against conspirators? Against assassins who are crushing out the very life of their bruised and powerless victim? Why, he who would shape his conduct by such a principle does not deserve to have a brother or a friend. To fight for self is but the result of an honest instinct, which we have in common with the brutes. To defend those who are dear to us is the highest exercise of the principle of self-defense. It nourishes all the noblest social qualities and constitutes the germ of patriotism itself. Why is the step of the Kentuckian free as that of the bounding deer, firm, manly, and confident as that of the McGregor, when his foot was on the heather of his native hills, and his eye on the peak of Ben Lomond? It is because he feels independent and proud, independent in the knowledge of his rights, and proud in the generous consciousness of the ability and courage to defend them, not only in his own person, but in the persons of those who are dear to him. It was not the blood that would desert a brother or a friend which swelled the hearts of your fathers in the olden time, when, in defense of those they loved, they sought the red savage through all the fastness of his native forest. It was not such blood that was poured out, free as a gushing torrent, upon the dark banks of the melancholy Raisin, when all Kentucky mourned her warrior sires. They were as bold and true as ever fought beneath the plume. The Roncesvalles Pass, when fell before the opposing lance the harnessed chivalry of Spain, looked not upon a braver or a better band. Kentucky has no law which precludes a man from defending himself, his brother, or his friend. Better for Judge Wilkinson had he never been born, than that he should have failed in his duty on this occasion. Had he acted otherwise than he did, he would have been ruined in his own estimation and blasted in the opinion of the world. And young Murdaugh, too. He has a mother who is looking even now from her window, anxiously watching for her son's return. But better, both for her and him, that he should have been born a bloody corpse to her arms, than that he should have carried to her, unavenged, the degrading marks of the accursed whip. But there was danger, as well as degradation. Their lives were in imminent hazard. Look at the cuts in Murdaugh's hat and upon his head, the stab received by the judge, and the wounds inflicted upon the doctor. Besides the overwhelming superiority in number and strength, the conspirators had very greatly the advantage in weapons. We have proven the exhibition and use, by them, of knives, dirks, a sword cane, and a pistol, without counting the bludgeons, which, in the hands of such men, are weapons little less deadly than the others. Need I dwell longer upon this point? Need I say that the defendants are no murderers, that they acted in self-defense, and took life from necessity, not from malice? But there is a murderer, and, strange to say, his name appears upon the indictment, not as a criminal, but as a prosecutor. His garments are wet with the blood of those upon whose death you hold this solemn inquest. Yonder he sits, allaying for a moment the hunger of that fierce vulture, conscious by casting before it the food of pretended regret, and false but apparent eagerness for justice. He hopes to appease the manes of his slaughtered victims to his falsehood and treachery, by sacrificing upon their graves a hecatomb of innocent men. By base misrepresentations of the conduct of the defendants, he induced his imprudent friends to attempt a vindication of his pretended wrongs by violence and bloodshed. His clansmen gathered at his call and followed him for vengeance, but when the fight began and the keen weapons clashed in the sharp conflict, where was this wordy warrior? Aye, where was Roderick then? No blast upon his bugle horn encouraged his companions as they were laying down their lives in his quarrel. No gleam of his dagger indicated a desire to avenge their fall. With treacherous cowardice he left them to their fate, and all his vaunted courage ended in ignominious flight. Sad and gloomy is the path that lies before him. You will, in a few moments dash, untasted, from his lips the sweet cup of revenge. To quaff those intoxicating contents, he has paid a price that would have purchased the goblet of the Egyptian queen. I behold gathering around him, thick and fast, dark and corroding cares, that face, which looks so ruddy, and even now is flushed with shame and conscious guilt, will from this day grow pale, until the craven blood shall refuse to visit his haggard cheek. In his broken and distorted sleep, his dreams will be more fearful than those of the false perjured Clarence. And around his waking pillow, in the deep hour of night, will flit the ghosts of Rothwell and Meeks, shrieking their curses in his shrinking ear. Upon his head rests not only all the bloodshed in this unfortunate strife, but also the soul-killing crime of perjury. For surely as he lives, did the words of craft and falsehood fall from his lips, ere they were hardly loosened from the holy volume. But I dismiss him, and do consign him to the Furies, trusting in all charity that the terrible punishment he must suffer from the scorpion lash of a guilty conscience will be considered in his last account. Johnson and Oldham, too, are murderers at heart, but I shall make to them no appeal. There is no chord in their bosoms which can render back music to the touch of feeling. They have both perjured themselves. The former cut up the truth as coolly as if he had been carving meat in his own stall. The latter, on the contrary, was no longer the bold and hot-blooded knight, but the shrinking, pale-faced witness. Cowering beneath your stern and indignant gaze, marked you not how his coward lip did from its color fly, and how his quailing eye sought from floor to rafter protection from each honest glance? It seems to me that the finger of Providence is visible in the protection of the defendants. Had this affair occurred at Mr. Redding's coffee house, instead of at the Galt House, nothing could have saved them. Their lives would have been sworn away, without remorse, by Redding and his gang. All that saved them from sacrifice was the accidental presence of gentlemen, whose testimony cannot be doubted, and who have given an honest and true account of the transaction. Gentlemen of the jury, I shall detain you no longer. It was, in fact, a matter of supererogation for me to address you at all, after the lucid and powerful exposition of the case which has been given by my respected friend, Colonel Robertson. It was doubtedly so, when it is considered that I am to be succeeded by a gentleman, Mr. Rowan, who, better perhaps than any other man living can give you, in his profound learning and experience, a just interpretation of the laws of your state, and in his own person a noble illustration of that proud and generous character which is part of the birthright of a Kentuckian. It is true, I had hoped when the evidence was closed that the Commonwealth's attorney might have found it in accordance with his duty and his feelings to have entered at once a nolle prosequi. Could the genius of old Kentucky have spoken, such would have been her mandate. Blushing with shame at the inhospitable conduct of a portion of her sons, she would have hastened to make reparation. Gentlemen, let her sentiments be spoken by you. Let your verdict take character from the noble state which you in part represent. Without leaving your box, announce to the world that here the defense of one's own person is no crime, and the protection of a brother's life is the subject of approbation rather than of punishment. Gentlemen of the jury, I return you my most profound and sincere thanks for the kindness with which you have listened to me, a stranger, pleading the cause of strangers. Your generous and indulgent treatment I shall ever remember with the most grateful emotions. In full confidence that you, by your sense of humanity and justice, will supply the many defects in my feeble advocacy, I now resign into your hands the fate of my clients. As you shall do unto them, so under like circumstances may it be done unto you. End of Section 8. Read by MegannDiGenova.
Section 24 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of John Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks, Kentucky, 1839, Part 9. Mr. Thompson, I know you are already wearied by the lengthened protraction of this cause. I am also aware of the high and great claims and unqualified ability of the gentleman who has preceded me. By retracing, I cannot hope to strengthen the positions assumed by him, and so well has he swept the field, but little remains for a gleaner. The mature experience, the distinguished and well-deserved reputation of the gentleman who will conclude the defense also admonish me of the propriety of taxing your patience as lightly as consistent with a succinct statement of the law and a brief commentary upon the evidence in the cause. When all that has been alleged against the defendants in argument has been so ably answered, I assure you that nothing but a sense of duty and a compliance with the wishes of the accused would induce me to address you. The defendants come before you, gentlemen, not as in ordinary cases. Among the wise provisions and wholesome customs of the common law, it was ordained that the triers should be of the vin or neighborhood. Jurors thus selected were presumed, from their acquaintance with the parties and their knowledge of character, to be better prepared to adjudicate justly upon those arraigned for a violation of the laws where the offense was committed, and there only could the party be tried. His character and reputation might shield him from suspicion and prejudice. The whole tenor of his life, the uniform purity of his conduct, would often of themselves, among his neighbors and acquaintances, refute any imputation of crime. The trial by compurgation is not known to our laws, but the testimony of an upright life and an unblemished character is a more convincing and less suspicious proof of innocence than the compurgational oath of friends, too partial, perhaps, and too confiding. The moral force of that good name and the countenance of those steadfast friends, which would encircle and protect the defendants at home, they have not here. But, gentlemen, they are not only strangers, far from home and friends, they are also arraigned and upon trial before you, not of the vin or county where the offense is alleged to have been committed. By a change of venue, this cause has been translated to another county, because where the offense was committed, the defendants have been driven from the temple of justice by prejudices unwarranted by the facts, fomented by the newspapers, and sedulously circulated and impressed upon the public mind by those who originated, and upon whose skirts rests the blood of the unfortunate catastrophe in the tragic events of which the accused are implicated. The defendants, Dr. Wilkinson, Murdaugh, and Judge Wilkinson, are now put upon their trial upon two distinct and separate indictments. The first charges Judge Wilkinson with the murder of John Rothwell, and charges Dr. Wilkinson and Murdaugh as principals in the first degree, as being present, aiding, abetting, and assisting him in the murder. The second charges Murdaugh with being guilty of the murder of Alexander Meeks, and charges Judge Wilkinson and Dr. Wilkinson as principals in the first degree, present, aiding, assisting, and abetting him in the murder. As you have learned from the testimony, the same, and but the one fatal and unfortunate affair at the Galt House in Louisville, is the foundation of these two distinct and separate indictments. By the examining court, whose duty and province it is, if, upon inquiry, it deems a party brought before it so far culpable as to merit a stricter examination, to send him on to the circuit court for further trial, Dr. Wilkinson was discharged. No beneficial purpose in attaining justice, no requirement of law, demanded this double proceeding by distinct indictments. To the doctor's conduct, the color of crime did not so far affix itself, but that the mayor of Louisville, promptly, against the tide of public sentiment, dismissed him from further prosecution as one in whom he found no fault. So inapprehensible was the doctor, in the opinion and judgment of that officer of the law, a trial before a jury of his country was deemed not proper. I have not been able to perceive, nor do I now perceive, the propriety of including the doctor in these indictments. In the affray at the tailor's shop, which is unconnected in point of fact and in legal contemplation, is separated from and independent of the transaction at the Galt House. The doctor not only committed no violence, but one of the witnesses tells you he attempted to separate the parties. Opportunity, with safety to himself, the provocation of seeing his brother insulted on his account, and then overpowered, would surely have been a sufficiently exciting cause for that wantonness and malevolence of heart with which he is now charged, if in truth, quote, fatally bent on mischief and regardless of social duty, end quote, he thirsted for blood. He then, as afterwards, had with him his pocket-knife. Angry and personal altercation first, and then actual conflict between Redding and his brother was transpiring in his presence on his own account. He spoke not an offensive word, he struck no blow. The harshest interpretation that can be given to his actions is that it is doubtful whether he would have assisted his brother or separated the combatants. In the affray at the Galt House, not a solitary witness proves that he offensively participated in the affair. There is no evidence that he did, or even offered to do violence to his assailants, unless you are disposed to credit the statements of Oldham. What credence should be given to the testimony of that faith-worthy conspirator? What reliance can be placed on the oath of that volunteer in the fight? Your knowledge of human character and the discretion of the gentleman you have already witnessed will enable you readily to determine. To Redding and Company, the doctor gave not the slightest cause of offense. He knew none of them, except Redding, was a stranger passing through Louisville from Mississippi to Bardstown, and was found, much like a, quote, certain man on his way from Jerusalem to Jericho, who fell among thieves and robbers, who stripped him, beat him, and leaving him for dead, departed, end quote. Upon his entrance into the public bar-room at the Galt House, he was suddenly, unarmed, struck down senseless. He had assaulted no man, provoked no one, insulted nobody. He had not even uttered a syllable. The enormity of getting hungry and coming downstairs to supper when supper was ready is the only crime he is proved to have perpetrated. For this offense he was assailed, bruised until he was livid, and not only beaten there until he was senseless, but now here again is he struck dumb by being joined in these indictments. His power of utterance is suppressed, and his tongue torn out by the roots, that he may not divulge the foul deeds of that night. By a ruse de guerre, it may well suit the prosecutor to stifle the utterance and suppress the testimony of all of the adverse party. The accused are not permitted, by any of themselves, to give a narration of the matter. No one acquainted with all of them was present to remember their words, watch their movements, feel their danger, and now detail the circumstances of necessity under which they acted. Redding and his party, the assailants then, the prosecutor and witnesses here, can, without contradiction, save from casual visitors at the house or accidental lookers-on, give what complexion they please to the cause. Why has Dr. Wilkinson, after his discharge, been included in these indictments? Why has his evidence been stifled, his power of utterance in behalf of his brother and Murdaugh choked? It cannot be pretended that he even deserves to be tried. Why then not permit him to be heard as a witness? A vision from one of the adverse party might much elucidate the matter. He has been included in the indictments because those of neither side present were persons from all parts of the Union, itinerant, unknown, their attendance as witnesses doubtful, flurried by the suddenness of the affair, their testimony composed from want of acquaintance with the parties, the ignorance or indifference of lookers-on. All these circumstances forbade a hope that the proper acts and parts could be assigned to the proper individuals. Dr. Wilkinson out of the way, the combined oaths of the conspirators, they hoped, would give color and cast to the case. The forms of law have been perverted to subserve the purposes of this prosecution by implicating the doctor. Explanation from an opponent, or the possibility of contradiction, save from someone accidentally present being cut off, they hoped by concerted swearing to accomplish what they so signally failed to effect by their combined attack. The doctor is now inculpated, not because he is guilty, but because it suits the purpose of the prosecution that he shall not be heard as a witness. I will here, gentlemen, briefly advert to the law of homicide in self-defense and its bearing upon the facts in the cause so far as Murdaugh is concerned. Quote, Section 14. And not only he who on an assault retreats to a wall or some such strait beyond which he can go no further before he kills the other, is judged by the law to act upon unavoidable necessity, but also he who, being assaulted in such a manner and such a place that he cannot go back without manifestly endangering his life, kills the other without retreating. End quote. 1 Hawkins, P.C., page 113. The right of self-defense as settled by the law is first that rule of action that is instinctively implanted in the human breast by the wisdom of Providence for our preservation. It is only so far modified by the benignity of the law and enlightened reason as to require that from, quote, tenderness of shedding a brother's blood, end quote, the assailed party shall so far recede and avoid conflict as his personal safety or the violence of the assault will permit. The rule of the civil law that, quote, quicum aliter tueri se non possunt, damni culpam de deverini inoxi sunt, end quote, is also the English common law, contained in the latter portion of that section of Blackstone's commentaries read to you by the attorney for the Commonwealth. The party assaulted must not factitiously, but really retreat so far as he conveniently can, or, quote, so far as the fierceness of the assault will permit him, for it may be so fierce as not to allow him to yield a step without manifest danger of his life or bodily harm. Then, in his defense, he may kill his assailant instantly, and this is the doctrine of universal justice as well as of municipal law. End quote. 4b-c, page 185. The same doctrine, that where the fierceness of the assault forbids, or no opportunity is afforded to retreat with safety to the assailed party, is the law as laid down by Hale. 1 Hale, P.C., page 482. And in the clear and lucid language of Mr. Justice Parker of Massachusetts, in the case of the Commonwealth against Thomas O. Selfridge, quote, when the attack upon him, the assailed party, is so sudden, fierce, and violent as that a retreat would not diminish but increase his danger, he may instantly kill his adversary without retreating at all. End quote. If Murdaugh was attacked at such time and in such place, and so fiercely that to save his life or protect himself from great bodily harm it was necessary to slay his assailant, the law adjudges him only guilty of homicide, excusable, se defendendo, where the necessity is unavoidable, urgent, imposed upon the party against his will, neither reason nor law require him to do what his safety and personal security forbid he should attempt to do. The law being, as I have laid it down, and as may be read from those works of unquestioned authority, I now ask you to collate and apply the facts touching Murdaugh's conduct to the law so understood. The scope of action and the line of duty, as permitted and demarked by the principles of law to an assailed party, have not been transcended by him by color of and under pretext of the right of self-defense in this instance, as I understand the testimony. Murdaugh had no acquaintance with Meek, did not know him, had never before seen him. Being a lodger at the Galt House, at the usual hour he came down from his room for supper. He came down with his coarse overcoat on, a serious encumbrance to a person about to engage in a combat, a garment of which any one meditating battle would have divested himself. Murdaugh is a small and feeble man. Had he expected danger to himself, or proposed a hostile collision with anyone, he would have been more efficiently armed. A pocket-knife was the only weapon about his person. Had he deliberated an attack, he would certainly have divested himself of his heavy coat and armed himself with pistols or some more effective armor than a common pocket-knife. The proprietor of the Galt House, Mr. Everett, informs you that the time of his coming to the bar-room was in the evening about the time it is usual for the inmates of the house to assemble for supper. You are also told that it is customary that about the time of and just before supper is announced, the boarders, sojourners, and others congregate in the bar-room adjoining the dining-room. When others assembled and were preparing for supper, Murdaugh also, encumbered with an overcoat and almost unarmed, came into the public bar room. The tavern, for the time being, was his house, and he was entitled to all the privileges thereof, so long as he demeaned himself with propriety and paid charges. Which of the party commenced the conversation is settled by Redding himself, who, although he recollects no concert or conspiracy, nevertheless informs you that the altercation in words commenced by his accosting Murdaugh and saying, quote, "You are the man that struck me," end quote, or, quote, "You are the man that drew your bowie knife at my shop," end quote, or words to that effect. To this charge against him, falsely made in allusion to what had transpired at the shop in the evening, Murdaugh emphatically responded that, quote, "The asserter, whoever he was, of such a charge was a damned liar," end quote. To be calumniated to your face and falsely taxed with an offense, if offense there was, provoked just such a response as such a charge deserves from a free, fearless man. The affair at the shop would never in all probability have been revived or even so much as alluded to by the defendants. Time had intervened for the passions to cool and for reason to interpose, but in an irritating manner the former quarrel is called up. When Murdaugh asseverated that he was not the individual who gave the blow or drew the bowie knife at the shop, Meeks, with the murder of whom he is especially charged, seized him, saying, quote, "You are the damned little rascal," end quote. When the conversation commenced, Rayleigh, Trabue, and others tell you, the crowd commenced gathering around them. To many of those in the room they were partially obscured. This gathering around him by total strangers was simultaneous with the revival of the previous quarrel. His position near the counter of the bar-room prevented his receding. As they advanced, Graham and Trabue tell you he warned them off, and that warning, earnest as it was, passed unheeded. Now surrounded, retreat impracticable, a former quarrel revived, his warning unheeded, his knife hand uplifted as a menacing signal not to advance, seized by an unknown arm with an oath of violence, what was he to do? Meeks in wanton drunkenness imagined and had avowed, quote, that he was bound to have a fight on that night, end quote. Oliver had in friendship taken him off, and by a sort of pious fraud had obtained his knife under the pretense of paring his nails with it. Yet ill-fated and as if demented and doomed, he had returned, and at the same instant, with laying violent hands on Murdaugh, Montgomery and others inform you, he struck him with a whip or cowskin, and other blows at the same instant were inflicted by others. What, I ask you, was he to do? Every man feels in his own bosom, as testifying consciousness, that under such circumstances the right of defense would justify, the law of self-preservation would impel him to act as the laws of his nature prompt him, and the laws of the land justify him in acting. The vilest worm that crawls on the earth, if trodden upon, will turn against the heel that crushes it. The meekest and meanest of animals, when hunted down to death, in desperation will turn on its pursuers. It is an instinct of nature impressed on animal organization by an all-wise providence. Situated as Murdaugh was, to defend himself was but to act in obedience to a law of his nature, above the control of human laws, implanted in the constitution of his nature for good purposes. The love of self-preservation would predominate if even forbidden by positive municipal regulations when assailed, overpowered, and beaten down almost to the very jaws of death. To strike for your life or security of your person is an instinct inherent in your nature by the laws of heaven. It is an involuntary, spontaneous effort of your animal organization. It is the inspiration of God Almighty Himself upon the human heart to rebel and contend against destruction. Impelled by extreme necessity, under great impending peril of life, Murdaugh did stab Meeks, and of that wound he died. Although the calamitous occurrence is to be regretted, who can doubt the necessity of the act? A left-hand thrust, with a pocket-knife, by a feeble and partially disabled man in defending his person against dangers and himself from degradation against a superior in strength, aided by numbers, caused the death of Meeks. It, gentlemen, is unnecessary for me to recapitulate the testimony or array the facts to prove what is perfectly evident, that Meeks' death was the result of a necessity, that he causelessly, wantonly, and without provocation imposed on a stranger, to him unknown, and who indeed or by words had never offered him injury. The manner of the attack, the weapon used by Meeks, peril and necessity apart, gave higher provocation than a brave man will tamely endure. Should Murdaugh, when stricken with a cowskin, have submitted? Should he have whined and begged as a Negro slave when lashed? Should the finger of scorn be pointed at him as a coward disgraced by the whip? The jests of the rude, the taunts of the vulgar, would mark him for insult and mockery had he not fought. The very girls, even at church and on gala days, would have pointed to him as the chivalrous young gentleman of the striped jacket had he tamely submitted. There is not a man on that jury who deserves the name of a man that would passively submit to personal degradation by personal chastisement. The whelks of the cowskin would bleed and blister, fret and forever fester upon his memory, long after all traces of the lash were cured on his back. The life of the aggressor could alone atone for the indignity. End of section 24, read by Martha Weller, Champaign, Illinois, June 10, 2023. Section 25 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1, by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks, Kentucky, 1839, Part 10. As the accusation is more gravely urged against Judge Wilkinson than the other defendants, I will now advert to his conduct. Suits to obtain personal satisfaction for assaults and batteries they never committed are pending against the doctor and Murdaugh for the affair at the shop. An indictment is also pending against them for that violation of the public peace. This attempt to amerce the doctor and hold him pecuniarily responsible for an injury he never committed is like to those indictments against him for the murder of men he never before in his dream had thought of, much less of violence towards them. This persecution is perhaps on the ground that he was the judge's brother. Murdaugh, too, shares in all this legal persecution. First, because he is in bad company, and secondly, because, se defendendo, he slew a man so vile that the prosecution would discredit and render infamous the only man, Oliver, who seems disposed to recognize him as an acquaintance. The violation of the public peace at the shop is an injury that another jury will pass upon, and by their verdict avenge the insulted majesty of the law. Another jury will mete out to the prosecutor's satisfaction for the injury received on that occasion. You are now, gentlemen, called on in the name and on behalf of the Commonwealth to convict Judge Wilkinson of the murder of John Rothwell, a worthier and less offending man in the affray than Meeks, as it is insisted, and because, however excusable the other defendants may be, the judge at least, as the Commonwealth's attorney contends, did not act in necessary self-defense. In addition to the authorities already alluded to relative to the doctrine of self-defense, the following positions upon the law of homicide are, I believe, sustained by reason, and deducible from the text and reasonings of standard authors. When a retreat would not diminish, but increase the danger of a person under the imperious necessity of exercising his right of self-defense, he may, without retreating, oppose force to force, and even pursue his adversary unto death, if his own preservation require it. And such killing is justifiable. See Foster C.L., page 273, 1 Criminal Law, page 80. The right of self-defense is not confined to the party endangered. It is not only an individual, but a social right. It embraces the principal civil and natural relations, husband and wife, parent and child, master and child, not only may but in duty are bound to protect one another, and holds good between citizen and citizen in the spirit of the law, according to the reciprocal duties they owe one another. A servant or any other person, when a felony is attempted, may interpose and justifiably slay the aggressor. A person in possession of a tavern room, although no injury be intended him, may, against burglars or incendiaries, oppose such force as may be requisite to prevent the felony. To protect against murder, robbery, or enormous bodily harm, servants of the party attacked, or inmates of the house about to be robbed, may justifiably take the life of the assailant or robber. See Archbold, page 121, Foster, pages 273-4. I quote almost literally from the best law writers. These cases are but examples to illustrate rules. The law is more palpably embodied and distinctly presented to the understanding when exemplified by a case than when presented as an abstract rule of action without reference to circumstances. Homicide is justifiable or excusable when committed upon compulsion and ex necessitate, because the party does it not from choice as a free agent, but his action on the matter is constrained, his volition controlled by external circumstances. The concurrence of his will to the deed is absent. When there is no freedom of action, no voluntary assent of the mind, there is no moral and should be no legal accountability. When it is practicable with safety, the law to eschew the shedding of blood requires the party should retreat in cases of mutual conflict. But this requirement is only when he may be stationary or advance with as much propriety as it is consistent with his safety, and if his safety requires it, recede. How flight would have affected the judge's personal security is now a matter of pure speculation. If, for his own personal safety, he was constrained to act as he did, or if in the exercise of a social, not a selfish, privilege and duty, he succored his brother and Murdaugh to preserve their lives or protect them from great bodily harm, he, in law, is excusable. Society and mutual companionship justify such interference, as is happily illustrated by the case of the three men walking in a field, and one is assailed, the others may interpose to prevent a felony being committed, and may interpose to any extent to make their interposition effective, as you've already learned from the case so aptly quoted by Colonel Robertson. The reason of the law is this: the life of a citizen is, in its contemplation, dear, his person sacred. Against assaults, injury, or destruction, he may defend them to the last extremity. If the exigency of the occasion demands it, that right is not altogether personal to him, but it is a social right, and it is not only the right of any person to interfere to prevent the perpetration of a felony, but such interference to intercept the commission of a crime is enjoined as a positive duty. The natural relationship between the judge and his brother, the mutual ties of friendship between him and Murdaugh, his duty as a citizen, justified him in interfering in the conflict to defend them. By the spirit of the law for the purpose of defense, he is indentified with them. Their necessity and justification is his. Their right of self-defense is transferred to him, or is rather common to all. If the judge has not malignantly transcended the degree of violent interposition necessary to save his brother and friend's life, he has but fulfilled his duty as a citizen. I do not desire to be understood that officious meddling in broils is countenanced by law, nor do I mean to assume the position that where combatants are struggling in an affray to prevent mischief or keep the peace, extreme violence is proper. No such licentious latitude of action is even permitted to those engaged in the conflict. I limit the right by the wholesome restrictions imposed on willful, wanton killing in other cases. Before I call your attention to the evidence, I will merely advert to another principle of law which is sound in doctrine and applicable to this case. In treating of justifiable homicide in the due advancement of public justice, and in allusion to what killing is justifiable for that purpose, the opinion is intimated as correct by the author. 1 Hawkins, PC 107. Quote, "The killing of dangerous rioters by any private person who cannot otherwise suppress them or defend themselves from them is lawful, inasmuch as every private person seems to be authorized by the law to arm himself for the purpose aforesaid." End quote. This doctrine seems so near akin to lawful killing in the execution of public justice by hanging, or in the arrest of felons who cannot be apprehended alive by those who pursue them, that I cannot question its correctness. The law, to maintain itself and be respected, must tolerate the means to suppress rebellious contempts of its authority, and such means should be proportioned to the exigency of the occasion and consistent with the safety of the orderly and law-abiding citizen. Rioters assembled in force like rebels against the government when they condemn the supremacy of the law and spurn its commands should be regarded as outlaws and traitors. The law surely cannot cherish any such suicidal and disorganizing principles as a favorable regard for those who have forfeited all claims to be within the pale of its protection by their disrespect for its principles and the institutions of their country. Without a labored analysis of the testimony, the prominent facts are few and substantially as I shall recall them to your minds. I have but little to say of the scuffle in the evening at the shop. The occurrence itself is quite impertinent to the matters now in issue as I conceive. The defendants were staying at the Galt House in Louisville. Judge Wilkinson was to be married in a few days at Bardstown in the interior of the state. Whilst in Louisville, the wedding day being just at hand, it was thought by them that the operatives of one shop could not in time finish the necessary equipments in the way of dress. The judge and Murdaugh applied to Davy, one of the witnesses, to make their clothes. Dr. Wilkinson engaged Redding to construct for him a coat to wear to his brother's wedding. Dr. Wilkinson, to ensure promptness and satisfy any misgivings Mr. Redding might entertain of him, a stranger, deposited with him a $100 Mississippi note. The money was appreciating. The doctor did not wish to lose the exchange in converting it into Kentucky money just at that time, nor did he desire to incur a possible suspicion on the part of Mr. Redding that the garments would not be paid for. The judge and Murdaugh obtained their clothes and went to Redding's shop with the doctor, accompanying him as is usual with comrades in strange places. The fit of the doctor's coat did not please him. Alteration was suggested. The doctor was for throwing the coat on Redding's hands as an article he was not bound to receive. Some chaffering took place. The $100 was not surrendered, and that was the whole cause of the difficulty. Redding retained the money and insisted that the coat was or could be made to fit as such an article of dress ought. The judge, who was in the room, gave his opinion of the coat. It is probable Redding was not apprised that he was a brother of the doctor's. He spoke so harshly and insultingly that the judge rose from the stove where he was sitting and struck Redding with the little iron rod used for stirring coal. The judge may have been too hasty, but insulted by being told he was a meddling busybody, or substantially that, as you no doubt recollect the testimony, did no more than almost anyone might be provoked to do. A scuffle ensued, in which neither the judge, nor Redding, nor anyone else was hurt. The parties got from the shop into the street, were separated, and departed when, just as soon as Dr. Wilkinson got his money. Had the money been surrendered as it should, there would have been no difficulty. But for the occurrences happening since, the affair at the shop would have passed off, as it was in reality a slight, casual fracas not worthy of notice. The attempt to swell it into an important fight is ridiculous, and the expression of my opinion about the $100 is the most aid I can give you in your deliberations upon that mass of immaterial testimony from the shop and about the shop. After the parties separated, the Wilkinsons and Murdaugh go to their boarding houses, ashamed of what had happened, I have no doubt, or rather not thinking of it at all, in the preparations making for their trip to Bardstown. Not so with the other party in the quarrel. Menacing speeches and hostile movements characterize their deportment. In Redding's coffee house adjoining his shop, Meeks, Johnson, and his friends are seen. The affray which had taken place is talked of and discoursed. and the proposals and propriety of going to the Galt House to give the Mississippians hell is mentioned. Warrants in blank against the defendants were offered Redding. Those, however, he did not accept, to insert the names when ascertained. Redding, however, must go to the Galt House to procure the names. The Pacific, Johnson, Redding's legal advisor, had made the proposal to give them hell. Upon this stake cutter, immortal celebrity has been conferred by the roasting he has received at the hands of the gentleman, Mr. Prentice, who preceded me. Meeks gets his knife ready, is under the persuasion, yes, a sort of religious obligation rests upon his conscience, that he is bound to have a fight that night. He seemed, however, to have loaned his knife and gotten in its stead a cowskin. Oldham, who goes around for any chance, is up in blood for a fight on his own hook. At the ingathering, Rothwell, Redding's brother-in-law, and Holmes congregate with others. The concert of action, the hostile intentions, the conspiracy to inflict grievous injury on the defendants is so obvious from the testimony and has been so clearly enforced and happily commented on by others, Colonel Robertson and Mr. Prentice, that I will not fatigue you with its repetition. When the combined forces had convened according to the plan of concert, allow me, gentlemen of the jury, to ask your marked attention to the manner of conducting the battle. Several hours had elapsed since the skirmish at the shop. The names had been obtained. Redding awaited, it is said, the coming of a peace officer to serve the process. The names, when procured, like the rejected blank process, did not satisfy him. Staying for the marshal of the city or other peace officer at that place, an hour or more getting a memorandum of their names, are but flimsy afterthoughts to cloak another arrangement. Redding and his friends, picked men of Herculean strength and stature, are accidentally in the bar-room about the time the boarders and lodgers at the house assemble to catch the news or be ready for supper. Judge Wilkinson, who I venture had scarcely thought of the battle of the shop, came into the public room alone. If Redding did not recognize the judge, and if curious about his identity, why did he not address his inquiry to some third person? Why address himself to the man he had fought with only about 4 hours before? As if ignorant, why insultingly inquire of him, quote, "Are you the gentleman that struck me in my shop?" End quote. The judge very calmly and readily replied, quote, "I am." End quote. This conversation thus commenced, and the torrent of vile abuse from Redding instantly following, I take it was intended to provoke an assault from Judge Wilkinson. Had he resented by an attack the opprobrious epithets so lavishly bestowed upon him, Redding and Company, as the assaulted party, would have shielded themselves under it, as a legal justification to have inflicted upon him a most grievous battery. This finesse to bring on the fight failed, and Judge Wilkinson returned to his room. Great forbearance had been exercised by Judge Wilkinson. He claimed to be protected from insult and violence, and requested of the proprietor of the house, Mr. Everett, to furnish him with pistols at his room. No arms were brought to him, and after remaining in his room about a quarter of an hour, he again came down to the bar-room. In the diagram shown you to point out the localities of the house, you recollect in descending the stairs just at the foot, there is a window overlooking the bar-room. Time for Redding to depart had intervened since the recent quarrel, and in passing the window by the stairway, if Judge Wilkinson had thought of it and passed into the public room, he would not have discovered Redding there. The witness, Rayleigh, informs you that when Judge Wilkinson, at Everett's instance, returned to his room, Redding and some of his friends also left the public room and went into the entry or across the passage into the reading room. The judge came into the room in company with the other defendants, or they were immediately in his rear. Up to this time, no intimation had ever been given to the defendants that Meeks or Rothwell were enemies. Redding was the only one of the conspirators personally known to them. The existence of such conspiracy they were as ignorant of as they were of the individuals who composed it. The judge, it is true, was armed with a bowie knife, but Murdaugh and the doctor were not equipped for fight. Redding again came into the room. He had been foiled in his effort to bring on a fight by the patient forbearance of the judge. During the interval, the judge was upstairs. It is more probable that Redding left the public room to rearrange his plan of attack than for any other purpose. Whether Judge Wilkinson's knowledge of the topography of the house would have enabled him to sneak to supper by the way back of the barroom, designated in the diagram, we do not know. The premonition he had already received would have induced a prudent man to arm himself. He came into the barroom the usual route to the supper table. His right to wear arms for his defense is as unquestionable as his privilege to come into the room. About the time of Redding's re-entry into the room, Mr. Pearson, just when Murdaugh was attacked, and the remarks were made which I will presently attend to, accosted Judge Wilkinson, to whom he had been passingly introduced the previous summer, and told him it would be better to leave the room. This suggestion from Pearson he acceded to, and was about leaving when the quarrel and fight arrested his attention and checked his exit from the room. The admonition from Pearson and the testimony from the other witnesses are replete with proof that however secret to the defendants, it was apparent to others they were to be attacked. The remarks made in their absence upstairs, the mysterious presence of unusual personages about the house, fighters all, but too clearly foretold the impending danger. At the shop, Murdaugh had displayed hastiness of temper. He was young. With him a fight might be provoked. He would possibly answer their purpose. The judge had been insulted but declined battle. Just before, Murdaugh was angered by a provoking falsehood, as to his drawing his knife, etc., at the shop. Redding is heard to say, quote, "These are the three men," end quote, or, quote, "Here are the three men," end quote. Mark the words, they are of ominous import. To whom were they addressed? The words, quote, "The one whom I shall kiss is he," end quote, did not more significantly mark the object of treason than Redding pointed out the defendants. When the conversation commenced, the conspirators at the signal, like Caesar's assassins when the petition for the recall of Metellus from exile was presented to him in the Senate chamber of Rome, gathered around the intended victim. The murmurs that in whisper had presaged the storm, the growling muttering broke into open violence. The onset is made upon Murdaugh in one part of the room, as we have before stated. At the same instant the doctor is stricken down. Proximity to Pearson, an esteemed citizen of Louisville, perhaps saved the judge. About the time Murdaugh stabbed Meeks, from the testimony of General Chambers and Montgomery, you cannot but be satisfied that Rothwell, with his cane or bludgeon, was also inflicting violence on him, then reeling and almost bound to the floor by severe blows on the head. The severity of the blows is evident from the scars left, and Meeks could not and did not inflict them. At this crisis, the judge did inflict with his bowie knife a wound upon Rothwell in the side or back. Murdaugh, extricated, seems to have gotten from the room, and in that part of it, where Holmes had the doctor down prostrated and lifeless, Rothwell hard by is again stabbed by the judge. As soon as disengaged, the defendants retreat to their room upstairs. When Rothwell received the second stab, a futile attempt is made to show, and Johnson swears he was performing the office of pacificator. He was one of the conspirators, was present, engaged in the fight, had come to the Galt house for the purpose of abetting the lawless violence, and it would be as miraculous if any such instantaneous revulsion of purpose seized him, as it is wonderful that no one present heard the pacific exclamation, quote, "Peace! For God's sake, peace!" end quote, about the time of the second stab, except this redoubtable and veritable Billy Johnson. This sketch of fancy is no doubt of a piece with much of the testimony of the conspirators in relation to the matter. Pride of character, if any they have, tempts them to extenuate their conduct for their own exculpation. Chagrined by defeat, burning for vengeance, they testify with all the feelings a party could in his own cause. Their account of the occurrence should be discarded, because others present were disinterested lookers-on, whose recollections are not warped by bitter prejudices. The testimony of persons not of the party is every way less exceptionable, less suspicious, and more satisfactory. In scanning the testimony of various witnesses to the same occurrences, enlightened reason teaches the propriety of not rejecting what one testifies because another did not see or hear the same thing. That you did not see or do not know what I have seen or what I know is no reason even to doubt the detail of facts I may make. When within the range of human probability a credible witness attests the existence of a fact, it outweighs the negative testimony of the whole world. What you know to be true is not the less so because others do not know it. Now, rejecting altogether the testimony of the conspirators, or in charity permitting it to prevail when not contradicted by the unenlisted lookers-on, the brief narration of the matter up to the stabbing of Rothwell is a succinct history of facts. To reconcile apparent clashings, or rather to fill up omissions in detail which may seem to occur, apply the rule just suggested, and you may well credit and reconcile all that those gentlemen have testified to. What Trabue saw may have escaped the observation of Graham or Rayleigh, and so of others. The testimony of one cannot be impugned because another did not see or may not recollect what he sees. Of the wounds inflicted by the judge, and a wound inflicted in the breast by an unknown hand, Rothwell died. By collateral remarks foreign to the cause, I am unwilling to detain you. The severity of the conflict is too well attested by the death of two and wounds of others of the assailants. The peril of the conflict to the defendants is too well attested by the still visible marks of violence on their persons. The brutal and merciless beating inflicted on the doctor, the attempt not only to chastise but to take the life of Murdaugh, as manifested by the cuts with a deadly weapon through his hat, the assassin's stab the judge received when the combat was being declined by returning to his room, a retreat itself by brave men, too clearly proves that enormous bodily harm and impending hazard of life had placed the defendants in the attitude justifiable of self-defense. By the joinder of the defendants in the indictments, they are identified in the proceedings as one individual. If for the purpose of accusation, the crime of one is the crime of all, the right of defense should be deemed the right of all to defend. Are good citizens to stand by and let a lawless band of ruffian conspirators slaughter them one by one? Must each run as far as he can, and if overtaken, fight if he can? The prosecuting attorney, Mr. Bullock, seems to insist that unnecessarily, in their malice, Judge Wilkinson stabbed an unoffending man in the back, and thereby caused his death. The nature of the offense is not affected by the part of the body the blow may happen fortuitously to alight upon. That the blows were inflicted maliciously or even willingly, except so far as constrained assent of the mind constitutes such willingness, cannot be believed. Suppose, gentlemen of the jury, any three of you were to go to the state of Mississippi and land at Vicksburg or Natchez, whilst temporarily at a tavern in one of those places, before proceeding to the interior on your business, you have a difficulty with citizens of the place and kill two of them. When the news reached your friends here in Kentucky, 1,000 miles from the scene, would they not be willing to swear that necessity, and necessity alone, induced you to kill strangers you never before saw? Men, too, with whom neither from business nor acquaintance you had ever before had intercourse? Judge Wilkinson, with his brother and friend, had come to Kentucky on an embassy of love. So near the consummation of his nuptials, he would not desire the comeliness of his person nor the integrity of his attendants to be soiled by a fight. At such a time, distant, far distant from his thoughts, would be meditations upon bloodshed and murder. As a visitor to our state, he was entitled to our hospitality. We do not, as the wandering Arabs of the desert, seize and prey upon the confiding traveler. Surely we are too civilized to regard all strangers as enemies, and like the piratical barbarians of northern Europe in the Dark Ages, consider as lawful booty all who unfortunately or accidentally are cast upon our shores. To our state, as the abode of hospitality, Judge Wilkinson had come to contract the tenderest of human relations with one of the daughters of your land. A distinguished citizen of his own state, and known throughout the Union as a valued and honored citizen, A pacific man, at such a time, is it consistent with reason to believe that he would, but by constraint, have involved himself in so disagreeable a difficulty? The language and the deportment of the judge, his retiring, the motives of action that would influence any man circumstanced as he was, evidences how studiously and consistently with self-respect he avoided a conflict. Now, permit me to ask you, when at last a fight was forced upon the defendants, what should Judge Wilkinson have done? Ought he to have stood calmly by until at leisure they were all lynched or slain in detail? Should he, if practicable, have run until caught and then have fought? No, no. As a true man against them, lawless rioters, he had a right to defend his companion and brother. A mob arrayed in numbers with force were inflicting ignominious and grievous hurt upon his companion and friend. Men whom he had never wronged, unmerciful in their wanton riotousness, of superior brutal force, were mangling Murdaugh with bludgeons, and instruments of death were savagely playing about his person. The doctor, his brother, whom he loved with a brother's heart, was overpowered, downtrodden. They were crushing the life from his body as he lay prostrate on the floor. Ought the judge to have refrained from interfering? Who could refrain? Does reason or law require any such degree of high and impracticable philosophy as apathy and indifference under such circumstances? He that would not rescue a friend or brother never deserved the fidelity of the one or the affection of the other. Had the doctor or Murdaugh been murdered, and the judge had not interfered, a voice of execration against his faithlessness and cowardice would have rung over the whole state that could only have been equaled by the deep-toned denunciation that would have resounded through the length of the land if the mob, unharmed, had succeeded in their bloody and murderous purpose. The revolutionary and disorganizing proceedings of mobs in New York, in Mississippi, and at other points in a few years past have tarnished the fair character of our country. These lawless conspirators have imprinted on the escutcheon of our state the first foul blotch of lynchism. Contemners of the law, signally foiled by the resistance of their victims, in the name of the law they now ask you to perform an act of vengeance for them. Rebuke them from this place. Repudiate their claim to be avenged. Through your instrumentality on men whose lives they have attempted by violence, whose characters they have traduced, whose liberty they have infringed by incarceration in a common felon's jail, and whom they would now doom to felons' graves. By your verdict, proclaim to the world that our state, in bygone times known as the dark and bloody ground, is now a land of civilization, where peace and good order in society are respected and the laws revered. Gentlemen, any inaccuracy of statement as to the evidence I have fallen into, your memories will correct. The further defense to be made by an older and abler advocate will more than supply all admission on my part. As to myself, the fate of the defendants is in your hands. I thank you for your polite attention. End of section 25, read by Martha Weller, Champaign, Illinois, June 13th, 2023. Section 26 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1, by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks, Kentucky, 1839, Part 11. Mr. Hardin, I little expected when I engaged in this cause in Louisville last winter that I should ever have to address you on the subject. Although I have been 50 years practicing at the Kentucky bar, this is the first time I have ever had to address a jury in this place, and I cannot help feeling that I am as much a stranger here as any gentleman who has addressed you. I shall, however, in speaking to you, apply myself to an exposition of the facts and of the law bearing upon them, and whatever may be your feelings, you will, I am sure, keep in mind that you are bound to exercise your reason, and that you owe a duty of no ordinary responsibility to yourselves, your characters, and your country. That duty is a sacred trust reposed in you which you cannot weigh lightly, without injury to yourselves as well as wrong to others. Nor must you surrender up your reason to your passions, and allow yourselves to be carried away by the shouts of applause from a fashionable audience, as if you were in a theater where a Junius Brutus Booth and a Miss Ellen Tree exhibit the practiced arts of controlling the feelings and successfully eliciting the noisy plaudits of excitement. This is not a theater. This trial is not a farce, nor are you seated on those benches for amusement. This, gentlemen, is a solemn court of justice, a solemn tribunal, in which your judge, presiding with becoming dignity, represents the majesty of the law, and in which you are expected to deliberate with becoming gravity upon circumstances of awful import. The appalling death of two fellow creatures is the occasion of your being here assembled, and the guilt or innocence of those at whose hands they fell is the object of your solemn investigation. Even though I knew I should have to address a jury of strangers and an assemblage to whom I am personally unknown, I little anticipated that I should have to make a speech to any other audience than that usually to be found in our halls of justice. But my friend Colonel Robertson, whose youth and warmth in that way urge him to precedence, has taken me by surprise, and placed before me a gallery of beauty and fashion, which might well deprive me of my presence of mind, if I were not fortified with less of the ardor of youth in my veins than himself, and were I not less practiced in those graces of person and manners which he can so successfully play off to woo and win their fascinating smiles. By law, and in conformity with the original institutions upon which all law is founded, this trial was to have taken place where the occasion of it occurred, in the county of Jefferson. The legislature, in its wisdom, has thought fit to change the venue from Jefferson to Mercer County, but why I am unable to say. For even Colonel Robertson, the very able counsel for the defense, has admitted that, although for a time great excitement existed in Louisville, yet, after the investigation at the examining court, that excitement was altogether allayed. In this country, experience has always taught us that when a change of venue is sought, the object is not to obtain justice, but to evade it. The object is to thwart and embarrass the prosecution, and multiply the chances of eluding the responsibility of the law. How is this effected? Is it not by a removal to some place esteemed favorable to the accused? By a removal so distant from the scene of action that the expense and inconvenience render it probable but few of the witnesses can attend, by a removal to where witnesses of a character dubious, if not infamous, were known, may find credit because they are unknown? Here we are some 70 or 80 miles from the stage on which this tragedy was acted, yet we are asked why we did not bring the stick and the cowhide and Bill Holmes the pilot, as if we would be afraid to produce them were they within our reach. I would ask the opposite side, in my turn, why gentlemen have brought us 80 miles from the scene where we could have elicited the truth in every particular. I listened yesterday with great pleasure to Colonel Robertson, whose speech was very good, and evinced as much of the fire of youth as the flowers of rhetoric, but I cannot say it was much calculated to convince the understanding that the worse can be made to appear the better cause. I also listened today with great pleasure to Mr. Prentice, who addressed you yesterday and in part today, and I must say that although there were in his speech some things which I could not approve and many deductions which I could not admit, yet, on the whole, it was an oratorical effort which I could not help admiring. I am even disposed to go farther, and to say that I am utterly astonished that such forensic powers, and so ably wielded, did not prove less abortive. But I must attribute the feebleness of the effect more to the weakness of the cause than to the want of genius in the advocate. However, Mr. Prentice really astonished me with one proposition he laid down with respect to the common law of this country, that every man is to judge for himself where the point of danger lies, that entitles him to disable another or to kill him, lest he might, in turn, by possibility, become the killed, so that, in fact, if it were so, the point of danger never could be defined by law, because what brave man would consider no danger at all, a timid man would consider the point of danger bristling with 1,000 deaths. Was there ever such a monstrous doctrine recognized by the laws of any community? Mr. Prentice: I only urged that what might be considered by a man, from apparent circumstances, the point of danger, where resistance was necessary for his own preservation, would in the law be grounds for justifiable homicide. Mr. Harden: I will come to that in due time. The dilemma cannot be removed that the same point, according to this doctrine, is, and is not, the point for the resistance contemplated by the law. No, gentlemen, the law recognizes no such absurdities. The law was laid down yesterday correctly by the district attorney, that when the killing of a man has taken place, it is a murder in the eyes of the law, and must be pronounced by the law to be a murder till the contrary is shown. What then becomes of this new doctrine, unknown to the law, that the slayer and not the law is to judge and presume the justification? The law itself says all killing of one man by another is murder. The slayer, according to Mr. Prentice, says, quote, "Oh no, I killed my man because I fancied he would kill me. It is not murder, it is justifiable homicide." End quote. Yet the law again says, if a sheriff who hangs a man by lawful authority, and in doing so commits only a justifiable homicide, should, even for the best of motives, instead of hanging the man, as bound to do, chop his head off with a sword, though death must necessarily follow either way, yet is he guilty of murder, and liable to the punishment for the killing contrary to the prescribed mode of his duty. These three gentlemen now arraigned before you are residents of the state of Mississippi, and they came to Kentucky early in December for what is of no import that I can see, although it is made to cut a conspicuous figure here as a favor conferred on Kentucky, a contemplated marriage at Bardstown. They arrived at the Galt House, where Judge Wilkinson had his clothes made up. If he had any prepared for the occasion, is not shown. Where Mr. Murdaugh had his made, if any, is not shown. But it is shown that Dr. Wilkinson was to have clothes made at Mr. Redding's. They were made with great punctuality, and the doctor came to Redding's store at the appointed time. He tried on the new coat and seemed well pleased with it. So satisfied was he with the coat that he wore it on the spot and left $100 bank bill on account of payment, requesting Mr. Redding would hold over the bank bill, which was of a Mississippi bank bill, till some expected change for the better would take place in the rates of discount. Dr. Wilkinson then went away wearing the coat, and desiring the other things to be sent to the Galt House. As I now come to where it will be necessary for me to mention the names of witnesses, I beg it to be understood that I do not mean to avail myself of the example set by the opposite side. I will not shelter myself behind my professional duty to vilify an unfortunate witness, disarmed of his self-defense, unfortunate because of his inability to make any reply in the same public court in which he is maligned. Younger gentlemen at the bar than I am may indulge in the practice, and perhaps the rashness of youth and inexperience may excuse what wisdom and manliness could not justify. No character, however spotless, no reputation, however unstained before, can escape the sullying hand wantonly raised to tarnish it, where there is no immediate opportunity of wiping away that which corrodes while it damps the luster. When Dr. Wilkinson returned to Redding's store, accompanied by his brother and Mr. Murdaugh, some objection was made to the collar of the coat. It was no serious objection, we may suppose, for we hear from Mr. Prentice himself, the expectancy and rose of the fair state, that he, perhaps, would not have been quite so fastidious. Perhaps some young fellow like my friend Colonel Robertson, the glass of fashion and the mold of form, might have been a little squeamish. But for myself, everyone knows I am not particular. I never should have knocked down a tailor with an iron poker because there was a shade of fashion lacking in the collar of my brother's coat. The whole thing, I admit, is a matter of taste, the poker included. But there was, however, some objection to the fashion of the coat, and that objection was thought grave enough to enlist the triple wisdom of a dignified judge of the land, an eminent doctor of a distant state, and a sage member of the Mississippi bar. Yes, with this formidable array of judicial wisdom, pharmaceutic skill, and legal research, these three gentlemen came to a little store in Louisville to fight a poor tailor, and all about an unfashionable twist in the collar of a coat. To be sure, they came from the El Dorado of the South, with their thousands of bales of cotton condensed into their pockets. They were perfect magnets of attraction, for the secret of their lodestone lay wrapped up in their Mississippi banknotes. Hotel keepers were bowing to them on all hands, tradesmen and storekeepers honored the pavement they trod, and as to tailors, I am ready to believe they became perfectly fascinated with them. Nay, I even make no doubt that the keepers of watering establishments and medical springs submitted to the soft impeachment and became devoted to their interests. It is the necessary consequence of the influence of cotton bales. Here was this hard-working tailor, ever on the watch for good customers, bowing to them as assiduously, if not more assiduously, than the hotel keepers or spring doctors, taking back his coat, I have no doubt, with tears in his eyes. But is it reasonable to suppose that, fascinated as he was by the ability of such customers to pay, he would be so blind to his own interest as to give unprovoked quarrel to such customers? However backward he may have been from prudence and circumstances, it seems that there was no want of readiness to carry matters with a high hand on the part of those with whom he was dealing. Judge Wilkinson is sitting on a stool at the stove, and when he sees his brother about to pay for the pantaloons and vest, he interferes without being called upon to do so, and opposes the payment for these things, upon which the tailor very naturally asks him what business he has to interfere. The judge, without telling him that he was the doctor's brother, which Redding did not know, and that as such he had a right to advise him, jumps up, snatches an iron poker, with which a man could be knocked down as readily as with a crowbar, and for the small provocation of a tailor, saying, quote, "You make yourself a little too busy in the matter," end quote, ignorant that he was addressing a dignified judge. The judge aims a deadly blow at his head, which, if not fortunately warded off, might have involved consequences to which I must not advert. What does this prove? If it proves nothing else, does it not show plainly that Judge Wilkinson is not quite as mild and forbearing in his disposition as his friend, Mr. Prentice, would have you to believe? Did Judge Wilkinson's conduct show that it was his belief men's passions should be subject to the control of law, if not of reason, that he was in principle a respecter of the law in this instance? I know it will be argued that there is a wider latitude given to the restraints of law in the southern than in the northern states, and a false assumption is built upon this circumstance, that the free use of personal liberty to avenge private quarrels gives greater bravery to a people. But I have read, I have witnessed, and I believe that the people of New England, a section of this great republic where you can get no man to fight duels, and where every man throws himself under the protection of law for the redress of his private wrongs, when they have been called into the field for the protection of their country, have shown the brightest examples in modern history of personal bravery and national valor. Show me where men have been more prompt to rush upon the bayonets of their country's invaders than the heroes of New England. Sir, courage and bravery belong to the respecters of the law, which protects every man's rights in a civilized community. Climate, in a country of such vast extent as this, may have its influence on men, as it is known to have on the inferior race of animals. You may meet the lion, distinguished for his courage and his power, in the Barbary States, where, conscious of his strength, you may pass him unmolested, if you are not the aggressor. As you descend to the more southerly latitudes, you meet the leopard and the panther, with whom treachery and ferocity are the substitutes for courage. And when you pass the equator, you meet the hyena, the emblem of uncompromising cruelty, and without a redeeming quality. Men may in like manner be affected by climate, and he who on the iron-bound coast of the frozen north, or on the arid rocks of New Plymouth, would illustrate every noble virtue of his nature, not less distinguished for his piety than his patriotism, for his endurance than his courage, and for his generosity than his bravery, when transplanted to the enervating regions of the South, may become different and degenerated, trusting more to his interests than his patriotism, to advantage than to courage, and to concealed weapons than to bravery. But to resume my review of the evidence, Judge Wilkinson, so remarkable for his mildness and forbearance, as a sample of these qualities, aims a blow, as I have said before, at the tailor's head, which probably would have killed him had he not warded off the blow with his arm in a manner to give great offense to Mr. Prentice, who cannot see the propriety of a tailor grappling with a judge to prevent a repetition of blows that might break his head. The little tailor, however, did grapple with the judge, and dragging him to the side door, he falls with his adversary out on the pavement. The tailor, though small, being strong and active, turned the judge under, and as he did so, Murdaugh hallooed out, quote, "Kill the damned rascal," end quote, a command which the doctor was about to obey, and when he was within a couple of inches of plunging his dirk into the tailor's heart, Mr. Redmond caught the doctor's arm. But for that interference, it would have been the last of Redding's career. Mr. Murdaugh had hallooed out to the doctor, quote, "Kill the damned rascal," end quote, and in the next breath, quote, part them, end quote. This is easily accounted for. When he saw that Redding, by Redmond's interference, had gained the advantage, he perceived that the tables were turned, and fearful of the consequences, became as impatient to have them parted as he had before been anxious to have the tailor killed. Well, they are parted, and when they get up, Dr. Wilkinson still has his knife drawn, Mr. Murdaugh has his knife drawn, and the judge has his favorite weapon, the poker. The little tailor's courage, notwithstanding this formidable array, is up, and he steps forth, a David before Goliath, and offers to fight the whole three of them if they will lay aside their weapons. This, I think, however, was a mere brag with the poker players, for I do not believe he could have done it. 5 witnesses swear that both Dr. Wilkinson and Mr. Murdaugh had out their knives. Several concur that Dr. Wilkinson re-entered the store with his knife drawn, demanding his $100 bank bill. All agree that he got it, and many agree that when he and his companions left for the Galt House, 2 went away exhibiting their knives, and 1 rejoicing in the poker. The knives, to be sure, have been identified as white-handled knives. Mr. Prentice, in that able speech which you have all heard and admired, and which, it must be admitted, like a West India tornado, swept through this house, carrying everything before it, even to the reason of many who heard it, seemed to think that we had some particular fancy for the handles of the knives, because they were white handles. He thought we dwelt uncommonly on the whiteness of the handles, till like spectres they were continually flitting before our visions. With all this poetical or forensic coloring, we have nothing to do. We only identified them, and the gentleman has failed to contradict us by proving that they were black, green, or red. We have now, gentlemen, traced a small portion of this affair at the tailor's shop. In what occurred there immediately after what has been mentioned, we find the following facts established. Mr. Redding swears that he was advised to enforce the law against these gentlemen. The principal officer of police, the city marshal, is usually to be found about the mayor's office or jail from the peculiar nature of his duties. Mr. Redding proves that he and Johnson went toward the mayor's office and looked for the marshal at Hyman's and Vaccaro's coffee houses. Not finding him there, they went on to the mayor's office. They applied at the mayor's office to Mr. Pollard, clerk of the city court, and told him that one of the gentlemen was named Wilkinson, and that the names of the others they did not know. They were told by Mr. Pollard that they should have the names, or, if they wished, they might have a blank warrant to be filled up with the names when ascertained. This Redding declined upon being told that if he could meet the marshal, he could arrest the parties without a warrant. Redding and Johnson proceeded to the jail in search of the marshal. Not finding him there, Redding returns by Market Street, at the corner of which he met Rothwell near his residence. As he tells Rothwell, his brother-in-law, the nature of the affair, Rothwell goes along with him. And here I must remark that to come down to Market Street from the jail is the shortest way, though my friend, Colonel Robertson, thinks that a man may go round by Jefferson Street a few hundred yards out of his road by way of a shortcut. But Redding, being but a plain man, not given to sophisticated deductions, believes the nearest road is the shortest cut, and took the shortest cut by Market Street, where he met Rothwell, as I have said, and told him what had occurred. He did not ask his brother-in-law to go with him, but his brother-in-law did think proper to accompany him. There was no Bill Holmes, no Marshal Halbert, no Billy Johnson, no one but Rothwell accompanying Redding. Mr. Graham swears that there was no one with Redding but Rothwell when he met them near the Galt House. Where was this terrible array of giants and Patagonians of which we have heard so much? Why, nowhere, to be sure. The gentlemen have only drawn largely on their imagination. As Sheridan once said of Dundas, they are indebted to their imaginations for their facts, though I will not go so far as to say of my sprightly friend, Colonel Robertson, or my brilliant friend, Mr. Prentice, that either is indebted to his memory for his wit. Jackson swears, indeed, that he heard propositions made of going to the Galt House to give the Mississippians a beating. Yet Graham swears Jackson would always lie a little. This Jackson, whom we have shown to be unworthy of credit, swears to that being a fact which is contradicted by Redding, by Johnson, and by Craig, whose credibility is unimpeached and unimpeachable. But it seems Mr. Prentice takes peculiar exceptions to Bill Johnson, because he uses strange figures of speech and low and outlandish tropes and metaphors. Well, the gentleman ought not to blame poor Johnson for imitating his betters in the arts and graces of oratory. I suppose he has been reading the newspapers in which the reported speeches of the most eminent members of Congress are recorded, and he finds one distinguished gentleman charges a party with being like a greasy pack of cards, all spotted and marked and shuffled together. Another young aspirant compares the Secretary of the Treasury, a dignitary old enough to be his father, to a she-bear, running through cane-brakes and dropping her cubs at every step. And yet Johnson is blamed for his figures, if he ever used them, of hides full of shucks, and skinning of sheep. I thought Mr. Prentice, who so lately returned from Congress, would have admired Bill Johnson for being so apt a scholar, like that classic personage, Zip Coon, in picking up the new and approved style of tropes and metaphors now so fashionable in the places which he himself has made resound with the aptness of his illustrations. Gentlemen, I had got to this place in the affair at the Galt House, where Redding and Rothwell were seen unaccompanied by any one entering that hotel. Mr. Redding says when he went into the bar-room, he looked over the register and called for the names. Scarcely had he got them when Judge Wilkinson entered and stepped up to the counter to take a drink of water. Redding addressed him thus, quote, "Sir, I believe you are the gentleman who struck me with the poker in my own house this evening." End quote. If Judge Wilkinson was sorry for his imprudence, why did he not then say it was in a hasty moment and upon reflection he felt that he was wrong? Could Redding have resisted the ingenuousness of such an answer to his inquiry? Could he have harbored for a moment longer any irritation for an acknowledged injury? But what did Judge Wilkinson say or do? Why, he heaped insult upon injury by an aristocratic allusion to the tailor's profession. Quote, "I will not," he replied, "fight or quarrel with a man of your profession." End quote. Now, although I agree with Mr. Prentice that there is nothing disgraceful in a profession, and I think the poet has expressed himself with scarcely less felicity than Mr. Prentice on the subject, honor and shame from no conditions rise. Act well your part, There all the honor lies. And as Burns says, the heart's aye the part, aye that's right or wrong. Yet we cannot help imbibing with our literature and our sentiments many trifling prejudices from the mother country, where aristocratic pretensions have too successfully attached disgraceful notions to certain pursuits of industry, and among these, the profession most sneered at by the would-be wits of the last century is that of a tailor. And although a man of that profession here may justly feel that he is as respectable, and follows as respectable a calling as any other man, yet when he thinks those old sneers are leveled at him as an insult, he naturally resents it with the indignation of an honest and industrious and free citizen, not bound by a servility unknown to us, to succumb to him who dares to utter it. There is, I fear, a principle growing up amongst us, inimical to our republican institutions, a principle of classification favorable to aristocratic distinctions. We have our bankers, lawyers, and doctors arrogating one rank in our society, the statesmen, heads of departments and officials, another. Our mechanics and those who toil by the sweat of their brow to produce our riches are cast into the shade, and knowing as they do that such an attempt, however noiselessly it is made, still exists palpably, is it any wonder they should be sensitive to every whisper that is breathed to mark the invidious distinctions? An apparent unimportant word may wound deeper than rough language. Call a man a knave, and he may forget it, but call him a fool, and he never forgives you. Call a young lady a coquette, and she may pardon you, but tell her she is ugly, and she will never abide you the longest day she lives. Tell a tailor he is a botch, and he may not even get angry with you, but sneer at him about his goose and his profession, and you insult him, though the words in themselves are harmless. It is the allusion to prejudices that have existed which carries the poison of insult in its barb. Sir, we must not disguise the fact that there is a line of demarcation drawn by the proud and arrogant between themselves and those who live by the sweat of their brow, between the comparatively idle, who live but to consume, and the industrious, who work but to produce, between the drones of the hive and the laboring bees. And to which, pray, is the country in its strength, prosperity, and wealth indebted for its teeming productiveness? To which for her energy, enterprise, protection, genuine patriotism, and celerity in national or municipal times of danger? Go to Louisville when a portion of the city is enveloped in flames, and you will see 1,000 mechanics rushing into the devouring element for the protection of property, while the lawyer and the judge and the haughty aristocrat walk about as spectators with their hands in their pockets. The mechanics compose the moving power and labor-working machine upon whose industry we all feed and fatten. Their labors are the wealth of the country, and when we cease to honor and cherish them, we poison the springs of our own invigorating prosperity and cut off the sources of our own enjoyments. Do we treat them with gratitude when we taunt them with epithets which they esteem derogatory or insulting? Are we to treat them thus in the halcyon days of peace, and when the thundercloud of war gathers around our course, with a monstrous pusillanimity fling ourselves into their arms as our only hope and rescue? Has not the history of our country shown, and will it not show again, that when the storm of invasion ravages our coasts, our safety is to be found alone in the strong sinew and ready arm of our laboring population? Where, then, are your bowie knife and pistol gentry, your duelists and your despisers of the man who lives by the sweat of his brow? Sir, they will be found cowering and lurking where they may snuff the battle afar off and hide their once lofty heads in ignoble safety. But I will not consume your time with recitals which may be found in every page of our history. I shall return to the evidence in the case before you. Mr. Everett is told by Mr. Sneed that there is likely to be some difficulty. Mr. Everett goes into the bar and by some indications to the judge meets him in the passage and takes him to his room, where they find Dr. Wilkinson and Mr. Murdaugh. Judge Wilkinson relates to them what had happened. The judge, having made this relation, asks Everett to provide him with pistols. Why? For what did he want them? Was anyone attacking them there or likely to do it? They were safe in their room. They could only want pistols for the purpose of descending and making the attack themselves. But Everett is asked to provide pistols. He said he would try, and with that avowed purpose left them. He had not been gone 15 minutes, in the opinion of some, in the opinion of others scarcely 10, when Judge Wilkinson, with this lower country toothpick, taking up the bowie knife, not trusting this time to the more merciful weapon with which he had been practicing, the tailor's poker, with this lower country toothpick he started down prepared to use it. Did he know Rothwell? Did he know any but Redding? No man had accosted him but Redding. Why then did he come down with this terrible implement of murder? Why, sir, just exactly for this reason, that he had been mortified at the result of what happened at Redding's store. The judge of the land had been turned over by a tailor. He had been bearded and abused by a tailor, and he provided himself with his bowie knife and went down to have another deal with that tailor. Mr. Prentice seems to think the judge had a right to go down to his supper. Why, so he had, but he had a right to wait for the bell to ring. He had no right to eat his supper before it was served up, no right to take his bowie knife down to the kitchen and terrify the cooks to allow him to devour the supper while it was cooking. And had the supper been ready, there were table knives wherewith to carve his meat, and he had no right to carve it with a bowie knife. But the supper was hardly cooking when he went down. The bell had to be rung over the private passage upstairs before it was rung below, and when rung below the folding doors had to be thrown open. But the bell had rung nowhere, and Judge Wilkinson, Dr. Wilkinson, and Mr. Murdaugh came down before any bells were rung. Therefore it was not to supper they came down. Which table had Judge Wilkinson been in the habit of going to, the large table or the ladies' table? There is no proof that he and his companions boarded at the large table, and it is known that many gentlemen, as familiar with the house as they had been, prefer the private or ladies' table. We have every reason to believe that was the table at which they boarded. The entrance to the room where that table is kept is not through the bar room. One entrance to the large dining room is indeed through the waiting room, and there is a bar in that waiting room, at which many gentlemen who are not pleaders become suitors, make motions, and put in their pleas. I sometimes make my appearance at that bar, but I am not summoned by the attachment of the bottles. I go to hear the politics of the day, for although I have long since quit the field, I cannot be cured of the curiosity to know what wrangling is going on among the little juntas in every village as well as among the mighty ones of Congress. When these three gentlemen got into the bar room, Mr. Redding was at the counter. Mr. McGrath was inside of it. Mr. Reo was at the fire. Some say Mr. Redding came in immediately after the judge. You must expect that out of 20 witnesses, no 2 will agree in all the facts. But in a transaction like this, where several fights were going on, where in every corner a man was bleeding or dying or suffering, that no 2 men could see everything or anything alike is to be expected. But, gentlemen, by collecting all the evidence together, contrasting, comparing, and justifying one by another, we can arrive at the facts of the case clearly and beyond the probability of doubt. We can arrive at them with as much certainty as we can at any other set of facts, and from this manner of collating the facts, I am enabled to present them to you without fear of contradiction. One of these facts is that Judge Wilkinson walked across the bar room, some 25 feet, when he came in. Mr. Trabue, a man whose evidence is to be depended upon, seems assured that when Judge Wilkinson came in, he walked 3 or 4 times across the room and then stood a while with his eye fixed upon Mr. Redding, his foot advanced, and his right hand behind in his coat pocket, and, I make no doubt, with his hand grasping the handle of this very bowie knife. At that moment Mr. Murdaugh went up to Redding. I will not say, with one of their own witnesses, that in going up to him he rattled like a viper, but as he went up he addressed Redding, saying, quote, "I understand that you say I drew a bowie knife on you in your shop this evening. If you say so, you are a damned rascal or liar." End quote. And as he said so, he opened his knife and elevated it, as one said, or held it down, according to another. Yes, he accosted Redding in the most insulting terms and threw open his knife at the same time. Is there any witness who has said Redding accosted him in an angry manner? One person said of the knife, quote, "Lord, how it gleamed in the candlelight." End quote. The most warlike nation the world ever saw was Sparta. When the Spartans prepared for battle, they polished their arms to glisten in the sun. They washed their clothes clean, combed their long black hair, and sang the song of battle. I have no doubt Mr. Murdaugh, if in the ranks, would have done the same. I make no doubt he would be the last to run. I make no doubt he would have been amongst the foremost to make his gleaming blade glisten in the sun. The highest evidence of a man's dexterity and intent to use his weapons is the high polish he gives them, and the high state of preservation in which he keeps them for use. Of Murdaugh's dexterity in the use of his knife in the work of death, we have unfortunately too much proof. Of his disposition to use it, we have the evidence of the high order in which he kept it for use, even to that state of Spartan polish which made it gleam in the candlelight, as the sword of the Spartan would glisten in the sun. We are told Meeks was determined for a fight, yet Oliver, whose friendship for these gentlemen seems of the most ardent and disinterested kind, gives up to Meeks his knife, after having so easily obtained possession of it on the small pretense of picking his nails. He had been invited by Oliver to drink at a saloon opposite the Galt House. They dignify these establishments nowadays by the high-sounding title of saloons, but when you enter one of them you find it the vilest groggery in the world. These dignified groggeries exist to a shameful extent in Louisville. And why? Because the politicians of Louisville are too busy with their unimportant bickerings, or too truckling to put them down. They are the strongholds of the voting interests of Louisville, and the truckling politicians who are ready to sacrifice every principle for the triumph of party court the coffee-house keepers and bend in supplication for their election to the inmates of the groggeries. Even the municipal government is either influenced by paltry mercenary motives in its avidity for the revenue of licenses, or it has not the nerve or public spirit to grapple with the monster. Talk of our Constitution being the greatest, the purest, and the most efficient on the face of the earth. Yet here is an evidence of its working in a duplicate government. The most destructive of vices, because the parent of most, is licensed, encouraged, fostered, pandered to by politicians, and through their truckling by the very local government itself, as if the misery and debasement of the community were more the end and aim of their rule than the encouragement of virtue, industry, sobriety, and rational enjoyment. We learn that Meeks was unknown to many, a slender, small, and weakly man, with a bit of a cowhide, the lash of which someone says was knotted. From what we learn of this cowhide, I verily believe it would take at least 500 knocks of it to kill a man, and I doubt if he could be well killed, after all, even with 500 knocks of it. Meeks, unfortunately for himself, stepped up to Murdaugh and said, quote, "Yes, you are the damned little rascal who did it." End quote. In reply to this, the very first lunge Murdaugh made at him severed a vital artery and caused his instant death. I am no physician, and know not technically what effect the cutting of that artery may have, but I believe it to be as deadly as if the brains were blown out or the heart pierced. A man stabbed through the heart no longer lives or breathes, but he may stand a minute. Meeks fell and, in attempting to resume his feet as he leaned on a chair, pitched forward upon his face, and when examined, he was dead. When did Rothwell strike Murdaugh? Not till Meeks was killed. Then, it is proven, Rothwell struck with a cane, and Murdaugh was beaten back. And at that instant the tide of battle rolled on to the right corner as you face the fire, and then Rothwell was seen losing his grip of the cane in his right hand, and he was seen endeavoring to resume his grasp of it. General Chambers thinks it was Dr. Wilkinson whom Rothwell was beating at in the right-hand corner, but everyone else says it was Murdaugh, and it is of course evident the general is mistaken. Every one of the witnesses swears that Rothwell was engaged with Murdaugh in the right-hand corner, while Holmes was engaged with Dr. Wilkinson in the left-hand corner. Let us now consider the wounds received by Rothwell. Dr. McDowell says the puncture in Rothwell's chest might be made with this knife carried by Murdaugh. The skin, by its elasticity, might yield without having an orifice as large as the blade, afterward apparent. Who gave Rothwell that wound? Why, Murdaugh, and nobody else. This accounts for Rothwell losing the grip of his stick or cane. The moment this knife penetrated his chest on the right side, that moment his arm became paralyzed, and he could not hold his cane. He caught at it, but he did not use it after. Just then Judge Wilkinson came up behind with his bowie knife in his hand, and General Chambers says he saw him make a lunge at Rothwell and stab him in the back. If two men are engaged in a fight, one with a dirk knife like this, and the other with a stick, in the name of God, let another with such a bowie knife as this stand off. But if he must interfere on behalf of him who has the deadly weapon, and against him who has not a deadly weapon, let him do the work of death front to front. Let him stab in the breast and not in the back. But to come up behind and to stab him in the back, who is already overmatched by his opponent in point of weapons, evinces a disposition which I shall not trust myself to dwell upon or to portray. Ossian, speaking of Kerbar's treachery, says, quote, Kerbar shrinks before Oscar's sword. He creeps in darkness behind a stone. He lifts the spear in secret. He pierces my Oscar's side. End quote. By this time, Dr. Wilkinson was down in the left-hand corner and Holmes over him. The fact is, Holmes was the only man that knocked the doctor up against Trabue, though Halbert boasted of having done it. It was only a boast in Halbert, for I believe he goes over his foughten fields more at the fireside than on the battleground. In the language of Dryden, speaking of Alexander, quote, the king grew vain, fought all his battles o'er again, and thrice he routed all his foes, and thrice he slew the slain. End quote. End of section 26, read by Martha Weller, Champaign, Illinois, June 13th, 2023. Section 27 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks, Kentucky, 1839, Part 12. March 16th. Mr. Hardin. Gentlemen of the jury, I would endeavor to resume the few remarks on the evidence which I offered yesterday as near the precise place where I left off as possible. If I did not know that in the present case such particularity is not so requisite as in the case cited by John Randolph, who once told of a man that was so precise that he could, if interrupted and called off in the middle of his dinner by the sound of a horn, on resuming his seat some hours after upon resounding the horn, take up his dinner exactly at the identical bite where he had left off. I am not quite so particular, and shall probably recapitulate some of the evidence I have already gone over. Yesterday evening I endeavored to give you the law and the facts of the case as nearly as possible as far as I went. I shall now repeat that you are not to take as facts all that may be sworn in a cause. Although witnesses may be men of undoubted integrity and veracity, yet all they state are not facts. They are fallible beings, and likely to misconceive and misinterpret facts without any intention of doing so. We are to ascertain the facts from the mass of evidence and judge of each witness's competency by contrasting his evidence with that of others. And when it agrees with all or the majority of witnesses, we may safely infer he is right. I endeavored yesterday to examine the facts that occurred at the tailor's shop, for the purpose of showing the ill blood fomented in these gentlemen's hearts against Reading. I then showed that they acted in concert, and provided themselves with what weapons they could, not being able to get all they wanted, and how, upon a small occasion, they were prepared to use these weapons. Indeed, there seems to be no witness as to what occurred when Judge Wilkinson remained in consultation with his companions in his bedroom. If Judge Wilkinson, Dr. Wilkinson, and Mr. Murdaugh were known to be frequenters of the bar before meal times, why has it not been proven by one of their witnesses? That not being proven, I have a right to assume that it could not be done, because it was not the fact. Next, I have to ask why these gentlemen came into the barroom provided with arms. Could it be with any other design than to run Reading out of the room? Were they going into a room where they commonly resorted? It is evident they were not. Did they go there on their way to supper? It is evident they did not, for supper was not near being ready. What disposition for eating supper merely does it show in Judge Wilkinson to pace the room 3 or 4 times and then fix the eye of destruction on Reading, while his purpose kindles and he grasps his bowie knife behind in his pocket? What more eagerness for supper does Murdaugh exhibit in going straight up to Reading, rattling like a viper and insulting him with being a liar? Sir, I care not if a man go into any crowd, and before an angry word is used to him, he goes up to as meek a man as Job himself, and says to him, "You are a damned liar or rascal," and flings open his blade to inflict mortal injury, as his words indicate. If the person so accosted strike his insulter, it is not surely any great wonder. And yet Reading did not strike a blow. Mr. Murdaugh may say, quote, "I kept within what I thought was the safe side of the law. I approached with my drawn knife, insulted the person to draw on the attack from him, that I might have some excuse for using my knife in the manner in which I came to use it at any rate." End quote. If any man come up and call you a damned liar or a rascal, and spring open his knife in the attitude of striking, should you strike or slay such an assailant, would you not be excusable? But Colonel Robertson attributes to an act of this kind nothing but a manifestation of innocence and high spirit. The colonel is really a gallant man, and judges of others by the fire and chivalry raging in his own breast. You must not laugh, gentlemen, for if you could look upon the volcanic mountain, though you would see its head capped with snow, you would find its bosom like his, rumbling with fire, smoke, and brimstone. In former times, the highest honor known to a Roman soldier was to have saved a man in battle, but here it is argued that if a young aspirant to fame pinks and kills his man, he is to be sent home to his parents in honor, crowned with the chaplets of victory. Nay, it is believed if Bonaparte in his youthful prime, in his Italian campaigns, had had Murdaugh by his side, he would have confided to his ready and unerring arm the execution of many a hardy adventure. Colonel Robertson may say what he pleases, but I say it was Murdaugh commenced the assault, and that all fighting done by him was in the wrong. All fighting done on his account was in the wrong, because he had commenced in the wrong. Well, gentlemen, as I remarked to you yesterday when I stopped, for I am now returned once more to that point, Murdaugh had given the first provocation, had killed his man, had stabbed another to the death, when Judge Wilkinson stepped up and gave Rothwell a stab in the back, while engaged with and probably receiving the stab in his chest from Murdaugh. Yes, gentlemen, a third man comes up and lunges this beautiful little weapon into Rothwell's side and starts back. Sir, if men are engaged with deadly weapons, part them if you can, but do not come up behind them and lunge a bowie knife into the vitals of one, and then come into a public court and demand of a jury not only to acquit you, but to do it with shouts of, "Glory, glory, go, go!" And yet, gentlemen, this is the polite invitation given to you by Mr. Prentice, to acquit such a man with acclamation. When engaged with a man who has only a cane no bigger than his thumb, his opponent gives that man a deadly stab in the chest, which paralyzes his arm. A third person, Judge Wilkinson, for instance, comes up behind and stabs the paralyzed man in the back. It is, no doubt, high time for you to be called upon to mark your approval of the deed by shouts of acclamation. Mr. Prentice, by way of winning your favor with complimentary allusions, thinks Kentucky should no longer be called the bloody ground, because the river Raisin has carried off the palm in feats of human butchery. But I think the Mississippi gentlemen of Vicksburg have bidden fair of late to obtain for that part of Louisiana opposite their city the palm of being the dark and bloody ground. I suppose in the far-famed Menifee duel with rifles, if someone had stepped up and lunged a bowie knife into the vitals of one of the combatants, the shouts of acclamation that would have arisen in that quarter of the world would have resounded to the uttermost ends of the earth. Dr. Wilkinson by this time became engaged with Holmes. Holmes is a stout and large man, but his size has been greatly exaggerated. Like the Patagonians, the first discoverers thought them 10 feet in height, the next voyagers only 8, and the next but 6. I recollect reading of Captain Smith that when he first explored the interior of this country, on his return he represented the inhabitants as all Goliaths, 6 cubits and a span in height. Yet subsequently, more matter-of-fact men found they were only miserable and cowering Indians of ordinary dimensions. In this manner appearances are magnified. We are asked why Holmes is not here. We echo to the other side, why Holmes is not here. Our answer is, because he was not to be had, being a pilot down the river, and not within the control of the state's attorney or any process issuing from him. Sir, among other appeals made to you for acquitting them, you are told, as a set-off, that there is no state in the Union on which you are more dependent than that of Mississippi. They take their cotton south and receive either through shipping agents or drafts direct their money for it from the merchants of Great Britain. True, Kentucky gets some of these dollars from the Mississippians for what they think better than their money or produce, or they would not buy it. We, in the rounds of trade, pay these dollars, or what represents them, to the Liverpool merchants for merchandise that we think better than the money. The Liverpool merchants, in the next turn of the wheel, pay the same dollars back to the Mississippians for their raw cotton, and the Mississippians are nothing loath to take our produce again for the same dollars. And after several twists of this kind, when we get them back and recognize one of them as an old acquaintance, we may say, quote, "How do you do, friend Dollar? I am very glad to see the face of an old acquaintance. Step into my pocket and warm yourself. I always give shelter to a traveling friend." End quote. We are proverbially a hospitable people, and never refuse a night's lodging to $1 or its liberty to travel further next day upon leaving us an equivalent for what we lent it. But to be serious, are we not all dependent on each other? I know this, and cannot admit that we owe more to Mississippi than Mississippi owes to Kentucky, and why there should in this case be made any parade about our indebtedness to that state, not founded in reality, is for you, gentlemen, to weigh. To resume the facts of this case, what does Judge Wilkinson do? He stabs Holmes in the arm, but he is not indicted for that. He stabs Rothwell when he is engaged with Murdaugh in the right-hand corner, and again when in the left-hand corner, standing over Holmes and trying to get him off his own brother. Rothwell had been disabled by 2 stabs. Judge Wilkinson, standing at the dining room door when Rothwell was saying nothing except in mercy trying to persuade Holmes to spare Dr. Wilkinson, comes across the room to the opposite door, finds Rothwell's back turned to him, and then makes the second thrust of his bowie knife into his victim's back. Robert Pope says, "I saw Rothwell's back to Judge Wilkinson when the judge stabbed him, up to the very handle. I ask you, gentlemen, I speak to you not in language other than the broad and naked truth. Is there any witness denies this?" Everyone who knows Robert Pope knows that he would not state what he did not know to be the fact. We know that each and all of these wounds contributed to Rothwell's death. The last stab is given by Judge Wilkinson to Rothwell. Dr. Wilkinson and Murdaugh retreat out into the passage and fight their way to the foot of the stairs. I care not what was done there. It was done after the offense previously committed. Suppose Oldham had shot one of them and not missed as he did. Suppose Murdaugh had been knocked down, and suppose Judge Wilkinson received blows in the passage. Does it lighten the offense previously committed? I care not what took place when a man has killed another. When making his escape, I care not how many guns are fired at him, how many rocks thrown, because it alters not his previous offense. If there is any evidence that anyone in the barroom laid a hand on Judge Wilkinson, who has proved it? Is it not plain that any bruises or injuries he did receive were received in the passage? Mr. Prentice said he was willing to stack arms with the Kentuckians. What arms had they? They had a cowhide whip. We hear of a cane, which he thinks may be conjured into a sword cane. Mr. Holmes, indeed, had his fists, but he could not stack them. We are told that Oldham had arms by a witness who viewed the scene from the outside of a window, like one of the venerable birds perched on a dry limb, eyeing the slaughter with a prospective instinct, one of those remarkable birds, renowned alike for their gravity and great stillness. We have heard a good deal said, and well said, if true, about Oldham, that he was unsteady, that he cast his eye to his counsel for relief. Yet we really saw nothing in his conduct to warrant his being called perjurer, scoundrel, coward, and rascal. And here I must remark that this very talented young gentleman, Mr. Prentice, in using such epithets to a witness without even a shadow of justness in the application, warranted me in saying that though I admired some passages in his speech, yet others I should feel bound to denounce as unworthy alike of his profession and of his character. No man in this state can boast a prouder ancestry than that very Oldham, whom it has been attempted to brand as odious and infamous. They have been among the earliest settlers and most esteemed of our citizens, trusted with command in our army, and venerated on the judicial bench. And has a man sprung from such an honored stock no pride in upholding his name, no feeling to rouse his indignation when epithets, as gross as they are groundless, are poured out to tarnish his reputation for the paltry purpose of influencing a jury to discredit his testimony and to warp their judgments from the straightforward path of truth and justice? What proof has Mr. Prentice to sustain the course he has taken? Sir, there is not a shade of proof. The gentleman is indebted to the fertility of his fancy, and his best friends must regret that he has not, in this instance, cultivated that productive soil for some more praiseworthy object than an ignoble and disgraceful crop of baneful, destructive, and loathsome weeds. Does the gentleman think he is one of the angels appointed to pour out the vials of wrath? Has he not indulged in pouring out gratuitously his vials of wrath on Mr. Redding, who could not escape? Redding is stigmatized as a murderer, to be haunted by the ghosts of the slain at his nightly couch. Yet what was his offense? He raised his arm to ward off the blow of an iron poker aimed at him by Judge Wilkinson. He had profaned a judge's person on this trifling provocation by seizing him, dragging him to the door, and turning him under. Quote, "Oh, you scoundrel," would Mr. Prentice exclaim. "Why did you do that?" End quote. He had retorted upon Judge Wilkinson when taunted by him about his profession, and worse than all, he did not, when the killing was going on, stay in some convenient place to be killed. Quote, "Why did you not, you coward, rascal, murderer, perjurer, and so forth, turn your back to be stabbed with safety? Why did you not stand up with your face to the breeze when the sirocco swept along, carrying death on its pinions? Why did you fall on your face and let the pestilential blast pass over you? Why did you not breathe till it was gone? You and your friends have offended us by your want of submission, and now you aggravate your offense by coming here to testify against us." End quote. Really, it is astonishing they are yet alive. But it will be more astonishing, perhaps, when it is told that they will return to Louisville and there stand in point of reputation just as they stood before these slanders were concocted, digested, and spewed upon them. It will turn out that they are yet unpolluted and unscathed. The same protecting providence which carried the Israelites through the Red Sea will protect even these persecuted and wronged few. Gentlemen, I have endeavored to trace facts as far as I have gone, with minuteness, and having presented these facts to you, it is for you to determine whether they do not establish these conclusions. When the fight occurred in the bar-room, it was brought on by these gentlemen intentionally. If they brought it on, did they fight in their own defense, or because they had drawn the conflict on themselves, could Meeks have inflicted death with a cowhide, or Rothwell with a walking stick, so as to render the killing of them necessary or justifiable according to the true spirit of the law? But here there is a proposition of law advanced by Mr. Prentice which I must combat. He says the law recognizes that the point of resistance unto death begins where a man himself believes the point of danger ought to be fixed. Then we have no law at all. We may burn up our law books. This revokes all that they contain on the subject of homicide. There are two men engaged in a quarrel, one as brave as Caesar, the other as timid as a hare. One kills the other when the quarrel has arrived at a certain point. The brave man, if he were a Marshal Ney in courage, is to be hanged, because he had no fear of his life when he killed his adversary. If the timid man is the survivor, he is to be acquitted with acclamation, because of his cowardice, which made him imagine danger where there was none. Thus cowardice and rashness are to be rewarded and cherished, and bravery and forbearance punished with an ignominious death. Is it possible you, an intelligent jury, can be imposed upon by such sophistry? Is there so low an estimate of your understandings as to suppose it? I knew what I should have to combat the moment I saw the hack driving into town with a head peeping out of the window, which head I knew belonged to the shoulders of a certain gentleman from Mississippi. When I was in Vicksburg, I asked a gentleman how it was that Mr. Prentice defended so successfully so many notorious murderers who really merited the gallows. "Oh," said he has hit upon a principle which he calls law, that charms every jury to which it is addressed." I asked the gentleman to repeat the magic words to me. He did so. It was the very principle I have been combating. It is possible that as the gentleman afflicted with this chronic principle, which he belches up with so much advantage to himself and relief to others, is now in the neighborhood of medical springs, esteemed so potent by Mississippians, he may resuscitate by a few drinks of the charming water, a sophism which I have shown to be no longer tenable by anyone who values what is healthy and sound above that which is merely delusive. Sir, the principle of self-defense does not warrant a man in killing under the name of self-defense, if he is himself in fault by being the aggressor. Is the principle of self-defense among nations to be carried into effect as justly applicable to the right of self-defense among individuals? In national controversy, The law of nations, an imaginary code of mutual convenience, is referred to according to the custom of the country. But in a conflict between individuals, there is a defined law which must be the redresser. A nation with right and justice on her side may be conquered by another nation in the wrong, and cannot sue for or obtain redress from the wrongdoer. But an individual in a community may be wronged by another and can obtain redress because he has the law common to both and a superior power to appeal to. Therefore, there can be no dependent analogy between the laws of nations and the laws of individual communities. There was some crude idea thrown out yesterday that the laws of Great Britain ought not to be enforced here. We are not to be told at this day that we have any other common law than that derived from the common law of England. The very principles of our statutory laws are dictated by the genius of English common and statutory law, with the exception of such local differences as require local application of principles. If the gentleman could take from us the right to apply the law of England where it would be in point for us, we could, by reciprocity, deprive them of any they might most rely upon. I shall now advert to the peculiar necessity enforced upon us of becoming a law-abiding people if we preserve any regard for our present form of government and constitution. In empires, monarchies, and kingly governments, armies are formed to keep the people in order. But in a republic, what could preserve the social compact but the law? The moment you dissolve or dispense with the law, that moment you dissolve all national constitution. Every government, and most especially a republican government, is bound to protect each citizen in his property, reputation, and life. How can a republican government do it but by and through the law rigidly and justly administered? Whenever you dispense with the law, you allow men to arm themselves and to become their own avengers, independent of and above all law. When they are not only permitted to do so, but to return home as innocent men, what is the effect? Every man will arm himself, and like the turbulent and licensed armed mobs at the fall of the Roman Republic, brutal violence will reign instead of law. All government will be dissolved, and anarchy and confusion will pave the way to usurpation and tyranny. You must venerate the law if you would not see such a state of things. If you do not, A and B will arm themselves, like the Turk, up to the throat and kill whom they please out of mere wantonness and sport. If you go into the northern states, it is a rare thing if you can find a man in 10,000 with a deadly weapon on his person. Go into other states that shall be nameless, and you will hear of them as often as of corn shuckings in an Indian summer. Go further south, to Arkansas or Mississippi, for instance, and though you would be a peaceable man, shuddering at the name of a toothpick in the north, in these states you may arm yourself to the teeth and track your steps in blood with impunity. Why is this, but from the relaxation of the laws that are elsewhere enforced and obeyed? I was down the river lately, and it was pointed out to me where the Black Hawk had blown up and killed her scores, to another place where the General Brown had blown up and killed her hundreds, to one spot on the shore where two gentlemen blew each other's brains out with rifles, to another where the widow somebody's overseer was butchered, to another where the keeper of a wood yard was shot for asking pay for his wood, to another where an aged gentleman had his guts ripped out for protecting his slave from cruel treatment. "Great God!" cried I at last. Take me back to where there is more law, though less money." For I could not stand the horrid recital any longer, when every jutting point or retiring bend bore the landmark of assassination and irresponsible murder. Why does the law call for punishment? Surely it is not in vengeance for the past, but to deter others from the too frequent and free use of deadly weapons, whether in Kentucky, Louisiana, Mississippi, or Arkansas. Is it to be left to the vitiated taste of the brutal few to give tone to the mind of a community in setting up the code of the bowie knife against the common law? It was but the other day that in the legislature of Arkansas, a member on the floor was a little disorderly, and the speaker, to keep quietness, stepped down, brandishing his bowie knife to silence the ardor of the unruly member, which he did effectually, for of all the ways in the world of putting down a young and aspiring politician whose tongue will keep wagging in spite of his teeth, your bowie knife is, I admit, the most effectual. And the speaker on this occasion, bent upon having silence, silenced the offender, not only then, but for all time to come. To be sure, he went through the form of a court of inquiry, but a life is only a small matter there, and he was acquitted according to the laws of that state. Coming events cast their shadows before, and here we have one symptom of that downfall of our own glorious republic, which has been so often predicted, but which has been reserved for the present generation to consummate. The symptom is to be found in the flash of those deadly weapons carried about and used with such unerring fatality by our legislative sages and judicial dignitaries. As if the next should come from high places, too, we have a fatal symptom of our downfall, furnished by the corruption of those in office, who share in, or connive at the grossest defalcation, the widest system of public plunder, even in our monetary defalcations, ever known in any government. Why should we deceive ourselves with the vain hope that our republic will boast greater permanency than that of Rome, when we are fast falling into the very track, step by step, which leads to the precipice over which she plunged headlong, that once magnificent mistress of the world marched up the hill of fame and glory with irresistible strides, till she reached the summit and looked around upon the 100 nations in her rule. But at last, satiated with prosperity, she began to repose supinely upon her laurels, and she permitted herself gradually to relax that discipline and good order which had been to her not only her shield and buckler, but her bond of union. The people were permitted to fight in twos and threes at first with impunity. They became accustomed to it, and then fought without interruption in gangs. By and by, mobs fought with mobs, and finally the whole people became arrayed against each other in regular armies, till they had to retire to the plains of Pharsalia, where the doom of the greatest republic the world had ever known was sealed forever. Are we not relaxing the laws, which leads to anarchy and from personal violence to popular usurpation? Are we not relaxing our financial vigilance, which leads to corruption at the fountainhead, and from private peculation to public defalcation? Is there no symptom in all this of a great crisis? I tell you again and again, when you can lay your hands on great delinquents, make them an example. When you can grasp great defaulters, punish them. Then will you more easily check pernicious discords, and restore to its proper tension and tone the harmonizing power of your laws and your government. Whenever you see men wearing bowie knives and daggers, hunt them down as you would bears and their cubs, from whom you can expect nothing but injury. The whole state of Kentucky looks to you this day for justice, for this is an awful investigation concerning the loss of 2 of her citizens. 2 of our fellow citizens have been murdered, and these gentlemen are here to answer for it. Some of the best blood of the country has been spilled, as if in the pen of slaughtered hogs, but because the relatives of one of these butchered men employ counsel to aid the prosecution in developing the truth and guarding against the delusions of sophistry from the greatest array of talent the country can boast, or that wealth unbounded can procure, to elude the punishment due to the offended laws, you are told to take but a one-sided view of the evidence, and to decide at any rate against the paid advocate. I have not asked these gentlemen what they are to be paid for eluding justice, because I did not consider that a sort of evidence which ought to influence your verdict. Gentlemen, one question is, are we to tolerate this bowie knife system under the false pretense of self-defense? I say, let your verdict act like the axe laid to the root of the tree, and many a prayer will bless you for your timely check of its growth. Many a woman is made a mourning widow, many a child made a pitiable orphan, and many a father childless by the use of this accursed weapon. You have it in your power to prevent the recurrence of such scenes. We have had an exhibition here in miniature of those Roman scenes which prepared the public mind for the downfall of that great people. There was a vast amphitheater where the Roman people could be crowded together, and in the presence of some 100,000 persons of both sexes, a man would be brought into the arena, and a ferocious tiger turned in upon him. He might or he might not possess skill or courage to meet the formidable beast and evade the deadly spring. But if not so fortunate, when the tearing of his vitals was seen and the crunching of his bones heard, the solitary shriek of the victim's wife, as it arose upon the air, would instantly be drowned by the acclamations and thunders of applause bestowed upon the ferocious beast, prolonged by its renewed efforts to suck the blood, tear the flesh, and grind the bones of its prey. As we have no amphitheater, a hall of justice is made to answer for a miniature arena, and as we cannot have tigers, nor men who will submit to be their victims, we have forensic gladiators and witnesses whose private feelings and characters may be wounded, lacerated, and tortured to the infinite delight and encouraging shouts and plaudits of a fashionable auditory, while the victim is helpless and gloomy in his unmerited prostration. Yes, it is all for the amusement of enlightened minds, and it is intended, perhaps, for the edification of the rising generation. But, I protest, I cannot yet perceive that it is any more for the honor of the applauders than it is necessary for the good of the country, that these gentlemen should be honored and glorified for their dexterity in the use of the bowie knife and dirk. In the time of public danger or foreign invasion, is it these bowie knife gentry, these pistol men in private life, that mount the breach and face the danger? Are they the brother Jonathans that face John Bull and eye him and his scarlet coats with defiance? Where are they then? Why, like the gnats and mosquitoes, who glisten in the sunshine and the calm, but when the storm rages and the thunder growls and the lightning flashes and the earth is rocked to its center, they are stowed away from the danger, though they are sure to emerge from their hiding place to annoy with their stings when the succeeding calm and sunshine invite them out once more. Brave men may be voluptuous and effeminate in private life, but in the hour of danger they put on a new nature. But these fighters in time of peace clothe themselves in the skin of the lamb in time of war. Sardanapalus, who sat all the while with his women and eunuchs in times of peace, spinning and knitting, and telling long stories, no doubt, and sometimes wearing petticoats to make himself more effeminate, when conspired against by Balasis and Arsaces, gave up his voluptuousness, and at the head of his army gained 3 renowned battles, and though beaten and besieged at last in the city of Ninus, to disappoint his enemies, burned himself, his eunuchs, and his concubines with his palace and all his treasures. Alexander the Great, who was kind, courteous, familiar, and confiding with his officers in private life, when leading the Macedonians, moved to battle like a pillar of fire, irresistible in his might. When the great Frederick led on his brave Prussians, they fought and fell and fought and fell as long as any were left. And thus men imbibe the spirit of their chief. If led by a brave man, they are brave. If led by a coward, they are poltroons. And if led by the bowie knife and pistol gentry, I make no doubt they would be either assassins or nothing better than mosquitoes, to be dispersed by the very first report of the cannon. Even at home, in our own rural districts, we see the influence of leading men on whole neighborhoods. Let a virtuous and enlightened man, whom all will look up to as a pattern, settle in your neighborhood, and every one will partake of his good influence. Why was it that Nelson, in his death, did more for the glory of his country than ever he did in his life? Because he ascended to heaven in the arms of victory, like Elijah, who tasted not of death. Let us never dream of selecting for our leaders or our examples those who have so little moral courage as to trust to bowie knives and pistols for the preservation of their manhood, instead of to their blameless conduct in peace and bravery in war. Gentlemen, I beg of you in the name of Him who sits upon the cloud and rides upon the storm, mete out the measure of justice to these men, and vindicate the honor of Mercer County. But do not stigmatize your county by doing, as Mr. Prentice would have you to do, by shouting, "Glory, glory, go ye righteous! Go to your homes in honor and in innocence." Whatever you may do, I shall content myself with the conviction that in my professional capacity I, at least, have done my duty. I have been deputed by the widowed mother of the murdered Rothwell, and at the instance of his mourning sisters, to implore your justice. I have closed my mission. Between you and your country, between you and your God, I leave their cause. End of section 27, read by Martha Weller, Champaign, Illinois, June 15, 2023. Section 28 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1, by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks, Kentucky, 1839, Part 13. Mr. Rowan, I solicit your already jaded patience. I will not say for a short time, for I know not how long it may employ me to make the appropriate comments upon the facts, the law, and the arguments of counsel in this case. I will promise you, however, not to be unnecessarily tedious. I have, in the patience and attention you have already displayed, a pledge that you will bear with me for at least a moderate length of time. My unfortunate clients, confiding alike in their own conscious innocence and your intelligence and unbiased state of feeling, were willing that you might have decided their case without argument, but their will did not prevail. The Commonwealth's attorney, Mr. Bullock, in whom I am proud to find the son of honored parents whose friendship I enjoyed in days past, has evinced an entire competency to the duties of the station with which he has been recently honored, and which permit me to say he honors by the commendable candor and high talents with which he performs his official duties. I regret that I cannot speak in the same commendatory terms of the candor of his aged and very highly talented adjunct. That gentleman represents the vengeful feelings of the very near relations of the ill-fated Rothwell and Meeks, by whom he has been employed to convict, if possible, the accused. He has just closed a philippic of 4 hours against them, as remarkable for vigor of intellect as for vehemence and impassioned zeal. He implores you, with great earnestness, to check, by a verdict of conviction in this case, the habit of wearing arms, and especially bowie knives, which has, as he says, latterly so much prevailed and multiplied assassinations throughout our country. He considers the frequency of these melancholy incidents as infallible evidence of the growing degeneracy of public morals, indicating the rapid decline and eventual subversion of our free institutions. It is the corruption of the people, he tells you, that saps the foundation of a free government, and he refers to the history of Greece and Rome to confirm and illustrate his doctrine. He asserts that he is set, and that all good men ought to set their faces against the degeneracy of the times. Gentlemen of the jury, I concur with him in the belief that corruption is the great destroyer of free governments, but do not believe with him that its prevalence is so alarmingly evinced by the incidents to which he has so glowingly referred. While corruption displays itself upon the surface only of the body politic, it is, like boils on the surface of the natural body, but an evidence of the exertion of the recuperative energies to throw off the puissant matter. The right of the people to carry arms is little less than identic with their freedom. Without arms, they cannot vindicate their freedom. Without the right to possess and wear them, they will very soon be without the spirit to use them, even in defense of their liberty. I feel no apprehension for the liberty of my country from that source. I fear nothing from the carrying of bowie knives. Brave men do not fear them, and cowards seldom use them. It is wrong to reason against the use of any good thing from its occasional or even frequent misuse. While our institutions are pure, and especially our courts of justice, we have nothing to fear. They will vindicate the just use and punish the misuse of bowie knives or any other arms which our free citizens may choose to wear. But I can refer him to an instance of the growing degeneracy of morals, more recent and greatly more alarming than any or than all the instances he has named. The recent instance to which I allude, of the alarming degeneracy in the public mind and morals, is the composure and even complacency with which we have listed in the Temple of Justice to the mercenary ebullitions and sanguinary efforts of the gentleman himself. It is in proof that he has received from Mr. Redding, the brother-in-law of the unfortunate Rothwell, a fee of $1,000 to convict, if possible, the accused. He has not appeared in this case as the Commonwealth's attorney, nor under any appointment by the government, but as hired counsel, hired too by the incensed witness Redding, upon whose testimony mainly it was hoped and desired by both to produce the conviction and ignominious death of the accused. Gentlemen of the jury, bear with me a few moments while I also attempt to repress corruption by denying it the right of access to the forum and to the sanctuary of justice. Let me tear from its face the elusive and imposing mask under which it hopes to win its way to your favor and exert a bad influence upon your judgment and your feelings. I shall attempt to convince you that his appearance in this case, against the accused, is in contravention of the law of the land and the moral sentiment of all civilized communities, reprobated as well by the social sympathies of our hearts as by the precepts of our holy religion. And first, of the legality of the gentleman's posture in this case. Our Constitution guarantees to every man a fair and impartial trial by a jury of his peers, and proclaims that no man can be deprived of his life, liberty, or property unless by the judgment of his peers or the law of the land. By the law of the land we understand as well the protective as the punitory laws of our code. The punitory part relates to offenses and their punishment. The guilty are punished, and the innocent are protected. In ascertaining and punishing guilt, the laws are construed and applied to the case of the accused by the functionaries of the government. In the making of laws, there are no hired legislators. They are all elected by the people. So, in the enforcing of the laws, there are no hired prosecutors, judges, jurors, or sheriffs. I mean hired by individuals. They are all appointed and paid by the government. The machinery of judicial proceedings is altogether official. The agents are all official. There is no clubbing of official powers with that of any other individual to bear down, oppress, or destroy another individual. The government, instead of assisting individuals to oppress, restrains them from oppressing each other. The government acts toward every man upon the presumption that he is innocent until his guilt be ascertained by official agency according to the laws of the land. This presumption, that every man is innocent until his guilt be fairly and legally proven, is the most essential element in the corporate structure of civil society, one without which its parts could not cohere nor exist for a single day. It is not only the cement, but the very basis of the civil union. It is the postulate without which the jurist, the moralist, and the divine would plead, write, or preach in vain. Without this presumption, war, anarchy, and rapine would usurp the places of law, order, and justice. Upon it the whole fabric of civil society stands poised, widening out like an inverted cone until it embrace those morals and manners and those sympathies and charities of the heart, together with those radiations of mind, which embellish and sweeten human life. It is a presumption which no man can contravene without poisoning the fountains of human happiness, and thereby proclaiming himself an enemy to mankind. This principle is necessary, not only in the nascent state of society as its basis, but in every moment of its existence, in every act of its progress. Neither law, morals, nor religion could live without it. In consonance with this great principle, the officers of the government all proceed in reference to the accused. He stands in the box, shielded as with the fabled aegis of Minerva, by this presumption, until his guilt is proven beyond a reasonable doubt and fairly proved. The Commonwealth's attorney, the judge, the sheriffs act upon it. Their oaths for official fidelity require them to do so. They have no motives to act otherwise. They represent the Commonwealth, and she is as much bound to protect the innocent as to punish the guilty. It gives me pleasure to say that the Commonwealth's attorney, Mr. Bullock, has discharged his duty fairly, faithfully, and ably. He has acted upon the presumption, which I have been urging, that the accused should be considered innocent throughout the whole progress of their trial, and until its conclusion should evince the contrary. The distinguished counsel, who represents the avenger of blood in this case, has, with his usual ability and with somewhat unusual zeal, displayed great devotion to the interests and inclinations of his client. He was bound by his undertaking to have the accused convicted and executed unless they should be able to prove themselves innocent. His duty and his energies were to destroy them, guilty or innocent. The duty of the Commonwealth's attorney was to suppose them innocent until their guilt should be ascertained. The duty of the former gentleman was to suppose them guilty until their innocence should be evinced by a verdict of acquittal. The gentlemen drew, as you will perceive, their motives from directly opposite sources. They acted from different motives, and have thereby subjected the accused to a crossfire throughout the whole proceeding, and such must always be the case when hired counsel are permitted to appear against the accused. The appearance of the gentleman in this case violates the rights of the accused, and especially their great right to be presumed innocent, and profanes the sacredness of the temple of justice, and all the sacred usages and forms of proceeding. It corrupts the streams of justice in their very fountains. It introduces and consecrates the sanguinary and long-exploded claims of the next of kin to the slain. Gentlemen of the jury, according to the rude and barbarous usage of man in his aboriginal state, the next of kin had a right to kill the slayer of his father, brother, etc., without regard to the character of the occasion, without inquiring whether it had been inflicted justifiably, excusably, by misfortune, or of malignant design. This practice prevailed even in our day among the Indians of North America, and perhaps still prevails in many of their tribes. It crept into the codes of many semi-civilized nations as they advanced from barbarism. To weed out this vengeful and sanguinary principle, and to protect all but deliberate murders from its impassioned and baneful effects, the great lawgiver of the Jews directed a competent number of cities of refuge to be erected and so distributed throughout Judea as to yield to the unfortunate homicide the requisite security from the next of kin to the slain. The same principle insinuated itself into the Code of England, but as she has advanced in civilization, she wisely and humanely tamed and rendered it harmless in the shape of a civil action, denominated an appeal of murder, which she permitted the next of kin to institute against the homicide, and she humanely encumbered the action with such technicalities and subjected it to such delays in its progress as rendered it harmless to the accused, by affording time for the subsidence of the bad passions of the avenger, while she, in the meantime, proceeded to give the accused a fair and impartial trial by a jury of his peers. But in the appearance and efforts of the hired counsel in criminal cases, we behold the reappearance of that odious and exploded principle in a more aggravated form than it was ever displayed among the barbarians, the Jews, or the Anglo-Saxons. With them, the unfortunate homicide had to fear only the aroused passion of the avenger. It would subside. It might possibly be mitigated or appeased. At most, none but the next of kin was to be dreaded. None other dare act. But where counsel are hired by the accused, when his vengeance is at its highest, and it is always in that state of feeling that he employs counsel, his feelings are transferred into those of counsel and set, to use a figure from dying, more or less unfadingly by the size or quantum of the fee. There the accused had the passion of revenge only to fear. Here he was to encounter that passion combined with the passion of avarice, the most sordid of our nature. But if the avenger might lawfully employ the talented gentleman who represents him, and not the Commonwealth, in that case, might he not have employed any given number of our most distinguished lawyers and advocates, and at once overwhelm the accused by their combined talents, eloquence, and weight of character? The limits of his vengeful efforts are not to be found in the law, but in his purse. The security of the accused is no longer to be found in the laws and the institutions of the government, but in his own wealth and the poverty of the avenger. Guilt or innocence upon this principle is to be decided not by the constitution and laws of the land, but by the comparative wealth or poverty of the avenger and the accused. And thus, instead of appealing to heaven for a decision of guilt or innocence, as in the days of yore in the trial by battle between the avenger and the accused, we shall have the question decided by a conflict of their purses. And thus our beautiful system of criminal jurisprudence will be so subverted and degraded that the liberty and life of the accused will depend not upon his innocence, but whether he or the avenger can bid highest, the one to preserve and the other destroy it by the instrumentality of hired lawyers, who, in competition with each other for employment, will be seen hovering about the avenger and the accused, ready to be employed by either, and soliciting employment from both, regardless of the merits of the case, and regardful only of the amount of the fee which may be obtained. Gentlemen, I leave you to contemplate the moral degradation, the widespread corruption, which would follow the practice if it were to prevail, which I am resisting as unfair and unlawful. The venerable gentleman has told you that he and myself practiced law together and abreast for nearly half a century. It is true, and for the first 25 years of that period, he, like myself, declined all applications to appear against the lives of our fellow men. His first departure from that course was, as he tells us, in the case of the Commonwealth versus Smith, charged with the killing of Dr. Brown. That was a long time ago, and I am sorry to tell you that he has been at it ever since, and seems determined to keep at it. I take much pleasure and feel some pride in being able to say that I never have taken a fee or appeared as a lawyer against the life or liberty of my fellow man, and that no amount of fee could, at any period of my life, have tempted me to do so. I refused a fee of $1,000 to do so when I was not worth that many cents. Apart from its being unfair and unlawful, as I verily believe it to be, I do, and always have, reprobated the practice because of its tendency to indurate the heart and deprave the moral feeling. But I am now contending that it is unlawful, and further to illustrate this point, let me suppose that Redding had given to the judge, the Commonwealth's attorney, and the sheriff, and even to you, gentlemen of the jury, the $1,000 which he has given to his talented lawyer in this case. I beg pardon of the judge, the Commonwealth's attorney, the sheriff, and of you, gentlemen, for the supposition. I make it only for the argument, to animate them, as he would term it, in the just performance of their official duties. To the sheriff, that he might summon an impartial jury, who would convict the accused. To the judge, to decide most justly and impartially against the accused every question of law which might arise in the progress of the case. To the Commonwealth's attorney, that he might invert the presumption of law as to the innocence of the accused, and urge with ardor and zeal their conviction. And to the jury, that they might evince their love of justice by promptly rendering a verdict of conviction. What would be the public opinion of such conduct in reference to him and those officers who had received his money? Would not all mankind reprobate it, and fasten shame and degradation upon all concerned in a transaction so corrupt? They certainly would, but let us inquire why they would do so. Would it not be because of the influence of the money upon the fate of the accused? The mere passage of $1,000, or 10 times that sum, by transmission, from one hand or pocket to another is, in itself, and apart from its effect and influence, a matter entirely immaterial and indifferent. It is then not in its naked matter-of-fact aspect, but in the effect and influence of those matters of fact, that the public reprobated. The odious effect of money so distributed consists in the pollution which it inflicts upon the pure streams of justice, to the prejudice of the accused. The pith of its effect is in its unfairness toward them. Now, if the trial of the accused can only be fair, when all the proceedings against them are legal, and all the actings official, apart and free from all force but that of the law, and all motives to action but those of official duty, and if they are entitled by the Constitution to a fair and impartial trial, we can be at no loss to see why the effect or influence of money exerted against the accused should be deprecated by them and reprobated by all honest men. Money, therefore, cannot be given by the avenger to the Commonwealth's attorney, nor to any of the judicial officers, because of its unfair influence against the accused. Now, what is the difference in point of effect, that is, fairness and impartiality, between giving the $1,000 to the Commonwealth's attorney and giving it to the very talented and very experienced lawyer to whom it was given and to whom you have listened for more than 4 hours? By giving that sum to the former, its effect, under the odious denomination of corruption, would have been let into the prosecution. By giving it to the latter, its effect, aggravated by an alien and unofficial volume of mind united with experience, sagacity, and weight of character, has been brought into the case, and their condition thereby rendered worse than if the $1,000 had been given by Reading to the Commonwealth's attorney. It is, gentlemen, in the contemplation of sober reason, unfair, and therefore unlawful, that the effect and influence of this $1,000 should be thrown into the scales against them. It is corruption to an undefined extent. I say undefined extent because though we can ascertain the amount of the money, we cannot ascertain precisely the degree of unfairness it produces. But as any, the least degree of it, is excluded by the laws of criminal procedure, we can, with confidence, say that the influence of the $1,000 fee most gratuitously and sagaciously exerted by the hired lawyer against the accused is palpably unfair. There is, gentlemen of the jury, in the human heart an inherent love of fairness, which, when unbiased by passion, it is sure to display whenever occasions for its display are presented. It pervades all ranks and grades of mankind. It is evinced in all their settled modes of contest. When a fight occurs among the multitude, you will hear the exclamation of "Fair play" from the mouths of all who are not engaged in it, and very many in every crowd are ready to maintain fairness at all hazards. Hence the popular apothegm, "Fair play is a jewel." Pugilism and dueling have their rules of fair play. The sports of the people, as well as their fights, have some settled rules of fairness, and even war between nations has its laws of fairness. These rules of fairness are legibly and indelibly written upon the human heart, and we perceive them intuitively. We feel their force in every fiber of our frame, in every pulsation our blood. They are venerated everywhere, and in reference to every subject. End of section 28, read by Martha Weller, Champaign, Illinois, June 16, 2023. Section 29 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1, by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks, Kentucky, 1839, Part 14. Gentlemen of the jury, to give you some idea of the degree in which this principle was cherished by our rude ancestors, when the accused had a right to wage battle with his accuser, let me refer you to the rules of fairness by which the combat was regulated and conducted, and mark that even in this mode of trial, the accused was presumed to be innocent until convicted, that is, until vanquished by the accuser. You will find the rules to which I allude in the second volume of Montesquieu's Spirit of Laws, commencing at page 201, but I shall read only 2 or 3 of the rules from page 203. Quote, "Before the combat, the magistrates ordered 3 banns to be published. By the first, the relations of the parties were commanded to retire. By the second, the people were warned to be silent. And the third prohibited the giving of any assistance to either of the parties under severe penalties, nay, even on pain of death, if by this assistance either of the parties should happen to be vanquished." End quote. Observe, gentlemen, that the relations were to retire. Do you ask me why? Surely, lest influenced by the feelings of kindred ties, some of them might assist their relative, and therein violate the principles of fairness. The crowd were to be silent. Why silent? Lest by their hisses or their plaudits they might animate the one or depress the other, or exert a distracting influence upon either. Now let me ask you, does the attitude of the gentleman and his $1,000 power exerted against the accused quadrate with this rule? What rule of fairness, within the verge of human conception, justifies his position here, and his exertions against them? Does he know how much the assistance given by him to the accuser may conduce to the vanquishment of the accused? Does he feel conscious that if by this assistance of the Commonwealth, the accusing party, he shall conduce to the conviction of the other party, he incurs, under the spirit of this last rule, the penalty of death? Gentlemen of the jury, such was the mode, and such the principles of fairness observed by our ancestors in trying such a case as the one in which we are now engaged, a mode upon which we look back with reprobation, but our reprobation of it is greatly mitigated by the luster of the moral jewelry which lingers about it. And think you, gentlemen of the jury, that the wise and more civilized statesmen and jurists who rejected that barbarous mode of trial and substituted the mode which we are now pursuing, rejected with it those principles of fairness which constituted all that was attractive and valuable about it? Think you that they interred the jewelry with the body of the defunct mode? No, gentlemen, they transferred those jewels to our code. Their splendor gilds and sets off its symmetry. It is that very splendor which is now being dimmed, that symmetry which is now being marred, by the unfairness of the mercenary and unauthorized efforts of the representative of the avenger of blood. By the theory of criminal trial with us, the accused are placed in the custody of the law, protected from all extraneous force, and subjected only to that of its own power, exerted through its own responsible and unprejudiced official agents, throughout every stage of the proceeding, from the inception of the trial to its finale. Even after conviction and sentence pronounced, the execution must be done by the proper officer and in the manner prescribed by law. If the proper officer vary the manner prescribed, as by hanging one sentenced to be beheaded, or by beheading one sentenced to be hanged, he is guilty of murder. And if one that is not an officer execute the culprit, even according to the manner prescribed in the sentence, he is guilty of murder. Strange that a man ascertained to be guilty and doomed to death should be protected by the law from all unofficial assaults, and that the same law should allow the life of a man presumed to be innocent to be assailed by the hired representative of the avenger of blood, even in the very temple of justice. By our Constitution and laws, the accused are allowed to defend themselves against official assailment, and even furnished with the means of doing so. They shall be heard by their counsel, and if they are unable to employ counsel, counsel shall be assigned them by the court. They shall be confronted by the witnesses against them. They shall have compulsory process to compel the attendance of witnesses in their behalf. The jury, the judge, the sheriff, and the Commonwealth's attorney shall be unbiased. All shall be unbiased. And yet the hired counsel of the avenger, and he alone, is to be irresponsible, and may aim his poisoned arrows with impunity, nay, lawfully as he would have it, at the hearts of the accused. He is to be the only licensed homicide in the whole judicial coterie. He alone among all in the courthouse may, per fas aut nefas, kill the accused if he can with impunity. Can the law, I would ask you, gentlemen of the jury, license such a procedure against the accused? Ought it to do so? Would it be fair that it should? No, gentlemen, no. It neither is nor ought to be the law. It is a vicious and foul excrescence, which, like mistletoe upon the oak, deforms and distempers the trunk upon which it fastens itself. It is an erroneous notion that when a man has a license to practice law, he may annoy and harass whom he pleases in his professional character. No man has a right in virtue of his law license to harass one man by assailing him with even a civil suit in the name of another without a warrant of attorney from that other. Then let me ask the gentleman, where is his warrant of attorney to prosecute in this case? He has no authority from the government, which alone could give it. The commission of the Commonwealth's attorney is his authority to prosecute, but the gentleman has no authority whatever. The judge cannot give it. He can confer the power only in the absence of the Commonwealth's attorney, and then only according to the provisions of the Act of Assembly in that case provided. But if he could confer the power, he cannot decently appoint a man who had taken a fee of $1,000 to convict the accused, if possible, guilty or innocent. He would be bound in honor to appoint some disinterested gentleman of the profession, whose weight of character would be a pledge to the accused and to the community that he would conduct the prosecution fairly and justly. Now I ask if it be reasonable to suppose that the law which denies to the licensed lawyer the bad privilege of annoying his neighbor in a civil action without warrant of attorney from the plaintiff would allow him without a warrant of attorney from the government or from any authoritative power whatever to obtrude himself into a prosecution and exert all the powers of his mind, not merely to annoy or harass, but to destroy the life of the accused? Can it be believed that the law would guard the citizens so scrupulously in reference to their property against the avarice of the bar and leave their lives a prey to that cormorant passion? There is no statutory inhibition against such a course by a hired lawyer against the life of his fellows, and only because the inhibition was to be found in the statutes penned by the finger of heaven upon the human heart. The legislature could not suppose that gentlemen of the bar would give in to a practice so obviously contrary to the laws of nature, a practice reprobated alike by the unvitiated feelings of the human heart and the spirit of Christianity. Grotius, after having commended nations for giving commissions to their national vessels, authorizing them to destroy pirates, commends also the practice of appointing by commission prosecutors of crime, quote, when not any one who has a mind to it is allowed to be a prosecutor, but only some particular men who are appointed by public authority. That so, no man may contribute toward the effusion of his neighbor's blood, but only he who is obliged to it by his office. Agreeable to this is that canon of the Council of Elibus, quote, if any believer be an informer, and another by his information be either proscribed or put to death, we have thought fit to forbid him the sacrament, even to the last. End quote. Gentlemen of the jury, comment upon this passage is unnecessary. It speaks the language of humanity as well as of Christianity. Its import applies to the prosecution of the life of one man by another, who has no commission from his government to do so. Here the talented gentleman who is hired to prosecute pretends to no such authority. The circumstance that the accused are strangers from a sister state should, if nothing else could, have restrained him. Gentlemen, the word stranger addresses the ear of every generous and benevolent man, and more especially of every Christian, in a tone of peculiar emphasis. It is a word of consecrated import, consecrated by the founder of our most holy religion. He enjoined upon all his followers sympathy for and courtesy towards strangers. Quote, "I was a stranger, and ye took me not in," end quote, etc. Gentlemen of the jury, I set out with telling you that it was in the first place unlawful for a lawyer to appear for money against the life of his fellow man, and second, that it was immoral for him to do so. I have been laboring, and I hope not without effect, to prove the first point, namely, the unlawfulness of the act. I have, to some extent, in discussing it, anticipated the second. But it was unavoidable, for the laws are rules of moral duty, though they do not embrace defense, and enforce the imperfect obligations of morality, such as charity, benevolence, gratitude, etc. They enjoin only the duties of perfect obligation. I contend that the counsel who is now hired to convict his fellow men in a capital case violates in the very act of being so hired all the imperfect obligations of morality, and if his efforts produce conviction, he violates the most important of all the rules of perfect moral obligation. Quote, "Thou shalt not commit murder," end quote, is the rule to which I allude. And I urge that there are more modes than one of committing that crime. A man's life may be destroyed by false swearing, or by erroneous and impassioned pleading, as well as by the stiletto, and the man who deliberately destroys life by false swearing or by erroneous and impassioned pleading is not less guilty at the bar of conscience than the man who deliberately perpetrated the same deed by the dagger. The accused are prosecuted for murder. Suppose them to be innocent, and suppose that by the efforts of the hired counsel they shall be convicted and executed. Would he not be guilty, in a moral point of view, and at the bar of conscience, of the very crime he had imputed to them? You must answer in the affirmative, and he, but for the illusion into which he seems to have fallen upon this subject, would be constrained to answer, as David did to the prophet, quote, "That man is surely guilty," end quote, etc. And might it not, in the words of Nathan, be replied, quote, "Thou art the man," end quote. I wish I could disenchant and redeem his mind from the illusion in which the sorceries of avarice have enthralled it. I wish I could convince him and the few among our lawyers who, influenced by his example, and the example of one or two other lawyers of distinction, have been seduced into the practice of receiving fees to assail the lives of their fellow men. But I almost despair. The habit with him has become too inveterate. Yet in the hope of restraining the younger members of the bar from a practice which detracts so much from their professional, and according to my notion, so much degrades their personal character, I will pursue the subject, for it is in this view mainly that I have devoted so much attention to it. I will not deny, however, that I had the further view of endeavoring to convince you, gentlemen of the jury, that you ought to distinguish between the efforts of Mr. Bullock, the accredited organ of the government, and those of the gentleman who has, influenced by a $1,000 fee, obtruded himself into this prosecution, and to regard those of the one as a stream emanating from the pure fountain of public justice, but a little discolored by the excitement from which even official posture is unable to redeem our frail nature. Those of the other as a turbid and muddy stream of large volume emanating from the fetid marshes of exuberant avarice, betraying its source by the noxious effluvia which it emits in its course. The one as the fountain of health and of life to the innocent, the other as the bohan upas, destroying indiscriminately by its poisonous breath all whom chance or accident shall have thrown within its grasp. But dropping the figurative, let me discuss further, in plain prose, the moral position of the lawyer who appears for fee against the life of his fellow man. He is employed to devote all his talents and attainments to the destruction of the accused. That is the object at which the avenger of blood aims. To achieve that object, he gives the $1,000. For that sum, the lawyer engages to take the life of the accused, if by the weight of his character and force of his talents he can possibly do it. If the death of the accused could have been effected justly by the operation of the laws and the agency of the public functionaries, then the $1,000 would not have been given. The purpose of the avenger would have been attained without so large an expenditure on his part. It was then to destroy the accused, guilty or innocent, that the counsel was engaged. The engagement must have been either to convict or acquit the accused. But the avenger would not have given $1,000 to procure their acquittal. It must then have been given to destroy them, to take their lives, and it must have been received by the lawyer to effect the purpose for which it was given, namely, to take the lives of the accused, or to convict them, which is identical with taking their lives. Gentlemen of the jury, if this is the fair conclusion, and I feel so sure that it cannot be resisted, then I would ask you, I would ask casuists, I would even ask the venerable and distinguished lawyer himself, to tell me what is the difference of the moral guilt between taking a man's life for his money and taking money to take his life. I declare solemnly that if there be a difference in the moral guilt, I have not brains to comprehend or perceive that difference. I can readily perceive that in reference to the exterior aspect of the two cases, the former would seem to have the advantage of the latter, in the fact that with it are associated a boldness and daring of which the latter is entirely destitute. The highwayman, in taking the life of another for his money, hazards his own life. He may himself be slain, and if he should not, he may be apprehended, convicted, and expire on the gallows. He incurs the hazard of all these events. There is in chivalry a charm, a fascination, I had almost said a witchery, which gilds and to some small extent mitigates crime itself. But in the latter case, there is no one mitigating, not one redeeming trait. The hired lawyer knows before he contracts to take the lives of the accused that they are not only without arms, but bound hand and foot by the cords of the law, aye, and dumb too. He has nothing to fear from them. He has but to compound with his own conscience, and without any hazard whatever, fall to work upon his victims. But still it would seem to me that the heart of the lawyer thus engaged must become strangely callous to enable him to proceed in the work of death with the levity and sportiveness with which it has been conducted in this case. And yet the gentleman tells us, and quotes Burns in affirmation of the sentiment, that, quote, "the heart is I, the part I, that is right or wrong," end quote. Does the gentleman expect us to take as a facsimile of a right heart the feelings and sentiments which he has displayed throughout the management of this case? It is not by such sentiments and feelings that the Scottish bard illustrates his conception of a heart that's right. Let me refer the gentleman to the following delicious morceau upon the subject of the heart from the same poet. Quote, "The sacred lowe of weel-placed love, luxuriously indulged, but never tempt the illicit rove, though nothing should divulge it. I waive the quantum of the sin, the hazard of concealing, but it hardens all within, and petrifies the feeling." End quote. Here we see how the heart is hardened and the feelings petrified by indulging a passion less sordid than avarice. Burns thus shows how the heart may be rendered wrong. Let me refer the gentleman to another poet who, like Burns, ministered at the altar of nature. He thus instructs us how to keep the heart a right eye. Quote, "Be thine the feeling of the mind that wakes at honors, friendship's call, benevolence that unconfined extends her liberal hand to all. By sympathy's untutored voice, he taught her social laws to keep. Rejoice, if human heart rejoice, and weep if human eye shall weep. Who feels for others' woes shall feel each selfish sorrow less. His breast, who happiness bestows, reflected happiness shall bless." End quote. Which gentleman of the jury is the right heart, the one displayed by the lawyer who permits himself to be employed to degrade and destroy the accused, or the one portrayed and recommended by the poet just quoted? I will not insult you by affecting not to know what your answer will be, or rather what it is. I should ask your pardon for having asked you the question. The precepts of the poets of nature, like those of the gospel, in reference to the feelings of the heart, are but principles of fitness resulting from the nature of man and his social relations. Human life is at best but a tissue of hopes and fears, of cross purposes and inquietudes, of alternated sickness and health, of sorrows and joys, and the reciprocation of kind offices and sympathies of the heart by men in their social condition alleviate the sorrows, mitigate the woes, and increase and heighten the joys of each. Man is not a solitary animal. He cannot live alone. His organic bias and natural aptitudes are all social. But with them all, without the fine sensibilities of the heart, society would be a curse to him, for without them there would be no conscience, and without conscience there could be no virtue, and without virtue there could be no happiness. Hence those who permit inordinate avarice, or the extreme of any other passion, to petrify their hearts and harden their feelings, are warring with the purposes of nature, in reference to the social condition of man, man's long state of infantile imbecility and helplessness, and his dependence, during all that time, upon the sympathies of the heart for existence and sustenance, indicate the high estimate which nature places upon them. Infancy is the period of the heart's pupillage in the divine science of sympathy. Our first lessons are received in the nursery. They fall from the lips of maternal affection upon our infant hearts, as gently as the dews of heaven descend upon the tender grass. It is thus the virtues are planted in the heart, and take root, and grow in its sensibilities. It is here, in the nursery, that valor, too, the associate and protector of his sister virtues, germinates and unfolds its nascent energies. Stern and vigorous, bold and daring as it becomes, it is like the other virtues, the offspring of weak but lovely woman. By a wise arrangement of nature, the ladies are made to grow and to admire it, because they constantly need its protecting influence. They respect it in their husbands and cultivate it in their sons. The little boy, but just emerged from his cradle into his first pantaloons, while he listens to the tale of female distress or injured innocence from the lips of his fond mother, feels the germ of valor glow in his bosom, and distends his little chest, and while she tells him that the fair damsel was rescued from brutal violence by some chivalrous knight, struts across the floor in steps of measured pride, and pants to be a man, that he also may signalize himself by deeds of valor and benignity. The mother rejoices to see in the flashing eyes of her lovely boy the scintillations of his father's spirit, a spirit in the full and protecting radiance of which, and the blessing of heaven, She and her little ones have thus far rested securely. Gentlemen of the jury, it is thus the heart is trained, and its sympathies and feelings schooled in each successive generation to the performance of the social duties and the practice of the virtues. Yes, gentlemen, it is from the physical weakness of women that man derives his moral strength. And shall her lessons be set at naught and contemned with impunity? Will not the gentlemen who receive money to destroy the lives of their fellow men be signally rebuked by public sentiment? Will not the ladies take cognizance of the subject and place their withering veto upon a practice so repugnant to all their feelings and inculcations? The venerable gentleman has humorously, wittily, and even prettily protested against a change of venue in this case. From the jury to the assemblage of beauty, taste, and intelligence, with which this trial is honored, and the bench of the judge adorned, and assigns as a reason for this protest, first, that the venue has been once changed and cannot be changed again, and secondly, that he would not be at home before that fair tribunal by reason of the want, on his part, of imposing personal presence and the aptitudes, manners, and attractions suited to such an assemblage. This little sally on his part was intended for the ladies, and designed to divert their attention from the repulsive posture which he occupied, and to conceal its moral deformity from their view. I tell the ladies that every question involving morals belongs in an emphatic manner to them. Let the law of the case be decided as it may by courts of law. The morale of it must, directly or indirectly, be finally settled by their tribunal in its appellate character. But I have occupied too much of your attention upon this preliminary point, and perhaps have been too divergent and diffusive in the discussion of it. But impressed as I am with its importance to the profession of the law and to the community, I could not pretermit it. What I have said is not in any spirit of unkindness toward the venerable and very talented gentleman who has been employed by the avenger against the lives of the accused. I have no unkind feeling toward him. I claim no right to rebuke him personally. I have no motive to do so, but I have a right to reprobate the practice, and I regret I cannot do it in the abstract. My observations are intended to be applied not to him personally, but to the practice personified by him. It is true, and pity it is 'tis true, that he is not the only distinguished lawyer in the Union who has permitted himself to be employed against the lives of his fellow men. A few, and I am glad to say very few, others have lent the sanction of their talents and weight of character to this odious and inhuman practice. I feel concerned that it should be put down, and regret that our courts have permitted it. The judge should denounce it as unlawful and unfair, and refuse to permit it. The prosecuting attorney should feel himself disparaged by any attempt to associate with him a lawyer hired, not to represent the government, but the revengeful spirit of the avenger of blood. He should feel that he is the organ of the law, ministering at the altar of justice, and to maintain the sanctity of his position and his own competency, he should exclaim to the mercenary representatives of the avenger, quote, "Procul, o procul estate profani," end quote. And such, I am sure, would have been the course of the prosecuting attorney in this instance, had he not felt restrained by that diffidence which is inseparable from youthful talents in the inception of its official course. But let me tell that young gentleman that the competency which he has displayed in the management of this case will leave him without apology or excuse should he, hereafter, submit to the like intrusion. End of section 29, read by Martha Weller, Champaign, Illinois, June 16th, 2023. Section 30 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials Volume 1 by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks, Kentucky, 1839, Part 15. Gentlemen of the jury, you must have perceived that I commenced with the topic with which Mr. Hardin closed. He would have you convict and sacrifice the accused for the purpose of putting down, if for nothing else, the practice of wearing bowie knives, and thereby checking the torrent of corruption which, as he would have you believe, emanates from that practice and threatens the subversion of our free institutions. I would have you believe that the practice of taking money to take the lives of his fellow men in our courts of justice, as he does professionally, is greatly more unseemly and corrupting in its tendencies than that of wearing bowie knives, that the latter is a matter of constitutional right, while the former violates the Constitution and laws of the land and every precept of Christian morals. You have heard us both, and will judge between us. What I have said, however, upon this point is intended by me rather as a kind of non-cupative legacy to the junior members of the bar, many of whom are attending this trial, and are the sons of my old friends, than for your consideration as jurors in this case. I would say to them that their license to practice law invests them with no powers to violate the social duties, that by becoming lawyers they have not ceased to be men, that the high and honorable profession which they have chosen imposes upon them increased obligations to cherish and promote those feelings of the heart upon which the virtues, and of course the happiness of mankind, so generally depend, that every political community consists of an indefinite number of domiciliary communities, the number of which are united to each other by the ties of affection, not simulated, but natural, emanating from the heart. The relations of the members of the political body are artificial, that the artificial ought not, indeed, cannot absorb or extinguish the natural. In the family circle, the virtues and charities which exalt, embellish, and adorn our nature are reared under the fostering care of maternal kindness, moistened and bedewed from the sacred font of the maternal storage, as I have already told you, that in their sacred domiciliary circles the hearts of all are reciprocally united to that of each other, by ties which, though of gossamer texture, are stronger than hempen cords, and that whenever a citizen is destroyed, a husband, a father, a son, or a brother is torn from this family cluster by a disruption of all the ligaments which bound their hearts together, that the heart of each bleeds with agony, and that of the mother is broken. Now, if there is any meaning in the divine precept, "Do unto others as you would that they should do unto you," how can any lawyer who is a husband, father, son, or brother, and every lawyer must come under some one or other of these denominations, reconcile it to himself to take a fee to take the life of a man sustaining the relations I have mentioned, and thus incur not only the moral guilt of homicide, but with it that of inflicting in many instances widowhood and orphanage, and agony of feeling in every instance upon some circle of domiciliary affection? For every man, I repeat, belongs to a circle of that kind. I would say, therefore, in conclusion upon this point, to every junior of the profession, touch not, handle not the price of such complicated cruelty. Degrade not your profession, harden not your feelings by an act so revolting and remorseless. I will not, gentlemen of the jury, apologize to you for having detained you upon this preliminary point so long, a point not involved in the cause you are sworn to try, but yet, as I think, of sufficient importance to the community to plead in its importance my excuse for the time I have directed to it. The question in issue, and the only question, is, were the accused placed under the necessity, by the conduct of the unfortunate Rothwell, Meeks, and others, of taking the lives of those two misguided men in defense of their own? Gentlemen, the moment the testimony was closed on the part of the Commonwealth, I perceived distinctly from your countenances that you had even upon that ex parte and adverse testimony decided the question in favor of the accused. I have perceived also that up to the moment when I rose to address you, your decision remained unshaken, unaltered, and therefore it was that I lingered so long at the threshold of the real subject of your inquiry. My clients, I know, would excuse me. They felt no apprehension. They had obtained all they desired, an enlightened and impartial jury. Their acquittal, they knew, would follow, of course. But if the case had needed the utmost and the ablest discussion, they saw and heard the efforts in their behalf of my friend Colonel Robertson, an aged, experienced, and talented lawyer, of young Mr. Thompson, whose display in this case may be considered by his friends as a pleasing presage and sure pledge of his future professional eminence. And they must have been delighted, as you and I, and all around us were, with the sunshine luster shed upon the law and facts of this case by the transcendent genius of their friend and fellow Mississippian, Mr. Prentice. I must, however, more because it is expected of me than needed by the case, retouch some of the topics which they analyzed so well and discussed so ably. But I do it with my intellectual vision dimmed by the reflected light of the genius which has beamed upon them, as our ocular vision is sometimes blinded for a time by the strongly reflected rays of the sun. Indeed, were it not that Mr. Hardin, of whose posture in this prosecution I have discoursed you, has given some distorted views of the testimony and the facts, and in some degree misconstrued, as I think, the law, I would not have said a word to you upon the main subject, believing, as I have already told you, that your verdict had been long since virtually formed in their favor, and that so far as speaking might be thought necessary, more had been said and better said than anything I could say. Gentlemen of the jury, let me, before I make any comments, exhibit a condensed view of the leading facts of the case. They are that Judge Wilkinson, with his two friends, was at the Galt House in Louisville on his way to Bardstown to marry Miss Crozier, an accomplished young lady of that place, whose affection and consent he had previously won. The day fixed for the marriage was the Tuesday next succeeding the day of the catastrophe which gave rise to this prosecution. His brother, Dr. Wilkinson, and his young friend, Mr. Murdaugh, had come with him as friends on this occasion, and they remained in Louisville a few days to replenish and fit their wardrobe for it, in the doing of which they became acquainted with the witness, Mr. Redding, a tailor of that place. He made a coat for the doctor. It did not fit him. A dispute arose between him and Judge Wilkinson. Upon that subject some blows were exchanged. They separated. The judge, his brother, and friend went to their lodgings at the Galt House. This happened about 4:00 p.m. on the day of the catastrophe. Redding was much enraged at what he supposed was the ill treatment he had received from the judge, who had snatched up a poker and aimed a blow at his head with it, which, as he warded it off, took effect without hurt or injury of any kind upon his arm. Redding went to the mayor's office to obtain process against the three, for the doctor and Murdaugh had, during the scuffle between him and the judge, drawn their Spanish knives. The clerk of the court told him that he could not issue process until furnished with their names. He promised the clerk that he would get the names and return. He and his unfortunate brother-in-law, Rothwell, went together in the evening about dark, or a little before, to the bar-room of the Galt House, to obtain the names, as he says, of the Mississippians. Having obtained them upon a slip of paper from Mr. Everett, he remained in the bar-room for some 15 or 20 minutes, when Judge Wilkinson entered, whereupon Redding accosted him by asking him if he was not the man or gentleman who had struck him with a poker, and commenced abusing him in a most vituperative manner, calling him rascal, liar, scoundrel, coward, poor pitiful Mississippi judge, and stating that he could whip them all three if they would lay aside their weapons and go into a room or the street. The judge replied only that he would have nothing to do with a man of his profession, that if he laid his hand upon him, he would kill him, and after listening for some time, as he walked backward and forward across the room, to the foul abuse of Redding, retired, accompanied by Mr. Everett, to his own room on the second floor. After remaining in his room for about 15 minutes, they came down into the bar-room to be in readiness for supper, which was nearly ready. When the judge retired, Redding exclaimed, "The damn coward has fled!" And when the judge returned to the bar-room with the doctor and Murdaugh on their way to supper, Redding, having retired during the judge's absence, immediately entered the bar-room after them, and exclaimed in a high voice, "They are all three here now," and accosted Murdaugh, saying, "You are the gentleman who drew the knife, or a bowie knife, upon me at my shop today." Murdaugh replied, "Whoever says I drew a bowie knife upon you is a damned liar," and displayed in his right hand a white-handled Spanish dirk knife, telling him to stand off, and swearing that he would kill the first man that laid his hands upon him. Whereupon Meeks seized the wrist of his knife hand, exclaiming, "You are the damned little rascal," striking him over the head with the butt end of a cowhide, when several persons rushed up, and Rothwell struck him over the head with a hickory club, and cut his head badly. Murdaugh took the knife into his left hand, and stabbed with it at Meeks, who retreated, striking Murdaugh with the cowhide. Murdaugh stuck to Meeks, although stricken and pressed by others, until his right hand, extricated from the grasp of Meeks, had gained the knife, and with it he gave the fatal stab to Meeks. During this time Dr. Wilkinson was knocked down and beaten by Holmes and others, almost to a jelly. Judge Wilkinson had also been struck and stabbed with a narrow blade knife or a sword cane, which some one of the friends of Redding used on the occasion. While the doctor lay helpless and nearly lifeless on the floor in another part of the room, Rothwell joined those who were beating him, and commenced upon him with his hickory club. While beating him, the judge, to relieve or rather save his brother, stabbed Rothwell with a bowie knife in 2 places, one stab in the side, and the other more towards his back than front. He also, with the same knife, stabbed Holmes through the arm. The judge, having relieved his brother, retreated, keeping him and Murdaugh before him, through the passage and upstairs to his room, keeping between the mob and them, and protecting them and himself by brandishing his bowie knife. They were pursued to the staircase, and struck with chairs, and as they ascended, shot at by Oldham. Redding disappeared as soon as the affray commenced, and was not seen until it closed. The accused were unknown to any of those who assaulted them, had never seen nor conversed with any of them. The friends of Redding, who had, all except Rothwell, who accompanied Redding, dropped in at the Galt House seasonably, were Holmes, Halbert, Oldham, Johnson, Meeks, etc. The first 5 were among the stoutest men in the valley of the Mississippi. Redding was armed with a dirk, which he had borrowed on that evening on his way to the Galt House. Rothwell had a large seasoned hickory stick. Oldham had a loaded pistol and bowie knife. Meeks a cowhide with a knot tied upon the small end of it, and a Spanish knife. The knife, however, was surrendered to Oliver, his friend, before the onset. After Judge Wilkinson had left Redding and retired to his room, these men assembled in the passage, and Rothwell proposed that they should go up to the judge's room, take out the damned rascals, and give them hell. Mr. Everett, one of the proprietors of the house, left the bar in which he was when the rush was made by these men upon the Mississippians, which was instantly upon the enunciation by Redding that they were all 3 present, under the full conviction that a scene was to ensue, which he had no inclination to witness. Gentlemen of the jury, these are leading facts which have been proved in the case. I have omitted many incidental and subordinate facts to avoid consuming your time by a tedious repetition. They have all been stated with accuracy and commented upon with ability by my associate predecessors in the defense. End of Section 30, read by Martha Weller, Champaign, Illinois, June 19, 2023. Section 31 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1, by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks, Kentucky, 1839, Part 16. Now we allege, first, that there was a regularly formed concertation between Redding and his associates to beat and degrade the defendants, if not to destroy them. And secondly, whether such conspiracy had or had not been formed, the accused were placed under the necessity, by the conduct of Rothwell and Meeks, of destroying them, to save their own lives, and so were justifiable by the law of nature and the laws of the land in doing the acts with which they are charged in these indictments. And, gentlemen, first of the conspiracy. You find that Redding was much enraged by the affair at his shop, that he was further inflamed by Johnson the butcher, who spoke to him of the insult he had received in aggravated terms, vaunted of his own manhood by declaring that he was as good a piece of stuff as ever was wrapped up in so much hide, and declared that they would get Bill Holmes and his party and give them the devil. Redding at the instant declined the proposal, but declared that he would have satisfaction. He and Johnson left the shop and went together to the mayor's office, when Redding applied for process and promised to return with their names and obtain the process. Here Johnson and Redding separated. The latter went by the shop of his brother-in-law, the unfortunate Rothwell, took him along with him, and returned, by what route we cannot know exactly, to his own shop, which is but a short distance from the Galt house. Where Johnson went we do not know. The next place we meet with him is at the head of the market house, in company with Bill Holmes, Halbert, etc. The same coterie is afterwards, late in the evening, seen on Main Street, near the Galt house. These men are all at the Galt house, and unite in making the attack upon the Mississippians. Now, gentlemen of the jury, weigh these facts, ponder upon them, and ask yourselves if they could all be the result of accident. Mark that Redding declared that he would have satisfaction. Johnson and Meeks urged him to it, and prescribed the mode, which was ultimately adopted to get Bill Holmes and his party and drub or lynch them. Did Redding pursue the plan of obtaining satisfaction which he had proposed? Did he, when Everett gave him the names of the Mississippians, return to the mayor's office as he had promised the clerk? On the contrary, did he not linger at the bar until Judge Wilkinson came in, which was some time, and after he had seen the judge and vented his venom upon him, did he then, after the judge had retired to his room, return to the clerk and sue out the process in furtherance of his ostensible purpose? No, gentlemen, and why did he not? Evidently because either his proposition to seek satisfaction at law was a mere pretense to cover the conspiracy proposed by Johnson, namely, to get Bill Holmes and his party and give them hell, or if he was sincere in his proposition, he was led to abandon it and adopt that of Johnson. That it was his primary or ultimate design cannot be doubted, for Bill Holmes and his party were there and united with Redding and his party in making the onset. Meeks, Johnson, and Rothwell were of Redding's party. How came they all to meet at the Galt house that evening, and about the same time of evening, and what is remarkable, animated by the same spirit, a spirit of hostility toward the Mississippians? How came they all to understand the watchword pronounced by Redding upon their entering the barroom? For you remember that the moment they entered, he exclaimed, quote, "They are all three here now," end quote. And instantly the rush was made. Mark, gentlemen, their malicious design was against the Mississippians, and they were three. The words all, three, and now are to be construed in reference to the interview which had taken place between the judge and Redding about 15 minutes before. Then there was but one. The three are here now. Their vengeance would not be slaked. Their purpose to punish and degrade all would not have been accomplished by action then, but now, as they are all three present, their purpose may be effected. Mark, too, gentlemen of the jury, that Redding was the only man of the conspiracy who knew the Mississippians personally. They had conspired to act upon the men who had insulted Redding, but they did not know them. Redding did. No other man in the house could have given the signal but Redding. They alone of all the men in the house could understand the signal. How could they understand it unless by previous concert? Their condition is certainly a very unenviable one. The lawless conspiracy which they formed to destroy the accused resulted in the death of 2 of the co-conspirators, and to avoid the imputation of the moral guilt of the murder of their friends, they are obliged to deny the conspiracy, upon oath, notwithstanding they cannot flatter themselves that there is in existence one honest man who can believe them. Alas for the frailty of human nature! There is, gentlemen, fortunately for the interests and happiness of mankind, an impress upon truth which we discern, as it were, by intuition. Man is a rational being. He acts from motive, and when he aims at any end, whether good or bad, he selects and adapts the means to the end. The means to be suitable must be homogeneous. Otherwise, instead of promoting his design, they will neutralize their force by antagonism and fail in their efficiency. A good purpose is promoted by good means, a bad purpose by bad means. Here we may learn the purpose of the agent from the complexion of the means he has employed to achieve it, and hence we can ascertain the character of the means from the known character of the purpose. Therefore, when a witness swears positively against the inference which every rational mind would draw from established or known facts, he is not to be believed. The known or established facts cannot lie. When those facts consist of acts done by men, as the agents were rational, we can infer their motives from their acts, and if the acts were simultaneous and concurrent, by agents living remote from each other and pursuing different avocations, we must infer that they agreed or concerted to act together and at the same time, though they should all swear positively to the contrary. In the moral, as in the physical world, homogeneous matter alone coalesces. Now, it was quite unnatural that Bill Holmes should have left his beat and with his party gone to the Galt House to beat and degrade 3 Mississippians who had never wronged him in word or deed, whom he did not know, and of whom he had never heard. It was equally so in relation to all the others except Redding, who alone knew them, and had, or supposed he had, cause of complaint against them. Holmes and the others must, therefore, have been informed of the grievance of Redding, and must have agreed upon the time, place, and manner of avenging it, by their joint agency. Therefore, what the 2 witnesses have sworn is negatived by the unvarying laws of nature as displayed in the agency of man. What they have deposed upon this matter not only lacks the congruity and symmetry of truth, but is stamped with the unglossed impress of a vile and execrable counterfeit. Yes, gentlemen, if every man concerned in that nefarious transaction were to swear that there was no concert, no conspiracy, they would not, under the state of facts disclosed in this case, they could not be believed. Gentlemen of the jury, is it reasonable to suppose that these 3 gentlemen, strangers from a distant state, one of them to be married within 4 or 5 days, would form a conspiracy to assault some 8 or 10 giant Kentuckians? They have been proved to be intelligent, well-bred gentlemen, of pacific habits. One of them has been a judge of the Superior Court in the state of his residence, and, of course, a conservator, not a breaker of the peace, and a member of the legislature, and to be now a commissioner appointed by his state to negotiate for her alone in Europe. I repeat the question, is it reasonable to suppose that such men, under any circumstances, and especially under such as I have named, would form such a conspiracy? Gentlemen, when the excitement was raging in Louisville upon this unhappy subject, I asked Mr. Coleman Daniel, a very respectable, honest, and wealthy mechanic of that city, if he also was excited against the strangers. He replied, quote, "No, sir, it would be hard to persuade me that an intelligent gentleman, who had come all the way from the state of Mississippi to this state to be married, would, upon the eve of his marriage, of choice, and without a necessity for it, get into such a scrape." End quote. Your answer will be like this. You will say with him that no man of common sense, and still less a well-bred gentleman, would willingly present himself at the altar of Hymen with his eyes blackened and his face lacerated and bruised. When a man is about to be married, his mind is far otherwise disposed. His feelings are joyous and pacific, attuned by his prospects to purposes of happiness, harmony, and peace, not to jars, tumults, and broils. Virtue enlarges her empire in his soul by presenting new topics of thought and new subjects of aspiration. He feels that his nature is undergoing an ameliorating process, and anticipates from the event to which his heart is devoted 10,000 felicities, all of which will perhaps never be realized, but I am too old to recollect much about this matter. I will barely say that the anticipated pleasures of the lover are not realized only because they are too sublimated for the matter-of-fact condition of even the happiest state of matrimonial life, and the matrimonial is the only happy condition of life. It cannot therefore be believed for a moment that Judge Wilkinson would sacrifice all his prospects of matrimonial bliss to a scheme so wild, so visionary, so sanguinary, and so impracticable. The very nature of such a conspiracy as Mr. Hardin ascribes to the three Mississippians is too absurd to be entertained seriously by even that gentleman himself. He, notwithstanding, still persists in urging it upon you, and as an additional proof of it, he urges their having chosen to pass through the bar-room to supper. Here, gentlemen, Mr. Hardin expatiated at great length upon the structure of the Galt House, its public and private ways, its highways and byways, its dining and supping, as well as its culinary regulations, and especially called your attention to a private entrance into the dining room through which the judge, the doctor, and Murdaugh might have passed to supper in safety, and would, as he contends, have done so if they had not formed a conspiracy in their room before they left it to kill Rothwell and Meeks, etc. He does not seem to understand the principle upon which mobs are formed, that it is a principle of cowardice which aims to effect its bad purpose without hazard or exposure to personal danger. It confides in numbers for security, and therefore all mobs are of several against one or of many against a few. A mob of one against several is a solecism, and a mob of 3 against a dozen is equally absurd, and in this case the absurdity is aggravated by the consideration that the 3 men were of frail physical structure and entire strangers. Again, such a combination must have had for its principle of cohesion and action the most determined courage in each, and of course must have been a natural affinity between brave spirits for the purpose, not of assault, but of mutual defense. Mr. Hardin's conspiracy is destitute of all the essential ingredients necessary to its formation. It is without soul and body both. There was neither cowardice nor number there. The elements of such an existence as he fancies were absent. Gentlemen, I repeat emphatically that cowardice is the element and basis of all deliberate mobs, that they originate in and emanate from a principle of cowardice. Hence, brave men, as members of a mob or conspiracy, not relying upon their own firm spirits, but infected by the principle of their union, play the dastard, and hence the man who shall be assailed by a mob must, if he hopes to escape its danger, meet and defy it. He must, to save his life, expose it. He must beard and conquer the danger. He need not hope to soothe it by addressing its reason. It has none. It is all passion, and passion never listens to reason. An appeal to its magnanimity would be equally unavailing. It is a coward and has no generosity or magnanimity. Flight inspirits it and increases the danger. I repeat, then, that his only hope is in defying it. I speak, gentlemen, not only from observation through life, but from experience in the early part of my life. Now, what is to be rationally inferred from the facts upon which Mr. Hardin relies as the basis of his concluding argument in favor of his alleged conspiracy? Why, evidently that the judge and his two friends had strong reasons to believe that a mob had assembled in the bar room to assault, abuse, and degrade, if not destroy them. What were they to do? Were they to take counsel from fear and remain in their room supperless, or slip down the stairs quietly and silently and creep to supper through the private door to the dining room, of which Mr. Hardin speaks, or say to themselves and each other, quote, "We will arm ourselves with pistols, if we can get them, and if we cannot get pistols, we will arm ourselves with the knives which we have worn in traveling, and we will go to our supper as usual and by the usual way, the way pointed out to strangers by the index upon the door." End quote. What less could they say? What less ought they to have said? What other course could they have taken and retained their own self-respect and the respect of honorable men? There is no proof that they knew of this private access to the supper table, even if they had been capable of skulking through it. Mr. Hardin may have known it, for he tells you that he spends half his time at that house, and it would seem from the very detailed account he has given of the culinary and table regulations that his powers of explanation have been whetted by his gastronomic impulses. But I will suppose, for the sake of argument, that they knew of this private way and door to the supper room. What then? Had they not a right to go along the public way, to enter the supper room by the public door? And if they had a right to do so, you cannot infer criminality from the exercise of their right. But, gentlemen, I contend that they could not, as men of honor, under these circumstances, have gone to supper by any other way. When Judge Wilkinson left the bar-room only 15 minutes before, Redding exclaimed, quote, "See, the damned coward has fled." End quote. What would have been said by Redding and his co-conspirators if they had remained in their room or glided stealthily from it to the supper-room by the private way? What would the community have said, and more particularly the people of Mississippi? How could they have returned to their own state? And which is of more importance than all other considerations, what would their own consciences have said to them? The reproaches of their fellow men they could avoid, to some extent, by retirement and seclusion. But they could have no refuge from themselves. But, gentlemen, there was another obligation stronger, if possible, than all I have mentioned, upon Judge Wilkinson, to take the course through the bar-room to the public door of the supper-room. It is in proof that he was to be married on the Tuesday following to a beautiful and accomplished young lady. Could he, if he had skulked, have dared to present himself to her and to her venerable mother, the widow of a gentleman of known gallantry, and the sister of General Hines, who is the pink of valor, whose fame is identified with that of Jackson, ADR, and the other heroes of the victory at New Orleans, and next in splendor of fame to the two I have named? I repeat, how could he have dared to form a marriage connection with such a lady and such a family? If, having acted otherwise than he did act, he had dared to present himself, he would have been rejected with scorn and contempt. I speak from long and intimate acquaintance with the family. Gentlemen, had he hesitated, and I am proud to believe he did not, all these considerations would have presented themselves to his mind, and his soul would have rebuked him for his hesitancy. There was but one course for them to pursue. There was but one sentiment which could animate them. That course was the pathway of honor. That sentiment is, with them and all honorable men, that others are as much bound to fear and avoid as we them. There can be, no obligation on one man to fear another. Men politically equal, equals in right and duties, ought not in the moral, as equals in the natural world, cannot control or detrude each other from their positions, and therefore, Equals ought not to fear each other. Conscious of this, a sensible man will not annoy another, and a brave man will not submit to annoyance. This sentiment is very pithily inculcated by Fingal upon his grandson Oscar. Quote, "Never search thou for battle, my son, nor shun it when it comes." End quote. Gentlemen, can you think of a consideration which would have, I will not say justified, palliated the conduct of Judge Wilkinson and his friends, had they acted conformably to the philosophy of Mr. Hardin? This part, and indeed every part of the case, I would very willingly submit to the decision of the ladies. They admire men who can protect them, and of course detest cowards. It is, as I have said in another part of the case, their high prerogative to give law to the world upon the subject of character. They ordained in the infancy of the world that valor was the sine qua non of excellence in the character of man. That ordinance has continued, and will continue unreversed till the end of time. To that ordinance in all its import, the accused conformed throughout the complicated scene we have been examining. Away, then, with the rules of action which Mr. Hardin has been prescribing for the accused under the circumstances of this case. They had learned other lessons. They consulted nature and obeyed her oracular responses. They had been taught to assert and vindicate their own rights, while they scrupulously observed the rights of others, and abstained from violating them, that they could not consistently with self-respect be deterred from exercising their own rights more than they could consistently with honor and honesty violate the rights of others. These responses of nature were embodied in the ordinance which I have just told you was enacted by the ladies in olden time, or rather when time was very young. Conformably to that ordinance, the accused came as they had usually done, to their supper, through the bar-room. They acted as I have no doubt they agreed or conspired, if Mr. Hardin likes the word, to do before they left the room. That was to meddle with nobody, but to defend themselves to the utmost against any and every assault that might be made upon them. And, gentlemen, they meddled with nobody. They assailed nobody, but they were assailed, and they did defend themselves bravely, nobly, efficiently. I might here ask why those men remained so long in the bar-room if there was no concert among them to make the assault which was so nobly arrested. But upon the subject of the conspiracy I have said enough, perhaps too much. Gentlemen, Mr. Hardin tells you that he has lately returned from the state of Mississippi, and from the graphic and glowing description he has given you of the battle scenes he stumbled upon in a short excursion which he made from Vicksburg into the country, one would be almost tempted to believe that a horror of dirks, pistols, and bowie knives had seized upon his feelings and distempered his imagination. Hence he can see nothing commendable in the character of the people of that state. He portrays them as irritable, vindictive, and sanguinary, as a lordly people who look down with contempt upon mechanics and the laboring classes of mankind. He kindly supposes in their behalf that the climate in which they live may produce these obnoxious biases of character. If they are attributable to the climate, it is unphilosophic to complain of them, for it was settled in the case of Nebuchadnezzar that the heavens must rule. But do the facts, as he has represented them, exist in reality, or are they the offspring of his own heated fancy in this case? He must allow me to suppose them factitious. I, too, visited that state more than once, and continued long enough to become acquainted to some extent with the people, their manners, habits, and customs. On my last visit, which was about 3 years ago, I spent near a month at the seat of government during the session of the legislature. During that time I saw and became acquainted with many of her citizens, and among others with Judge Wilkinson and Mr. Prentice, the gentleman, with the witchery of whose eloquence and power of argument we have just been delighted, instructed, and let me add, convinced. They were both members and leading members of the legislature. I saw nothing of the ferocious or sanguinary about the people of that state. They treated me with the utmost civility and politeness, and with marked hospitality. The members of the legislature and many of the respectable citizens who were on a visit to the capital, overlooking all political party distinctions, united in pressing upon the distinguished stranger, as they were pleased to denominate me, from Kentucky, a most splendid public dinner. Gentlemen, I have been much concerned through life in legislation, and of course my acquaintance with political men, legislators, and others has been extensive, and I can say that I never in my life saw a more respectable, orderly, and intelligent legislative assembly convened, either in my own or any other state, nor did I ever see a more intelligent, polite, hospitable, and high-minded people than the people of that state. They detest knaves and cowards, and are prompt to fraternize with honorable men, to support, assist, and uphold men of that character, without inquiry into their vocations. Mechanics, agriculturalists, or laborers, makes no difference with them. If he be honest and honorable in his transactions, and industrious and temperate in his habits, whether poor or rich, it makes no difference. If poor, they enable him to become rich. Gentlemen, the people of Kentucky should be the very last to make or sanction such imputations against the people of Mississippi. For all Kentuckians of good character who have gone to that state, and very many have gone, have been kindly received, and when they needed, generously assisted with loans both of money and credit, whereby they have become rich. They went there, most of them, mechanics or laborers. They are now rich planters. The gentleman says, they look down upon poor mechanics. It is true they do so, but it is to discern their merit, and if they possess it, to lift them up, to elevate, support, and sustain them in their exaltation. But the other day they looked down upon Mr. Henderson, a shoemaker, saw his merit, and elevated him to a seat in the United States Senate. But that is not the only instance. They looked down upon Mr. Prentice, who had traveled from the far East and was engaged in teaching school among them. An obscure pedagogue. No, I cannot say he was obscure. He could not be obscure anywhere. The eruptive flashes of his great mind, like those of Etna, threw a blaze of light around him which attracted, or rather exacted, their gaze and admiration. They sent him as their representative to the Congress of the United States. Mr. Prentice must pardon me for thus going into his private history. I was myself an humble pedagogue. The difference in our condition is that in my case the people of Kentucky honored me. In his, the people of Mississippi honored themselves. They looked down upon Judge Wilkinson. They discerned his talents and his worth, and elected him to the legislature, elevated him to the bench, and conferred upon him the commission to negotiate a loan in Europe for the purpose of internal improvement, as you have heard from the proof in the cause. Instances are innumerable. I will not go into detail. But they carry bowie knives, and the blade of a bowie knife is so long and so broad, and the edge is so sharp, and it has such a terrific glitter, that they must be a bloody-minded, hot-headed people. Besides, they fight the most desperate duels. Gentlemen, arms of some kind are worn more or less in all countries. They are in all countries used by the coward to assassinate, and by the brave for defense against assassins. If you want to put down the use of bowie knives, extinguish robbers and assassins, and the use will fall of itself. But as long as good men may be assailed in their persons or property by dishonest and dastardly men, the latter must be allowed the appropriate means of defense, and the arms for defense cannot be considered appropriate unless they are at least equal in efficiency to those of the assailants. But the wearing of arms, whether bowie knives, pistols, or whatever else, does not at all alter the rights of the citizens. For assault they should not be wanted. For defense, when occasion requires, they are of great value. The right of self-defense remains, under all circumstances, the same. It is a primary element of our identity. Nature gave it. Art cannot take it away. As derived from nature, it is limited to the use of no particular species of arms, and embraces every species. It is limited only by the obligation of benevolence on the part of the assailed toward the assailant, and benevolence does not require him to love his fellow man more than himself. A man's right of self-defense does not result from the degree of criminality in the one who assails him. It is personal, inherent, and inseparably united with his own exclusive individuality. A person may in many instances exert this right to the destruction of an innocent man. A madman, for instance, who is incapable of crime, but capable physically of destroying a man, may be slain justifiably in the exertion of this right. So may a somnambulist under the same circumstances. In the case of a shipwreck, when two of the passengers are struggling for a plank, which will sustain but one of them, the one may justifiably kill the other to save his own life. This, gentlemen, is the law of nature in relation to all animal existences, and the municipal law in relation to man. Then, gentlemen, why this denunciation of bowie knives and pistols? For it can make no odds if the killing was done justifiably, whether it was done with the one or the other, or with a simple jackknife. The question is not whether either or what weapon was used, but whether with or without weapons the killing was justified or excused by the law. All that has been said, therefore, by Mr. Hardin upon the subject of carrying and employing arms is foreign to this case. It must have been intended ad capitandum, or rather ad excitandum. Equally foreign to the case is all that he has said about Mississippi and the Mississippians, whether the killing was done by a citizen of Kentucky or by a citizen of any other state. The question still is, was the killing criminal or innocent? That it was innocent in these gentlemen because necessary to protect themselves from a band of conspirators, from a mob, we have urged, and I am now insisting. But, gentlemen, as Mr. Hardin has spoken so much at large upon the depraving consequences of the habit of carrying arms, let me give you my opinion upon that subject. I am now an old man. I was in this country when every man carried his rifle and his tomahawk and his knife wherever he went. He carried his arms to defend himself against the Indians, whose incursions were constantly apprehended, and during all that time there were no homicides, no man killed by his fellow, no man apprehended danger from his fellow man. How happened this? The rifle, the tomahawk, and the scalping knife were at least as formidable instruments of death and as depraving as the bowie knife and pistol, yet it never entered the mind of anyone that men were more depraved or more ferocious by the practice of carrying arms. The true reason is that there was not then in Kentucky a single coward. The men, aye, and women too, were all brave. A coward could not remain in Kentucky. The danger from the Indians was too continuous, imminent, and proximate. He could not breast it. He could not bear the scorn and derision of the men and of the women and children too, and had to leave the country. After the Indian War had closed, which was in 1794, the people of Kentucky laid aside their arms. People from every quarter rushed in crowds into Kentucky, and jars and bickering resulted for a time from the intercourse of people of different habits. They were settled mostly by an appeal to the prowess of pugilism. There were some suits of slander and of assault and battery. Kentuckians gradually amalgamated with the immigrants, and we got along very well for many years. Among the professional men there was occasionally a duel. There were no homicides, no assassinations, until the legislature of Kentucky, in an evil hour, influenced unconsciously by a mistaken policy, enacted what is generally denominated the anti-dueling law. That law required every officer in the state, civil and military, from a constable up to the governor, including members of the legislature and lawyers, and from a sergeant to a major general, to swear solemnly that he would neither give nor accept a challenge to fight with any deadly weapon within or out of the state of Kentucky. It was a law most evidently for the benefit of cowards, who, without the oath, would never have fought nor accepted a challenge to fight a duel, but who, by the administration of the oath, were palmed upon the community, and upon themselves too, as men of spirit. Before the passage of this law, a man who might chance to be irritated with another would, before he published a libel or slander against him, pause and reflect that if he persisted he would be challenged, and must either fight or be disgraced, and would wisely desist. He knew that the same consequence would follow from any personal violence to which his irritation might prompt him, and the effect was the same. But upon the passage of this law, dastards, when they had taken the oath, or aspired to offices which they could not fill without taking the oath, filled their bosom with dirks and their pockets with pistols, annoyed society with the insolence of mock heroism, insulted their brave competitors, and when about to be chastised, retreated to the wall and killed the gentleman they had wantonly insulted, à la mode, Mr. Hardin's law. The vicious and depraved portion of the people having been thus licensed to wear arms, the remaining portion were constrained to wear them in self-defense. The consequence is that the community has been very much annoyed and vulgarized by the short-sighted policy of the legislature. Sirs, the duel was in the times I speak of, and had been for ages throughout the civilized world, not only the most effectual polisher of manners and morals, but a most efficient, though sad, peacemaker. It held all who aspired to be gentlemen, and were of course amenable to its tribunal, under a strong recognizance for their good behavior. It is a tribunal instituted by nature, as an auxiliary to the political institutions of society. It was a misdirected humanity which influenced Kentucky, and the states of the Union who, following her example, have attempted to suppress it. The object was to prevent the effusion of blood. The effect has been to increase it tenfold. Just as the legislation to repress gaming by fines and penalties has increased it 100-fold, when a short act, making all sums fairly won, recoverable by law, would have diminished the evil and improved the morals of the people. Do not mistake me, gentlemen, as to dueling. I am no advocate for it. I would not sanction it by law, but I would reluctantly connive at it as an evil less, greatly less, than that legion of evils which supply its place. As I prefer a high and honorable to a low and degraded spirit, fair, open, manly, and honorable conflict to dastardly and cruel assassination, so I would leave it, as England and all wise nations have it, by reluctant connivance. Perhaps my notions upon these subjects are erroneous, but they are my deliberate views, and I do not wish to conceal them. Every duel is a lesson, more or less impressive, as it shall eventuate in favor of good morals and polished manners, and although the fall of one or both of the combatants must inflict pain and sorrow upon their immediate connections, yet the effect is wonderfully beneficial to the community in every view and strengthening to virtue. The price paid by the community is very great, but the purchase is inestimably valuable. The good effects of this lamentable practice cannot be obtained at a less price, nor in any other known mode, nor can it be suppressed by human legislation. End of section 31, read by Martha Weller, Champaign, Illinois, June 20th, 2023. Section 32 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks. Kentucky, 1839, Part 17. But, gentlemen, to return to the case from which I have been diverted by Mr. Hardin's discursiveness, I trust you have been satisfied that the accused were assailed by a band of conspirators, and that they were justifiable by the law of the land in acting as they did, and leave that part of the subject with you. Mr. Hardin's conspiracy, on the part of the defendants, is too unfeasible and preposterous to require further notice than has been wasted upon it. Indeed, it is unworthy of the attention it has received. I therefore dismiss it also, and will now consider the case of the defendants, for argument's sake, as though there had been no conspiracy against them, upon the insulated ground of self-defense. I will suppose that they entered the bar-room on their way, and by the public way, like other citizens and boarders, to the supper table, and that immediately upon their entry they were assailed respectively, as it has been proved they were. The question is, was Mr. Murdaugh justifiable in taking the life of Meeks? And was Judge Wilkinson justifiable in taking the life of Rothwell? For against the doctor there is no proof. The proof in reference to what Rothwell was doing when he was stabbed by the judge is not entirely free from apparent discrepancy. Mr. Pope says he, Rothwell, was standing close to where Dr. Wilkinson was lying on the floor, under the blows of Holmes and others, that he was apparently leaning over the prostrate doctor when he was stabbed by the judge. Mr. Hardin would have you believe that his proximity to the doctor and his stooping position over him were produced by his endeavoring to pull Holmes off the doctor and release him. But Pope tells you that he was among the first to assail Murdaugh with his club, in that he displayed no amicable or pacific disposition towards the doctor, for it is evident from all the testimony that his feeling towards Murdaugh may be fairly taken as the sample of his feeling towards each of the others. He did not attempt to rescue Murdaugh from the rush that was made upon him. On the contrary, he struck him with his cudgel. It was not, therefore, to release the doctor from the giant grasp of Holmes that he was leaning over him. For what then, gentlemen, let me ask you, was he standing stooped over him? General Chambers gives the answer. He had struck the doctor with his hickory stick, and was balancing it in his hand to repeat the blow when the judge stabbed him. General Chambers did not speak of his stooping, yet he may have been and probably was stooping, as Mr. Pope states, and the general not have noticed it. Pope may not have noticed the stick in his hand and the stroke inflicted with it upon the doctor just before he was making the effort to readjust his grasp of it for another blow. To strike the doctor, who was lying on the floor under Holmes, he must have stooped to avoid striking Holmes. Pope saw him standing near the prostrate doctor, but did not see him strike, nor did he notice the stick in his hand. General Chambers saw him in the same position, with the exception of the stoop, strike at the doctor, and preparing to strike him again, they both saw the stabs inflicted. The testimony then of both the gentlemen is correct, and may be easily reconciled. They both saw the same transaction, but did not both see all of it, and the testimony of each, instead of contradicting, corroborates that of the other. Much took place in that scene which was not seen by anybody, and much of what was seen imperfectly amid the turmoil and confusion and apprehension which the affair produced. Some things were seen by one and not by another, and some important facts were not seen by any. Mr. Raley, who was a stranger to all the parties, saw some man striking with a sword cane. Who struck, or who was struck with it, he did not know, but he saw the scabbard end of the cane fall off and leave the sword bare. No other witness saw that. Judge Wilkinson was stabbed in the back obliquely, between the shoulders, to the depth of 3 inches, with an instrument narrower in the blade than any weapon known to be employed on that occasion, unless it were the sword cane. The wound, according to the opinion of Dr. McDowell, who examined it, looked as if it might have been made with such a sword, Such, too, was the character of a wound which Rothwell had received in his breast, and nobody knows how or from whom he received it, and which, according to the testimony of the doctors, was the immediate cause of his death. Judge Wilkinson, too, received several blows, as was apparent from contusions on his face and head, and yet with what weapon, or by whom inflicted, nobody knows but he or they who inflicted them. I mention these facts, gentlemen, to show you that as much occurred which was not seen at all. So of what was seen, many parts might have escaped observation, or been seen very imperfectly. All the witnesses, however, saw that the doctor was knocked down and beaten most unmercifully. Oldham claims the credit of knocking him down. Holmes is proved by all who saw the transaction to have been upon him and engaged in beating him, assisted by Rothwell, when the latter was stabbed by the judge. Halbert claims the credit of having contributed several blows. You see what a giant Oldham is, and it is proved that Halbert and Holmes were larger, and Rothwell as large as he, and all of them at least as stout. Can you hesitate to believe that the doctor must have perished under their violence if the judge had not come to his rescue at the very moment when he stabbed Rothwell? Holmes was also stabbed with a bowie knife through the right arm. The judge only used a knife of that kind on that evening, and therefore must have stabbed Holmes, though nobody saw him stabbed or knew who stabbed him. By the use of his bowie knife upon Rothwell and Holmes, he saved the life of his brother, and in all probability his own life and that of Murdaugh. It is very probable that, infuriated by the death of Meeks, they would, with the aid of their maddened associates, have killed the judge and Murdaugh as well as the doctor. But it is contended by the counsel for the prosecution, first, that the doctor's life was not in danger, and secondly, that if it was, the judge could not lawfully kill the assailants to save his life. Upon the first of these points I will not detain you. It is a matter upon which you have heard the evidence, which all converges to prove that his life was in imminent danger, and that it was only saved, as I have stated, by the seasonable and intrepid interposition of the judge. He had been already beaten to a mummy, and was, at the instant of his rescue, being farther beaten by the cudgel of Rothwell and the ox-like knuckles of Holmes. The second is a matter of law upon which I did not suppose there could have existed a doubt in the mind of any lawyer, nor indeed of any human being of properly organized midriff. For it seems to me that nature proclaims, in the unvitiated feelings of every man's heart, what the law is upon this subject. The lecture given by the father to his sons, and illustrated by the bundle of rods in the spelling book of old Dilworth, inculcates the true law upon this subject. But, gentlemen of the jury, let me call your attention to the law of England and of this country, and of all communities, barbarous as well as civilized, upon the same point, for it is a law of nature, and of course universal. In Blackstone, 21st N.P. 184, speaking of the right of self-defense, that author states that, quote, "They cannot, therefore, exercise this right of preventive defense, but in sudden and violent cases, when certain and immediate suffering would be the consequence of waiting for the assistance of the law," end quote. And having in the next page laid it down as a law of universal justice, that a man, when the attack is so fierce that he cannot retreat without manifest danger of his life or enormous bodily harm, may, in his defense, kill the assailant instantly, end quote. In page 186, he states that, quote, "Under this excuse of self-defense," referring to the law I have read, "the principal, civil, and natural relations are comprehended. Therefore, master and servant, parent and child, husband and wife, killing an assailant in the necessary defense of each other respectively, are excused, the act of the relation assisting being construed the same as the act of the party himself." Now, I ask if the relation of brother with brother is not a natural relation. If it is, then it is comprehended in the law I have just read to you from Blackstone. The counsel for the prosecution seem to think because this relation is not specifically named by Blackstone, that it is not within the principles laid down by him. They have erred, they will pardon me, in construing his words. There are but two kinds of relationship which can exist among mankind. The first is the natural, the second, political or civil. The author illustrates the last, namely the civil first, by the example of master and servant, and the natural by the examples of parent and child, husband and wife. He does not pretend to enumerate all the relations of either kind, but gives examples, one of the civil and two of the natural. They outrage nature by giving to the artificial relation of master and servant the ascendancy over the natural and endearing relation of brothers and sisters with each other. I say they outrage nature, for what man in his senses can believe that the servant is under greater and stronger obligations to defend the master and the master the servant than a brother is under to defend his brother or his sister? Feeling, it would seem to me, decides the question at once by intuition, but upon the supposition, for argument, that my interpretation of Blackstone is wrong, still the gentleman will have gained nothing, for the relation of brother with brother is at least a civil relation. A brother, in the absence of other heritable relations, can, under the law of the land, inherit the estate of his deceased brother. But I go farther and assert that the relation of citizen to citizen is a civil relation, within the meaning of Blackstone, and a mere citizen may, to save the life of his fellow citizen, slay the man who assails it. And I will add to authority of Blackstone that of Lord Hale. That great and good judge, in the first volume of his Pleas of the Crown, at page 484, speaks thus upon this point, quote, "If A, B, and C be of company together, and walking the field, C assaults B, who flies, C pursues him, and is in danger to kill him, unless present help. A thereupon kills C in defense of the life of B. It seems that in this case of such inevitable danger of the life of B, this occasion of C by A is in the nature of se defendendo," end quote, etc. And again, the author in the same page proceeds, quote, "If A be traveling, and B come to rob him, if C fall into the company, he may kill B in defense of A, and therefore much more if he come to kill him, and such his intention be apparent. For in such case of a felony attempted, as well as of a felony committed, every man is thus far an officer, that at least his killing of the attempter, in case of necessity, puts him in the condition of se defendendo, in defending his neighbor." End quote. So you see, gentlemen of the jury, that the counsel for the prosecution have misconceived or misrepresented the law. I hope they misconceived it. Let me refer you to a law from recollection, not under the denomination of a law, but a fable. I read it when a boy in Dilworth's spelling book. Quote, "Two friends," I quote from memory, "setting out on a journey together, agreed, in case of danger, to stand by and assist each other. They were assailed by a large bear. One fled and climbed a tree. The other, not being able to escape, nor alone to defend himself, fell down and pretended to be dead. The bear came up and smelled him, and from his silence and motionless posture, supposing him to be really dead, walked off and left him unharmed. When the bear had disappeared, his companion descended from the tree and asked him what the bear had whispered in his ear. He replied that the bear had cautioned him against confiding, through the balance of his life, in the promises of a false friend." End quote. This fable inculcates the same principle of natural and municipal law, which is promulgated in the passages from Blackstone and Hale, which I have just read to you, namely, that you may justifiably, nay, that you ought to defend the life of your fellow citizen by taking the life of him who attempts to destroy it. Hence, I argue that it was not only the right, but the duty of each of these three gentlemen, who were friends in their own state and in their travel to this state, to defend the life of each other by taking the life of those who assailed it. Suppose they had traveled by the old route from the place of their residence to this state, and had been assailed by the same persons, with the same violence and ferocity, at an intermediate tavern instead of at the Galt House. To make the case stronger, suppose that tavern had been in the wilderness, within the Indian Territory, where there was neither government nor laws. Might not the judge in that case have defended the lives of his friends and associates? They will perhaps yield that he might, because of the absence of legal protection. I reply that if he might on that account, his right to do so must be derived from the law of nature, and government leaves all her citizens in the full possession of the natural right of self-protection, where she cannot or does not protect them. Well, at the Galt House they were as unprotected by the laws as they would have been in the case supposed. Therefore, both by the municipal law and the laws of nature, the judge had a right to kill Rothwell to save Dr. Wilkinson from great bodily harm or the loss of his life, even if he had been unconnected with him by the ties of brotherhood, and therefore each might have destroyed the assailant of the life of the others. And if the party assailing them were acting upon concert between themselves for that purpose, each of the assailed might, the moment one was assailed, have killed as many of the conspirators as he could, and he would have been justified by law in doing so. But I have spoken of the conspiracy, and am considering the cases as though none had been formed. When the person assaulted honestly believes that his life is endangered by the assault, he may kill the assailant. The law to that effect has been read by Colonel Robertson and stated by Mr. Prentice. Mr. Hardin scouts at the statement of the law, and ascribes to the inexperience of the young man, as he is pleased to style him, his erroneous notion of the law. Gentlemen, you find it both in words and import as Colonel Robertson read and as Mr. Prentice has stated it. It could not in the nature of things be otherwise. The man assailed has not time under the pressure of the assault to consult others as to the degree of danger to his life resulting from any particular stage of the assault or degree of its violence. No one else could judge so well, no one so much interested in judging correctly as himself. He might lose his life by intermitting his defensive energies. While he sought the opinion of others, his life was committed by nature to his own protection, to the protection of his own mind and muscles, and not to the opinion of others. And man, I repeat, in the absence of the protection of the law, continues in this respect in the condition in which nature placed him. It is upon the honest, not feigned belief of danger to his life, or of great bodily harm, that he may destroy his assailant. Mr. Hardin says, it will not do that the assailed honestly believe the danger to be present and urgent. It must be really so. Let me suppose a case. A and B quarrel. High words pass. A swears that he will kill B, draws a pistol from his pocket, and presents it cocked to his breast. B instantly thereupon draws his pistol and shoots A through the heart. And upon examination, it turns out that the pistol of A was empty when he drew it and presented it to the breast of B. In this case, it is evident that B was in no real danger from the pistol of A. Shall B be condemned and executed for the murder of A because his life was in no real danger? Or shall he be acquitted upon the ground that he believed his life to be in danger from the pistol of A, and therefore justifiable in killing him under that belief? Can any man, even Mr. Hardin, entertain a doubt upon this case? Mr. Prentice, therefore, stated the law as it really is, and as it must, from the necessity of our nature, always continue to be. Men are not equal in moral and physical courage. A timid and a brave man would destroy their assailants upon different degrees of danger, the former upon less imminent danger than the latter, but each upon an honest belief of its threatening imminence, upon an honest belief that his life was in danger. Shall the one expiate the weakness of his nerves upon the gallows, while the other is justified and applauded? Each was under the same obligation to preserve his life, and each exercised honestly all the faculties with which the great author of life had endowed him. The doctrine of Mr. Hardin is at war with the nature of man and the principles of his social condition. Then, if Judge Wilkinson believed honestly that his brother was in danger of great bodily harm or of losing his life from the assaults made upon him, he had a right to kill the assailants, even if the danger were not as imminent as he supposed it to be. For a person who kills the assailant of his relations stands in contemplation of law in the place the assailed would have stood himself had he killed the assailant. But why talk of the belief of danger in this case, when there is no reasonable man who has heard the testimony can doubt of its reality? The doctor had already, when rescued by the judge, suffered enormous bodily harm. He had been deprived of the power of self-defense, and was falling an easy victim to the violence which Holmes, Rothwell, and Halbert were inflicting upon him. Rothwell had struck him with the club, as General Chambers proves, and was stamping him with his feet, as Mr. Pearson proves, when the judge stabbed him. But Mr. Hardin thinks he should be punished for stabbing him in the back. The gentleman has high notions of chivalry, and is shocked at its violation in this instance by the judge. He forgets that this assault was not commenced in a chivalric spirit, nor upon any principle of fairness known to chivalric men. When the judge came to the relief of his brother, that brother, one and alone, was under the fists, feet, and clubs of 3 of the largest and stoutest men in the state. And yet Mr. Hardin will have it that the judge should have waited until the 3 had killed his brother, and until it was convenient for Rothwell thereafter to present his breast. Or perhaps, according to Mr. Hardin's notion of gallantry, the judge should have asked him to present his breast, that he might approach him à la mode. If such be his taste, he may consider the first thrust to have been an efficient request to that effect, and the second to have been made when he had, according to the intimation of the first, turned towards the judge to inquire into its meaning. But a sufficient excuse to the cavillings of Mr. Hardin upon the point of mobocratic chivalry is that the judge was inexperienced in broils, knew nothing of either their practice or theory, that his education and habits of life were anti-pugilistic. He had neither muscular aptitudes nor mental aspirations for distinction in that line, and if he had possessed all the excellence in chivalry of which Mr. Hardin can conceive, the occasion did not afford an apt theater for the display of it. And again he was acting under the spur of relentless necessity, which left him no choice of modes of action, no leisure for the observance of etiquette. He had but one purpose, and that was to save the life of his brother. That object he achieved with the greatest possible economy of the blood of the aggressors. He might justifiably have slain with his bowie knife many others, and it is wonderful under the circumstances that he did not. It is evident from the proof that he did not aim to hurt any but Rothwell and Holmes, and it is equally evident from the proof that by killing one and wounding the other, he saved the life of the doctor, and very probably his own life and that of Murdaugh. Gentlemen, I have not called your attention to the proof in detail. I shall not attempt to collate and analyze it. That task has been performed ably and eloquently by the gentleman whom I follow on the same side. You must have perceived the artifices by which Mr. Hardin attempted to evade and blunt the force of the testimony of many of the witnesses on the side of the defense. You could not fail to observe, and I hope with indignance, his attempt to disparage those of our witnesses whose testimony he could not twist to his purpose. Let me call to your recollection the instance of Dr. Graham, a gentleman of known integrity and high standing in your county. The testimony of that witness satisfied everybody who heard it that the accused were assailed ferociously and placed under the necessity of acting as they did. How did Mr. Hardin dispose of it? Why, by telling you that he is the owner of the Greenville and Harrodsburg Springs, that the Mississippians spend their money freely, and that it is a great object with the doctor to conciliate them and get their custom. Mr. Raley, who is as respectable a man as any in the community, and as respectably connected as any man in Virginia or Kentucky, whose father was full cousin to Thomas Jefferson, and whose high intelligence was evinced by the clear manner in which he gave his testimony, is branded by Mr. Hardin with cowardice, because he told you he ascended, when the affray commenced, to the sill of one of the windows, upon which, being an entire stranger, he stood and looked on. Mr. Hardin derided that act of prudence as an act of embarrassed timidity, and compared him standing there to a turkey buzzard perched on the top of an old dead tree. General Chambers, whom he knew to be an honorable, intelligent, and upright man, and one who would not be very patient under any disparagement, he prudently passed. In the same way he passed Mr. Pearson, a gentleman of cultivated mind and manners, and of unimpeachable integrity, and then again he selected Mr. Trabue as a man of such iron nerves that he could look upon blood and carnage with the composure of a Stoic, and urged you to regard him and Mr. Pope as the only witnesses who were composed enough to observe calmly and accurately the actings and doings of those concerned in the horrific scene, and thereby intimating, by implication, that Montgomery, Chambers, Graham, Pearson, and others were so embarrassed and confused by their fears as to be incapable for the time of correct observation. I barely mention these things to show you that his zeal to convict the accused displays itself vindictively, in some way or other, towards all the witnesses whose testimony thwarts his main purpose. I fear none of the testimony, and wish you to consider it all, and give credit to as much of it as you can. I have before said all I mean to say upon the credibility of the witnesses. It is not agreeable to me to awaken unpleasant sensations in witnesses by unkind comments upon their evidence, and therefore I forbear to comment upon that of Redding, Johnson, and Oldham. Gentlemen of the jury, I leave Judge Wilkinson with you. I have not been as much concerned about the legal as the moral aspect of his case. His is not a common case, for in common cases a mere legal acquittal is the desire of the accused and the aim of his counsel. But to a high-minded, honorable man like the judge, a mere acquittal upon the dry law of the case has but little to recommend it. A gentleman who would at any and all times sacrifice his life to preserve his honor can be but little pleased with any efforts of his counsel which, by overlooking his honor, aim at saving his life. My aim, and such I am sure has been the aim of his counsel who have preceded me, has been to manifest to you and to the public that Judge Wilkinson and his friends have, throughout this unhappy affair, acted up to the most punctilious requisitions not only of natural and municipal law, but of the strictest honor and sternest morality. We have entertained no fear of a conviction throughout the case. We represent men who do not place a very high estimate upon mere animal life, otherwise than as it subserves the higher purposes of human existence. Men whose lives are in their honor and can only be reached by sullying it, and I have dwelt longer on the judge's case in the view to rescue him from the slurs attempted to be thrown upon his honor by the imputations and envenomed innuendos of Mr. Hardin than for any other purpose. The case of each of the three is, in its legal aspect, the case of all, for they were all assailed by the same vile coterie, and for the same nefarious purpose, and they all resisted with a bold and unquailing spirit, each as he best might under the circumstances of attack. The act of each necessarily tended to the protection of all, and none had cause to reproach the other with the want of energy or spirit. End of section 32, read by Martha Weller, Champaign, Illinois, June 22nd, 2023.